Check, check, 1, 2. 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 Check, check, 1, 2. Check, check, 1, 2. Check, 1, 2. Check, 1, 2. Check, check, 1, 2. Check, 1, 2. Check, check, 1, 2. Check, 1, 2. Check, 1, 2. Check, 1, 2. Check, check, 1, 2. Thanks, Rob. Check, 1, 2. Check, check, 1, 2. Check, 1, 2. Check, 1, 2. Check one. Check, check, 1, 2. Check, 1, 2. Check. Check, 1, 2. 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 Check. Check. Check, 1, 2. Check, 1, 2. Check, 1, 2. Check, check, 1, 2. Check, 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 1, 2. Check.
Good morning, everyone. Welcome to today's General Law Committee meeting. We're going to kick off our public hearing for Monday, February 10th. See, folks are making themselves comfortable getting in. We're a couple of minutes behind. First on our agenda today is going to be the Attorney General. For, getting back in the building, public hearing purposes, the emergency exits are right there in front of you. If you hear any notification to leave the building, please follow the lights and the doors behind you. We have 3 minutes for members of the public. We kick off this first hour with members of the General Assembly or elected officials. The Attorney General is number one on our list today. We expect there to be a robust conversation. But starting at 11 a.m., we will alternate between elected officials and members of the public. So with that, if there are any opening comments from my co-chair? No? From our ranking members? About to find out. Seeing none, we are going to kick off to you, Attorney General. Good to see you this morning.
Good morning, Mr. Chairman. Do I press both of these buttons or just one? Okay. Thank you, Chairman Lamar and Chairman Maroney and Ranking Member Retigliano and Ciccarella and all of the members. Good to see you. It's good to be home in this building always. So thank you for giving me the opportunity to testify on a number of bills. I'll try to go through them. Would you like me to do them one by one or do all of the bills at once and then come back to them for
I think
questions?
do all the bills at once, then come back to them. There'll be questions
Okay.
probably on each.
Okay. So I'll try to move quickly. These are they're complicated bills, important bills. I'm joined by Mike Wertheimer, who's the section chief of our consumer protection section and leads all this work. Let me start first with House Bill number 6857, an act concerning the Attorney General's recommendations regarding social media and minors. And I want to note for the committee, I want to thank the chairs and ranking member Retigliano and others. I know that Representative Carpino is very supportive. Representative Kenny, Representative Morrow was there as well, Representative Rader and others to protect young people, kids here in Connecticut from the harms of social media. This is a pretty straightforward bill, and it addresses what is really the heart of the problem, and that is the addiction. As I said in the press conference that we had just now, I can't really look at my kids' phones. I wouldn't get away with that. But I have an 18-year-old, a 16-year-old, and a 13-year-old. And what I can see, if not the content, is the addiction. And I think you see the addiction with adults and with each other. And I have two of these devices, which I'm going to put here and try not to look at them. But it's already creating some anxiety for me not to be looking at these phones because there's a lot going on right now in the world, as you know. But if you have teenagers in the house and you sit down for dinner, you know that it's a constant struggle to get them off their phones. And this is about that addiction. We know that the social media companies target young people because they're the biggest and most important market for lifelong customers, and that the way they get them engaged and the way they make money is by the number of eyeballs they have on those devices and on their platforms. And the way to do that is to get them addicted to their platforms. I've sued so far Meta, Instagram, and Facebook because of the strategies that they use to, this one keeps going off, to get young people addicted to their platforms, including haptics. Haptics is a fancy word for rings and notifications and buzzes and vibrations on your phone. We know that they use strategies like infinite scrolling, which I think all of us do now without thinking about it, where you don't have to change pages on your phone, but you just keep scrolling and scrolling and scrolling. Well, the computer scientist at Meta who invented infinite scrolling called it behavioral cocaine as a way to keep you engaged and addicted and focused on your devices. One of the key ways they keep young people addicted and focused, and all of us, is through the algorithms, machine learning, which learns what you like, what you're interested in, what you want to buy, what teams and music and all the things that you follow and that are important to you. The machine learns what you like and then feeds you content. It also learns that in order to keep you focused on the platform, that it has to send you content that you want to look at. And so it may start out with harmless content that's innocent enough, but if you start looking, for example, if you're a 13-year-old girl and you start looking at content about skincare and about your appearance and about fitness, it doesn't take long for the machine to figure out that it's got to keep pumping it's got to keep pumping content that's going to keep you glued to your device. And that means ever more extreme, controversial content. And it doesn't take long for that content to turn from physical fitness to people who look unnaturally healthy to eating disorders. And that can lead to not just depression and bad body self-image, but self-harm or worse. And so what this bill does is it prohibits social media companies from using algorithms to target young people without parental consent under 18. It establishes a series of default settings around account privacy, time of use, and notifications. You can no longer, the default setting is you wouldn't be able to use Instagram, Facebook, Meta, TikTok between midnight and 6 a.m. And it limits social media use to 1 hour per day. Parents would be able to affirmatively decide to change those parameters. So it's not an absolute bar, but parents have to take that extra step. And then the bill requires social media companies to annually report to the state and all of you the number of minors on their platform, the number of minors with parental consent to use algorithms, the average amount of time per day a minor spends on the platform, broken down by both age and time of day. So that's the social media bill. I'll move quickly to the first consumer protection bill. I'll call it the price gouging bill, and this is HB 6856. Section 1 of the price gouging bill concerns the issue of shrinkflation. So if you're not familiar with shrinkflation, that's a phenomenon where you've been buying the same big bag of snack foods. And so I bought a lot of snack foods, right, on Saturday at Stop and Shop for our family party last night. And, we've been buying the same bag of snack foods for years and years and years. And over time, we have found that this bag feels a little lighter. I mean, it looks the same, costs the same, but there are fewer chips. And one good example of shrinkflation is how peanut butter manufacturers, they don't change the size of the peanut butter jar, they don't change the price, but there's a little dimple in the bottom of the jar. And that enables them to put just a little bit less peanut butter in the jar, even though you think it's the same jar. And so consumers, all of us, have begun to notice these changes. Another good example is somebody said to me, I used to buy a 12-pack of seltzer. It's now an 8-pack, costs the same as 12-pack. And so it's really important that we try to protect consumers. Everybody obviously is talking about prices, and we're all very concerned about prices. We heard voters loud and clear in this last election that prices, particularly the price of food, are really important to them. So what this does is it requires manufacturers, wholesalers, distributors to disclose to consumers if there is a change for 1 year, if there is a change in packaging and in the content inside of a package, so that people know that they're potentially getting less than they normally would have. My proposal would exclude retailers and restaurants from this responsibility and this burden, because we know it's not them, right? It's usually not the supermarket or the restaurant that's doing it. It's the manufacturer up the chain. And so this would address all eligible food products. There's a federal definition, and we think it'll go a long way to protecting consumers from shrinkflation. The second part of the price gouging bill is to expand how we handle price gouging in the state. And what it does is it would enable not just the governor or the president to declare an abnormal economic disruption, but to enable the Office of the Attorney General to do that and to trigger our price gouging authority. It is a clear standard. The Attorney General's office, working with the Department of Consumer Protection and others, and the Department of Economic and Community Development. The statute will require me to consult with those two departments and to assess whether there's an abnormal market or economic disruption that triggers our price gouging powers and would enable us to protect Connecticut residents here. As always, we're seeking expanded authority. Right now, we're limited to when we're trying to address price gouging, we're limited to the immediate retailer. And what we've learned time and time again is it's not the retailer. During COVID, of the 750 plus complaints we had about potential price gouging, most of them were not about the retailer, and the retailer wasn't the one who was charging, I don't know, $35 for a 16-ounce jar of hand sanitizer. It was the the wholesaler, distributor, manufacturer who sold it to the retailer at a very high price. And that's why the price jumped so precipitously during COVID. And so we really need expanded authority that most of our other states, sister states, have to address price gouging and abnormal market disruptions. Let me give you an example, by the way. Right now, the price of eggs are super expensive if you're lucky to find them, by the way. Sometimes if you go to your local market, they're out of eggs. And eggs have become very expensive. I think Waffle House is now charging 50 cents more per egg. We don't have Waffle House here, but I read this in the national press. They're charging 50 cents more per egg because of the shortage and because of inflation, the price of eggs. When COVID hit, Mike and I started getting reports that there was abnormally high prices for eggs, and we joined a multi-state investigation of the regional egg industry. And we found that there was likely misconduct around egg prices, but we couldn't go further. New York was able to continue its investigation and prosecution, but we had to stop because we have to stop at the immediate retailer. And if we don't find misconduct by the retailer and we think it's further up the chain, Connecticut can go no further. And that makes very little sense for consumers in this state. Let me turn to House Bill number 6858. This has more consumer protections in it. The first section, a number of sections, but it starts out focused on ticketing. And this, you've done a lot on ticketing in this committee. This closes a loophole to make sure that it's clear that as soon as a ticket is offered online, that you have to put all the fees, all the costs into that. Some secondary market sellers, resellers online have interpreted it to mean that they don't have to disclose the full price with all fees until a consumer selects a seat. We don't think that was your intent, and so we might want to make it clear that as soon as the price shows up, it should be the all-in price. It also prohibits the use of deceptive website URLs, deceptive website addresses. So not far from here across the street, the Bushnell, if you want to buy a ticket to go see, Wicked or Hamilton at the Bushnell, there is an official Bushnell site, but there are also a bunch of bootleg fake Bushnell sites. And unfortunately, you may have heard from your constituents, or maybe you have the experience of trying to buy a ticket, and you buy a ticket, you think you've bought a ticket, and it's a fake ticket. And you show up at the venue on the day of, and you can't get in. This bill also provides that secondary market resellers have to disclose that either they have the ticket in hand, or they have a contract to acquire the ticket, or they don't, so that you know what you're buying. And we think it's really important that there be more disclosure about the ticket so that consumers can protect themselves. This bill also includes Section 3. These are, there are people out there known as veteran benefits sharks, who basically go to veterans and sell services. Will help you get benefits from the VA, which are free, and will help you navigate services which are free. And we think that that's obviously unlawful, and people are taking advantage of veterans. There are veterans benefit counselors who are certified by the VA. Those are different from the people that we're seeing out there who are just charging money to people and making them pay for a service that they could otherwise get for free. And we think it's important to force these bad actors to conform to federal standards and to make disclosures so that it's clear what they're offering, what they can offer, and to make it clear to consumers and to veterans that they don't have to pay for this service. Section 4 is a narrow exception to the Office of State Ethics to enable the Office of the Attorney General to hire experts on short notice and in litigation. Right now, the way that it's set up, if there's an expert, for example, at UConn on social media, I have to go through an arduous process of going through an RFP and bidding out those services, and then in so doing, disclose to the world what my strategy is in litigation, right? What I'm focused on. If I target a certain expert and put in the RFP what I'm looking for, then now you know what I'm looking for if you're on the other side. And so we should be able to hire state employees, professors at UConn or at Central, who can serve as experts and help us in our litigation. And so this provides a narrow exception for that. One more quick thing, Section 13, this was a bit of a grab bag, would repeal the requirement that doctors and certain healthcare providers tell pregnant patients that they have the option of banking their cord blood. At one point, this was a thing in this building, and it appears there's not really a robust market for cord blood. The scientific underpinnings of banking cord blood have been called into question, and the value and utility of that is not clear anymore. At one point, we required people to be told about cord blood. We actually repealed parts of the sections of our law about cord blood, and now we're just suggesting that we clean that all up and that we no longer require healthcare providers to tell people about cord blood, and then that's an option for them. I think that's it.
Well, thank you very much for your
Thank you.
testimony on each of the bills before us. You're right. The third bill is really like 6 bills in one.
Yes.
But I don't know if you saw when we were raising bills, we had questions. Why does the Attorney General have so many bills in our committee? We thought that was our happy medium approach, but it turns into a bit of a grab bag. I think that's an appropriate way to look at that. Thank you again. The social media in minors bill is going to gain most of the attention when we leave here today. Right, it's going to be a focal point that is likely to generate a lot of questions, concerns, thoughts, media coverage. I want to say we decided to go with your bill and your request largely because of the effort and the time and consideration that you and your office has put into this for months and years leading up to this point. We had bills submitted from both parties in both chambers, bipartisan concern about this issue. You saw that at a press conference earlier where there were equal number of Democrats as were Republicans in attendance. Your bill's already been co-sponsored by Republicans. Like this is clearly something that impacts families across our state, across our country, frankly. We owe you a debt of gratitude for taking the lead on this, making it a little bit easier for this committee to consolidate efforts in this vein behind your office's work and research. So thank you. Thank you for taking this on.
Thanks for taking it up.
I know there are going to be numerous questions on each of the bills before us. I'm going to slowly turn that over. I'll clean up at the end if there's any remaining questions from the committee. But at this point, I'm going to turn it over to my ranking member. No, you're good. That's it. You guys good? Representative Acker.
Thank you, Mr. Chair, and Attorney Tong, thank you for being here.
Thank
I
you.
just want to do a shout out during your tour on social media. You stopped at the Coventry High School, and what an eye-opening event that was for myself. I know you're a fisherman. I enjoy fishing, so when mine scrolls, it comes up with everybody catching these wonderful fish that I would love to be catching. But we asked the students about what they did that weekend. Happened to be a long weekend. And many of them sat there and said they were scrolling.
Yeah.
One young man said he spent every hour of a 3-day weekend scrolling. When you say addiction, that hit home with me.
Yeah.
And we talked about that. How does this mechanically work, though? How do you actually, is it just the programming that the system has that says you can shut this down, like you can do your TV controls for what
Yeah.
you can watch? Is that how this gets put together?
Yeah, this is up to the social media companies, and I'm not a technologist or a computer scientist, and neither are you. And so it's up to these companies, which make trillions of dollars every year off of all of us, to figure out how to effectively age gate verify the age of young people, and to verify parental consent. And we know that just putting a page up that says, are you 18 or not? And clicking yes or no doesn't do it. Okay, it's not enough. And so they've got to figure out, look, these are companies that have developed multi-factor authentication, so annoying, right? You need now 2 devices for at least for my state account, in order to verify that I am who I am and I can use my email and get into the state network. So they can figure it out. It's up to them and the social media companies to come up with an effective gate to make sure that algorithms don't take advantage of young people, get them addicted, and send them bad content. I want to say, I know you were just talking about fishing for fun, but if you're a fisherman like we are, and you can start out by looking at things about rods and tackle, but it doesn't take long, right, for your social media feed to have the biggest fish you've ever seen, right? And there's a viral video of some fishermen on a boat where the whale like hit the back of the boat, and this was in the last year, and it was this shocking video about an incident on the water. That's the sort of thing you start to see because the machine knows in order to keep William and Tim on their phones looking at fishing, I've got to send them shocking, explosive, extreme fishing stuff so they'll stay on the platform.
Thank you for that. And one other Bill question, if I could. And yeah, mine are now looking at super yachts all of a sudden.
Yeah, right.
Super yachts. I happen to go down to
You must be
St.
doing
Martin.
very well, Representative.
Yeah, I'm not. I can't afford the dinghy that goes on the super yacht, but now it's you looked at one yacht and now it's all these $400 million yachts show up, and I'm like, that's not me. But on the veteran benefits
Yeah.
one that you mentioned and the targeting, I think that an area that we need to look at is that we need to promote. I know that Commissioner Welch is doing a great job in that position, but we need to, as a veteran, I didn't know where to turn myself. And I did happen to pop in at the VA Administrative Office in Willamette, Connecticut, and sat in there talking about all the services that they have. We do great things in the state. We need to promote it. So I thank you for taking that up and understanding that they are targeting our veterans. So
They're
thank you.
targeting our veterans, and I just want to clarify, there are accredited veteran service officers out there that can provide help, but they're accredited by the VA. I'm talking about the people that aren't accredited, that charge, God knows what. They charge fees for services that are essentially free. And then one thing I didn't mention in my testimony is that they also get access to the personal information of the veteran, right? So if you say, hey, Navy veteran, you're 70 years old, you're not that tech savvy, I can help you, I'll charge you this fee. Give me your social security number, right? Your service number, your healthcare information, give me your logins so I can help you. And now you've got a potential bad actor with all this information.
Thank you. Thank you, Mr. Chair. That's it for now.
Thank you. And I appreciate the allegory with respect to the fishing boat, because this is like you start with rod and tackle and you end up with super yachts and whales upturning like small boats. Now, if you're a teenager who starts with skincare advice or how to build self-esteem, you can only imagine how quickly that turns into something else. How quickly it turned from rod and tackle to super yachts is how quickly skincare and self-esteem related issues turn into something really dark and dangerous. And I think that helps to highlight how important this is and why you've seen so many bills introduced this year on all sides of the aisle. And again, we do thank you for your willingness to shepherd this through.
Thank you.
Any other questions for the Attorney General? Oh, sorry. Representative, yeah. Representative Turco, to be followed by Ranking Member Tigliano.
Thank you, Mr. Chairman, and it's great to see you, Mr. Attorney General. Just a clarification on the social media bill for kids regulation, and thank you so much for putting this bill forward. I think this is really important work that we have to do this session. But just, I'm trying to understand the hours, parameter of the hours that you have. Can you explain a little bit more, and then I might have a follow-up question on how that works?
Midnight to 6 a.m. It would be the default, right? Midnight to 6. Yes. Turned off from midnight to 6. So parents can decide that they want to change that, but parents have to affirmatively decide. So there's no absolute bar in this bill. If an individual parent decides that they want their kid to have access to algorithms, that they can handle it, or if they want their kid to be able to access social media between midnight and 6 a.m., they can do that. But they have to affirmatively make that decision. And it can't just be some simple click through. It's got to be some reasonable verification that the parent has made that decision.
So it's not barring the use during those hours,
Correct.
just the social
Correct.
media companies using algorithms to target and send notifications?
Yeah. I mean, and part of this is because of the addiction, but we also know that the addiction significantly impairs and impacts sleep. So a lot of what we know, a lot of this data, a lot of the information comes from Instagram, Meta, Facebook itself, from their own internal studies. They did a study, I think it's called the Teen Mental Health Deep Dive. And it's detailed in our complaint, by the way, if you'd like a copy of our lawsuit. But they did a deep dive into the impact of social media on young people. One of the focuses is, that when kids go upstairs to go to bed, they're not going to bed. They're on their devices. And sometimes I'll ping my 16-year-old right after 11, and she's up because I know she's on her Instagram, and so she responds, and there, I got you. So it's a challenge for parents. Let me say one more thing, which I didn't say during the press conference. State attorneys general have done a lot of work on these issues, and for those of us that are parents, there's a fair bit of conversation about, well, why don't the parents just step in, and shouldn't parents take responsibility for their children, and regulating use, and not buying them phones and not buying them iPads? My first response to that is good luck. Okay. But my second response, I did ask some experts about this during an attorney general meeting. I raised my hand and asked a question about, what about parents? And they said, yes, parents need to take action, right? One of the issues, frankly, about cell phones is schools, parents. And that's a conversation that we need to have. And to the extent that we can, we need to encourage parents to be accountable for their kids and for their safety and well-being. But this expert said, those of us who are parents now, like, we were hit by a tsunami. Nobody was prepared for this. This happened virtually overnight. And wasn't that long ago we didn't have cell phones. And it wasn't that long ago we didn't have smartphones. And social media is still a relatively new a new invention that we've been contending with. But this avalanche of social media and content, that's not that old. And I think parents in general were ill prepared for this and are still struggling to find ways to manage it.
Thank you for that. And just on the shrinkflation,
Yeah.
would this would your proposal cover if a company, let's say, offers, they sell peanut butter, they have a jar that's 5 ounces, they have a jar that's 10 ounces. They don't do anything to change the size of the 10-ounce jar. They just get rid of it, and they change the 5-ounce jar to what the 10-ounce price was. So are they finding a way to work around, or would they still be required, because they increase the price for a size of a product that is smaller, to put that label on there, or because they already offered the product for sale and didn't change an existing product, they'd find a loophole?
Yeah, maybe is the answer. I think what this piece of legislation addresses directly is the 10-ounce jar and a change to that 10-ounce jar. And we just, again, we're not saying you can't change 10-ounce jar. We're not actually saying that you can't put less peanut butter in the 10-ounce jar. We're saying you got to tell somebody that there has been a material change to this jar. I can't tell you, because this is a hypothetical on the fly, if something similar to the 10-ounce jar, I think it would be fact dependent and based on the circumstances about whether the consumer was likely to be deceived or not.
Thank you. I appreciate your answer to the question.
Sure.
And thank you as well for your proposal regarding the ticket prices and the clarity and the transparency, cleaning up our past language. Appreciate that. Thank you, Mr. Chairman.
Thank you. Ranking Member Ritigliano.
Thank you, Mr. Chairman. Good morning, Mr. Attorney General. And I just want to say that on the 2 of the 3 bills I think are fantastic, and I really couldn't support the social media bill more. Even the other consumer protection bill about ticketing and all the other things. It's really smart legislation, and I'm proud to support it, and I'm glad you put it in. I do have some questions about certain of the other part, the shrinkflation piece,
Yeah.
and that. So I wrote down a couple of questions only because I wanted to keep track of what the thoughts that I had in my head. And this particular bill provides that the Attorney General, you would issue the abnormal economic disruption notice. Do we have a built-in criteria what to use to determine what market forces took place so that it's an abnormal economic disruption?
Yes, we do. It's the one used by the governor now. And the president also has that authority. There's a definition, and it's a significant disruption in production, supply, distribution. It's a longer definition, but I can provide it to you, but it's in the legislation.
So you're saying that when this notice is authorized or issued, that's when the gouging statute would
Correct.
kick in? So
Correct.
you're saying, but if logically speaking, if there's a large economic disruption, wouldn't that lead to price disruption? It's sort of like the fruit of the tree. So
It can lead to price disruption, but it can also lead to bad actors gouging you. So I'll give you an example. Uh, I know we've heard a lot about. I think there's some testimony from from gasoline retailers or distributors. That's a different statute, I believe. Um, so I'm just going to try to keep it straight, but I'm just making an analogy. Um, there obviously has been a disruption in global energy supply, and that's going to impact price. Nobody disagrees on that. Okay, but there could also be somebody saying, well, now there's a global energy supply disruption, and maybe my price should go up 25 cents per gallon, but I'm going to decide to charge, $6 a gallon. That could happen. That could happen, and that would be on its face illegal and unlawful in price gouging. I'm not saying that's happening now, but I'm just saying that's a good example of, yes, there can be a disruption that can impact the price, but then going that step further to gouge people is wrong.
wouldn't the natural market take over if one gas station decided to charge $6? They'd be an outlier, and people could see the price posted up on a board, which is something we all support, transparency and pricing, and just drive to the next gas station.
Yeah.
I would think where your office would come in is if all the gas stations got together and said, you know what, we're all going to go to $6.
Well, that's a different issue.
Right.
Yeah, if you have choice and competition, but not everybody does. And this, let me move away from gasoline to food. Maybe you have one market. Maybe you have no market. Maybe you live in a food desert in a city, right? Maybe the market you rely on is a local convenience store. And we know from experience that local convenience stores are often, first of all, the only place people can buy food given their travel limitations, language limitations, language barriers, and that those can tend to be the highest price retailers out there. And so, if the market isn't working for you, then the market doesn't work.
So I agree with you. I could see your point in that,
Yeah.
but I would imagine that those stores' prices are high all the time under the scenario you just said. So in order for enforcement to kick in your office, you would have to declare economic emergency or disruption in the market, and then go to a place that's probably already charging too much to begin with, and then accuse them of gouging.
Well, look, with respect, I've got too much work to waste my time, right?
I-
So what would have to happen is that there's some kind of abnormal disruption, right? For example, in the price in eggs, right? There's bird flu across the world right now. We're very concerned about eggs or dairy milk, and there's a major disruption in milk, and that has to be not just observed, but documented, and it has to be a significant disruption that I have to be able to prove, okay, in order to sustain any kind of action that I take. And so, and the same is true right now for the governor, okay, or the president. And so we're just saying the governor and the president have this authority. Attorneys general should share that authority. It's true in other states. And we're going to share the responsibility to declare a disruption so that then I can take action. And in that case, once that happens, I'm going to go out there to protect consumers and to protect consumers from extreme and egregious conduct. The standard is a price that's unconscionably excessive, which is a standard that's used in other parts of the law. And that's a pretty high standard. So just because the local convenience store charges a little bit more than the supermarket, that's not going to be unconscionably excessive. It's if somebody's charging you $40 for a 16-ounce bottle of hand sanitizer.
Understood. The bill, as I read, calls for, it seemed to be, and maybe you could explain it, unlimited 60-day extensions.
Yeah.
Um, who is it? Just on your own decide whether to extend it or not, or is there some sort of governing body that you'd have to go to for the extension?
No, again, I have to be able to sustain the standard that there's a significant disruption. So if the disruption is gone, there's no basis for me to extend.
I, I I hear you, but what recourse would somebody have to disagree with your extension? Like, would that something that they'd have to sue over? Or do you just autonomously just could declare a 60-day extension? I just didn't know where the check on the power was. Is there any check on that power in the
Well,
legislation?
Uh, not in the legislation per se, but I would say the check is the standard, that there has to be disruption, that I have to be able to prove that the disruption exists. And then that would enable me, if I wanted to and needed to, extend, extend, the disruption period. Well, yes, I forgot about that.
Yeah, that was
We're
my
still
next
working
question.
we're working with DCP and DECD. So I'm not doing it by myself, although I think it's my call under the bill, but I'm doing it in consultation with DCP and DECD. And let me say, and I hear them right now, that the objection that the Attorney General would just, declare open season on retailers and distributors. First of all, I've heard that criticism many times in this committee, that we don't want to give the Attorney General the authority to protect consumers from price gouging and from unconscionably excessive prices. And my response to that is, why? You know, everybody wants to pay a fair price. Nobody in my office wants to go out and tee off on retailers for no good reason. There has to be, by the way, the retailers, the business people that are represented here in this room, they employ people in our communities. We hear from them. We're going to hear from them. And so they call my office, they complain. The most of the complaints though are, why aren't you doing something about the price of eggs?
Mm.
I'm getting screwed at my local market. What are you doing? And my response is, I don't have the power to go beyond the immediate retailer. I need more authority. And they're often very frustrated that the Attorney General doesn't get in there and fight for them. And I have to explain to them that my power is curtailed. And so we have no interest, no incentive to go after business people for no good reason. It does nothing for us, it does nothing for the state. And so that concern is not well founded.
So I'll speak for myself, not for the committee. We were supportive of the first round of consumer protection and price gouging statutes that you were looking for.
Yeah.
I think it passed out of the committee either unanimous or near unanimously. And so we're not, me personally, not opposed to that concept It was just, it's a bit of an expansion of the power.
Yeah.
And I'm not even sure if I support it yet or not. I'm not even taking a negative. I just had some generated questions. And one of them was the bill does call for you to consult with DCP.
Yeah.
What if they disagree? What's the mechanism where that gets worked out? Do you have absolute authority, or does DCP, is there sort of a court of an arbiter that's going to decide
No.
who's right and who's wrong?
But we're partners, and just like you and I are partners, and I represent DCP as its lawyers and its counsel, and we work it out. We're all on the same team. We're trying to protect consumers. I don't agree with DCP every day. Let me just be clear about that. On a lot of the issues that you talk about, I won't air our dirty laundry here, but we don't see eye to eye on everything. But it's our job to work it out. And DCP, of course, is an executive branch agency whose commissioner works for the governor. And sometimes, it's not just a conversation between me and the commissioner or the staff, but it's between me and the commissioner and the governor. So, they've got plenty of institutional power and influence to make their voices heard, and we take that very seriously.
I appreciate that, but
Yeah.
I guess you're saying that there is no formal mechanism to resolve
Not that I'm
the
aware of.
difference between the two.
No.
So even the governor can't come in and rule on one side or the other. It's okay. You can
the
just say
governor
no.
and I, the governor and I sometimes don't agree either.
I know
But
how you feel.
and and sometimes I have to tell him no, and he doesn't much like that. But I also know you tell the governor no at your peril. So it's a balance. It's a balance.
Part of the downsizing piece, it says it requires vendors to disclose downsizing for a 12-month period, right? It goes back in time. What came up? Where did the 12-month period come from? And then I didn't realize this before I read the bill, that it conflicts with federal law. Not conflicts. I guess there is a federal requirement to notify when you're downsizing a product or changing a packaging size. How do those two reconcile? Is the periods the same?
We thought that the 12-month period was a reasonable period for disclosure and was not unduly burdensome for manufacturers and wholesalers and distributors. We accepted retailers and restaurants, the immediate sellers, because we thought it wasn't fair to put that on them. But we think 12 months makes sense.
So I read the amendment that your office sent over, and it says retailers, all retailers. So that means the supermarkets, basically.
Yeah.
If somebody shrunk the peanut butter,
Yeah.
your example, it's really not Stop and Shop's fault. It's sort of whoever
I
made
don't
the
have
peanut
any
butter's
reason to
fault.
believe that Stop and Shop did that.
Right. What penalties or remedies would be available if they either fail to reduce the prices or have appropriate? I guess you say in there that they must reduce the price if they reduce the size, but I guess that's a manufacturer, not a retailer. But what's the enforcement mechanism? What's the penalty?
Our
How
office
are you
would
going
have
to
the
handle it?
authority.
Just
Our office would
random?
have the authority.
It's
Unfair
not
trade
spelled out?
practice. CUTPA.
CUTPA?
Yeah.
Anybody else? Shockingly enough, I have a lot more, but I'm going to turn it over to my Senate ranking. But I appreciate your time.
Thank you.
I think this bill, I think, generated a lot of questions, and I'm not even sure if we support or not support. It's just, it seemed that we just had questions.
Well, let me say this. This is the first time we're bringing this to you this year. This comes out of our investigation of food prices broadly. That's ongoing. I don't have to tell you, Representative, that our constituents are screaming about
Eggs.
prices and
Right.
about the prices of everyday necessities like food and eggs, and bread, and and what we're learning is there's a lot going on in packaged goods, and we're looking hard at that, and that shrinkflation is a real phenomenon, and it's not just unfair, it's wrong, and it drives people crazy, and I think it is an issue that demands a response. And so I'm happy to work with you and the members of this committee on this bill and this proposal. If you have ideas to strengthen it, we're happy to consider them.
I know I said I was going to turn it over, but I just had one more clarifying question, if you don't mind. It, you had a definition in the bill called consumer necessities.
Yeah.
Um, there's a lot of things that people consider necessities. It's not just food, water, and other things. Is there online services in that? Is there certain remote tools? There's a lot of things that have become critical during an emergency. One could even say a generator. I guess that might be under another statute. Who defines what's a
Yeah, I
consumer
believe
necessity?
that we borrowed from a federal statute to define what the necessities are.
Senator?
So then I was just say you referenced one thing that I did want to
Yeah.
thank you for. My ranking member Tigliano is exactly right. The first two bills that you talked about had broad bipartisan support in screening. We feel really good about getting those over the end. This was the one that there was concerns in screening, and immediately we raised some of those concerns in that screening process, and your team immediately came back with some amendments that aren't included in this early stage draft, but we will include moving forward. So I do want to thank your office for your willingness to immediately start to work with us on some of the questions and concerns that we raised. Senator Chigarella.
Thank you. And thank you for coming here today and for putting forward legislation that will ultimately help consumers, especially our vulnerable population like our children. Having two young children, it is a concern what they're constantly doing on the phone, and finding ways to help parents. It's very important. So I thank you for that. I do have a couple of questions on two specific bills put before us. The one we were just speaking about, the abnormal economic disruption. You said that other AGs in other states have the ability to step in and say that there is an economic disruption. About how many other states AGs have that ability?
I don't know the answer to that question.
Okay.
I can get that to you.
Okay. You also said that the governor has that ability right now.
Yes.
So we were just trying to figure out or understand what would happen when, you're working with DCP, maybe you guys aren't agreeing on something. And I think having the ability to act quickly when there's something going on that's affecting people, and if people are being taken advantage of. But it seems as if the governor has that ability to say something's happening. My understanding is you work closely with the governor. What would stop that from happening right now? And if you felt there was a situation that rose to this type of a level and needed action to be taken, why can't we just go to the governor and you have that conversation, and then you then have the ability to take action? You talked about people complaining about the price of eggs. What would be the need for changing this?
Well, a couple things. One is, let's just take this governor out of it and this attorney general out of it. A governor may have a different view from a attorney general as to whether there's a disruption, and they may read the data differently. Number one, a governor may agree that there's a disruption, but not want to take action for any particular reason, because it's not a priority for them at that moment, because they have other, just announced his budget. They have other priorities that they want to focus on. They don't want to expend time and capital in this building on those issues. So there could just be a good faith disagreement. And I would say I'm probably closer to it than the governor is. I'm closer to the complaints that I receive every single day about prices. My people are focused on consumer protection. Mike and his team, we're in the middle of the action. Not that the governor's not that the Department of Consumer Protection isn't, but there's just a different information flow, and we live and breathe it every single day. So I would just suggest respectfully that the Attorney General is in a stronger position to make that judgment, and not that the governor can't make that judgment, but that's an authority that we should share.
So, we were kind of laughing just before about saying that you may disagree with the governor. But when you guys both have that kind of equal power in that specific area, I think that creates a bit of an issue. He might not want to, you may, vice versa. I think keeping it, kind of having that balance is important. Having two people be able to make the same decision. I'm sure if it's something that's that serious, needs action, I'm sure the governor, as busy as he is, would find the time to listen and say, okay, you know, I'm going to make this decision, and you guys could run with it. So I just think that's where some of the questions come from. Why is there a need for it? That's why I asked the question of how many other states have that, and has there been any issues when you know that kind of a scenario could come into place. So that's why I asked those questions. I understand that you want to be able to take action quickly to give relief to Connecticut residents, but I just think that it does leave some concern when you guys could easily communicate, and he could give you the authority to do so. So
Well,
I just,
if I may, Senator, there are many ways in which we just, you know, there's the separation of powers, and we each have our own lanes and constitutional grant of authority. But there are many ways in which we share power and authority with the governor. You share power and authority with the governor.
I don't have as much power as he does.
Well, I would posit that the legislature is, um, as a former House member, you know, is structurally and institutionally more powerful than the governor, and he shares authority with you. That's why you go first when you pass a law, and then it's up to him, you know, to sign it or not, or to veto it. And I think that's the way it is under the federal Constitution, Article 1. The Congress is in charge, and so you share authority with the governor, and sometimes you don't agree, and you have to work it out through the process. But the lawmaking process is entrusted to you, and it starts with you, and 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 that's your primary responsibility, and it's constitutionally entrusted to you in this legislature. The governor plays a role, but it's still largely your call. And you know, in with respect to legal matters, the governor, you know, the governor has broad authority over um, state government in many respects, except when there's a clear separation of powers. But you know, in one area in which we share power is, you know, over legal matters and litigation, for example. That is generally considered to be my responsibility, not his responsibility. And so we share that, we confer about it. But then, you know, it's my job to do the best I can for the state of Connecticut on legal matters. It's not the governor's job, it's my job. And so, you know, the treasurer is the sole fiduciary. You know, it's not like the governor doesn't have control of the treasurer's budget. He does. And it's not like the governor doesn't have influence and a role to play, but it's the treasurer's call about our state pension funds. And so it's not weird, right, or unusual for our Constitution to assign responsibility to one official or another. I would say right now it is weighted, you know, too much in the governor and the president, and that and an executive branch official who's close to the action and close to what's happening to consumers on the ground is also capable of declaring an abnormal disruption.
thank you. And I'll let the governor know. The AG said I have some power, so I'll sit
Yep.
down with him and see if he'll listen to me on
You
some
don't need
things.
me to say that.
Um,
True.
So a second question.
Especially in the last week of the session.
That's true. So another question. Um, I think it is important we protect our vulnerable population, make sure we're protecting our veterans that did so much for us. And I just had a couple of questions with the individuals that maybe are preying on our vulnerable veterans that are looking for benefits. And sometimes it can be very challenging to navigate the website and the forms and the documents that are needed to get together to get certain benefits. You mentioned that the VA has a certified
Yeah.
group of individuals that could help. Can you explain?
Veteran service officers. I don't know too much about them, to be honest. I know they exist. I know they're accredited by the VA. You yeah, the services are free, and I presume you can go to the VA website or our Department of Veterans Affairs here at the state level and ask to be put in touch with a veteran service officer.
So I've spoken to veterans that try to navigate those systems, and they go to the VA, and they do have a fair amount of challenges.
Yeah.
You know, how would it be different from certain benefits, maybe certain state health benefits or programs that are out there for individuals, and there are third parties that help them navigate that, maybe for open enrollment or insurance or certain types of Husky benefits. They have third parties that I'm assuming get paid to help them navigate, the application process and
Yeah.
get them what they're entitled to. Is there a difference there?
Or a lawyer, right? I mean, you might hire a lawyer or an accountant to help you navigate any number of different processes. And of course, there's nothing wrong with service providers and people, helping you with any number of issues or processes in life. But I think what we're seeing is that these veterans benefits sharks are going after people who are vulnerable, and they're charging them money that's not regulated. I don't know how much money they're charging them, um, and there's no industry that keeps everybody in check and makes sure that there's fair and honest services and practices, and they're charging them for things that are free, and they're not disclosing to the veterans that that these services are otherwise free. So that's the difference. That's the difference. There's another related scam where, and I use that term intentionally. There's another related scam where uh, Connecticut business people are getting solicitations in the mail, sometimes on the phone, offering to help you with business registration, and other things that you can do for free on the Secretary of the State's website. And they make it seem like um, you have to use us, and they make it seem like they're government authorized. When you get envelopes in the mail, it looks like something official, but it's not. It's a solicitation. So they use these tricks and scammy behavior to get people to think, oh, I need to use this service, and I have to pay them money when it's otherwise free. And that's what we're seeing with the veterans benefit sharks. You have veterans who are unwittingly being tricked into thinking that they need to pay this person, that this person is their only hope, and that they have to pay for this service when in fact it's free and there are other resources. And I would say the final thing is, um, this is a particularly vulnerable population. People who are veterans, who we owe um, more than we could ever pay for their service and their commitment to all of us, and they're being taken advantage of and getting ripped off.
And that's something that I want to make sure that we address without maybe having some unintended consequences. I do believe that there are bad actors in every space, and I know there are bad actors in this benefit for the veterans, as we call them, the benefit sharks, if you will. My understanding, there are legitimate companies that help veterans at a reasonable cost to navigate this really tricky process.
Yeah.
So I just want to make sure there's not an unintended consequence, and we're going to be taking a resource away from the veterans that are helping them get the benefits. I wouldn't say they're free. I think they earn those benefits and sacrifice for them, and it's extremely challenging to get them. So for a reasonable fee to help navigate that, I think that we want to make sure we're striking the right balance of stopping individuals from, scamming our veterans or anyone really, for that matter. But I just want to make sure that we're not going to overreach and stop a service that may be valuable to the veterans. I mean, I could do my taxes for free, but I wouldn't do that.
Let me just add, Mike made a good point, that this practice, taking advantage of people and charging them for a service that is free, is already illegal under federal law. And one of the reasons why this has cropped up, this scam-like behavior, is because the federal government doesn't have an effective enforcement mechanism to enforce that law. And so we'd be filling an enforcement gap to protect people. Senator Ciccarella, if there are companies that are legitimate or believe themselves to be legitimate and think they're providing a valuable service and they're playing by the rules, we have no problem with them. And if they want to come to the Office of the Attorney General and speak to Mike and say, this is what we're doing, and we're disclosing to veterans that they can otherwise do this for free, and if they're not in violation of federal law, we're good.
Excellent. Well, thank you for answering those questions. Again,
Sure.
just want to make sure that we're flushing out any possible unintended consequence while still making sure that the consumers are protected. Thank you again for coming to testify
Thank you.
today.
Thank you, Senator. We have Senator Austin, and then that we'll have had you for an hour at that point in time, and then we're going to move on with the public hearing. So, Senator Austin, you're going to back clean up for us here.
I only have 1 hour of questions.
There we go.
so I actually don't have 1 hour of questions.
The Probst is on Thursday.
Yeah.
I'm sure.
Yes, and I'll have a lot of questions then. But no, I want to talk a little bit about the veterans. So you talked about veteran service officers, and here in Connecticut, we have veteran service officers who are unpaid volunteers who don't always have the knowledge that the veteran needs
Mhm.
because veterans cases are often very complicated.
Yeah.
So I want to make sure that we're not saying that veteran service officers are the answer because they often are not. Each town is supposed to have a veteran service officer. Some do, some don't. Some will not pay for them to go to the training that they need. Some go to the training on their own. So I want to make sure that people understand that each veteran's case is a little complicated and different. And that when we talk about free services, a lot of those free services are not up to par with providing representation as necessary. And you know, I'm a veteran.
Yep.
You know that this is an issue that's near and dear to my heart.
Yep.
And that I've done a lot of work around veterans benefits so that we're paying attention to a population. I don't know that we consider ourselves vulnerable. I do know that people try to take advantage of veterans. Most of us never felt vulnerable when we were engaging in service, so we're kind of proud about that whole term. But I just, on this point, I'm a little concerned. I have a veteran I'm helping out right now who is not receiving the benefits that they should under Agent Orange, even with the Federal PACT Act. The Federal PACT Act is limiting to the types of cancers that are eligible under that they may have gotten under Agent Orange. But doctors are finding more and more cancer treatments that are necessary for different kinds of cancer, different parts of the body that the cancer attacks. And I'm helping out a veteran down in my neck of the woods who is not getting the services that he needs. And he had to hire a lawyer, but this has been an ongoing case for him for a number of years. I don't think that that lawyer is doing him an injustice by providing him with the services that he would need. And I just want to make sure that when we do this, when Senator Ciccarella talked a little bit about unintended consequences, that we are not limiting the pool available to veterans broadly. And I'd also like to make sure that when we talk about veterans, that we're not, because a lot of time National Guardsmen, I'm sorry, did you want to,
Yeah, no, good.
are you sure?
Yep.
I don't care if you want
No,
to
no, no,
say something.
I'm happy.
So I also want to make sure that when we're talking about veterans, that we're not, because we really need to look at the definition of what a veteran is. So we have National Guardsmen who for years were not really considered in the population of veterans. And we use National Guardsmen as regular military now. We don't, you know, they, our own National Guardsmen here in Connecticut are deployed an average of every 3 years. At least a part of that particular troop gets deployed every 3 years now. And so we have to make sure that, I think that we have to look at that adjustment of who we are considering a veteran broadly. So I just, I remain concerned about this particular section of your bill here, and I would like to have further conversation with your colleague next to you who seems to have done some work relative to veterans benefits and veterans resources. So, and I would point out that veteran service officers are not always of the level necessary to handle the complicated cases that a veteran who gets into a specific need may actually achieve the end result that we need. So thank you.
Thank you. If
Mr.
I
Chair.
may, Mr. Chairman, thank you for that, for those points, Senator Austin, and we hear you on all of them. Let me say, I think it's clear that this is not a ban on services being provided to people. This is largely a disclosure bill, okay? That you have to tell people that that these services are otherwise free. It's consistent with federal law, and that you don't have to pay for them if you choose to go do it by yourself. And so this is just to make sure that people don't get taken advantage of. Um, we get tons of complaints, and some sad cases of veterans being targeted and taken advantage of and ripped off. There's a big case we took that doesn't speak to this specific issue about jewelry stores setting up shop outside of bases and taking advantage of young service members.
Yeah, they all want to get engaged.
Right,
I
but
tell them why. Just don't do it.
they
Wait.
they should also not pay 20, 30, 50% interest on the engagement ring that they want to buy. And so, look, when I say vulnerable, Senator, I certainly don't mean that people aren't tough and they're not strong. I but the veteran that you described who's trying to seek health care is nothing if not vulnerable, right? And so um, we're trying to help people that are in a tough. When I say vulnerable, I mean you're in a tough spot, okay? And I get that people need help and they want help, and maybe the existing public resources, don't go all the way, but they should know what they're getting into before they pay money, and they shouldn't be exposed to getting ripped off. And what I'm here to do, the only reason why I'm here, is to protect people from getting ripped off.
I understand what you're saying. I do. I just want to make sure that somebody's not saying they're going to get a free benefit and it's actually going to do what they need it to do. And that's a concern. And when somebody is listing off a number of services that are free, they have to know that that's an untrained person, and that is not something that people actually need. Sometimes you really need that trained professional. That's why we call lawyers, right? And none, well, I don't know if there's any lawyers in this group, so I can't say that. There's one over there. Kissel, John. I wouldn't go to my dry cleaner to handle a legal case for me, but I would not also posit that someone understands the complications of the medical field or the legal field, and say this person can do it for free. And I'm cautious about that because making a supposition like that is not necessarily helpful to that particular person. So I'd like to have that further conversation with I don't know your name. I apologize.
Mike Wertheimer, nice to meet you, Senator.
Nice to meet you.
Just a couple points, and I know we've been here a while now, but the policy reflected in this bill is already established policy. It's been that policy for years on the federal level, that if you're providing these services, it says you have to be accredited. There isn't a VA accreditation service. So that goes to one of your points. It can't be just someone off the street. And that for these certain types of benefit applications, federal policy has long been that you cannot charge veterans for it. You just can't. Now, if there's been a denial of those benefits and there's a
Right.
subsequent appeal, then of course you can hire a lawyer. That lawyer can charge. That's a whole separate process. But for the application of veterans' benefits that veterans have earned the right to apply for and often deserve, the policy decision has been made long ago that people cannot charge for that service. And that there are plenty of people out there that can do it for free. And if you're going to charge, then you shouldn't be providing this service. And the reason we need this bill is that the federal law does not have an associated enforcement mechanism. This would make a violation of that also a violation of the Unfair Trade Practices Act, so that our office could go out and actually protect veterans who are dealing with services that are running afoul of established federal law, but there's no one's keeping that in line and no one's watching.
So in how many cases have you had relative to that? How many people have actually come to you on this issue? Because again, I just want to make sure that we're not doing, and when you brought up the veteran service officers, I'm well aware of the veteran service officers. I was on the Veterans Committee when we put that in. But there is no requirement for that person to be paid, and there's no requirement for them to be trained unless the municipality can afford the training for that particular veteran service officers. Many of them go out and train themselves because they care about this. Many of them are veterans. I just want to make sure that we are not putting out that there are certain people that can do something for free when that is not really the case. And so I'm cautious about this, and I'm cautious about every time we say we're protecting veterans. So I often find that when we are protecting veterans, we're not really servicing veterans.
Mike, I'm going to jump in here. I think we're at a point where I think we're speaking the same language. We want to make sure that folks are protected. We think there might be some exploitation that's occurring. We want to flesh that out and ensure that people who are being taken advantage of are protected. But we also don't want to sacrifice a service being offered that may be enhancing benefits for a number of veterans. So we have some work to do on this issue. I know you guys care passionately. Again, you responded immediately on some of the issues we had with shrinkflation and inflation-related aspects of it. So work closely with Senator Austin. I know there's a number of members of this committee who do have some concerns. But with that, we've had you for an hour, Attorney General. Thank you so much for your time and effort. There seems to be broad consensus on 2 of these and some work to do on the 3rd. So we'll be in touch. Moving on, we've entered the portion of the hearing where we're going to take members of the public, followed by elected representatives in an alternating fashion. So first, from the member of the public, we have Brian Sullivan. Is Brian here? I'm not seeing Brian right now. We'll come back to him. William Breeden. Is William here? See, now we'll come back to him. Josh Elliott taking the place of Saud Anwar. Josh, if you can introduce Bianca as well, or maybe Bianca, you can introduce yourself.
Thank you, Chairman Lamar. Thank you, Chairman Maroney, and Ranking Members Ciccarella and Rutigliano. I am here today to testify for Senate Bill 430, and I will be ceding my time to Bianca Tylek of Worth Rises.
Thank you so much, and good morning. Good morning, Chair Maroney and Chair Lamar, and it's great to see you both again, and the rest of the committee members. My name is Bianca Tylek, and I'm the Executive Director of Worth Rises. We're a national nonprofit organization that works to end the exploitation of people who are incarcerated and their loved ones. And I come to this work as a victim of crime. 20 years ago, my partner was gunned down and murdered, and that is why I do this work. I come before you to introduce and express staunch support for Senate Bill 430, which would allow the state to deny or revoke business licenses for any corporation manufacturing, testing, or selling drugs or medical devices for the purpose of capital punishment. Connecticut abolished the death penalty in 2012, so you might be asking why we're here. Recognizing then the deep racial and economic injustice it perpetrates, as well as the high costs and failure to deter crime. Unfortunately, in recent years, several Connecticut-based corporations have been found to be facilitating the death penalty in other jurisdictions around the country. This discovery exposed a major loophole in the state's legal framework intended to ban the death penalty that is having a very real impact around our country. For example, in 2024, reporting by Last Week Tonight with John Oliver revealed that Hampden-based Absolute Standards was the source of lethal injection drugs used in 13 federal executions under the first Trump administration in 2020 and 2021. You will hear from a mother of one of those that was executed today. It has also been confirmed that Absolute Standards sold drugs to states with the death penalty like Arizona. While the corporation has since committed to no longer supplying lethal injection drugs, what it previously sold remains on federal and state shelves. Those drugs are now likely expired, but there are concerns that they may still be used. And now some states have moved to new methods of execution, like nitrogen suffocation. And again, Connecticut-based corporations are involved. In 2024, it was revealed that Windsor-based Walter Surface Technologies, through one of its subsidiaries, is manufacturing the gas masks, the respiratory masks that are used to deliver the nitrogen in Alabama, which has been used to now, as of last week, execute 4 people on Alabama's death row by gassing them to death. Connecticut corporations should reflect the values of the state, and that's why we're pushing Senate Bill 430. And this is incredibly timely as the current administration has released executive orders directing the U.S. Attorney General to expand the use of the death penalty at the federal and state level. Senate Bill 430 reflects a long-standing industry position among pharmaceutical manufacturers and distributors. All of the FDA-approved suppliers of drugs, over 60 major pharmaceutical corporations that have sold lethal injection drugs, have publicly opposed the use of their drugs and medical devices in executions and implemented distribution controls to protect their drugs from being sold for this purpose. Such corporations have even brought legal claims against states who sought to purchase their medicines in breach of these controls. The American Medical Association, the American Nurses Association, the American Pharmacists Association, and the Alliance of Pharmacies Compounding, among other professional associations, have all also come out against the misuse of healthcare products and medical personnel in executions. And beyond the healthcare industry, major chemical corporations like Airgas have also banned the use of nitrogen gas in executions. This has industry support because there is no legitimate market for the death penalty. And importantly, SB 430 would not and is not intended to impact legitimate uses of drugs and medical devices that are not to kill people. And so we hope for the committee's support behind Senate Bill 430.
Representative Elliott, any?
Nope.
Thank you, Bianca, for your time. I really do appreciate it. I know we had worked trying to get you in for Friday's hearing, but a little bit of a snafu. I appreciate that you were able to make the time to come here today. We do appreciate your willingness to make it on a tight timeline and to bring advocates to talk about this issue in greater detail.
Thank you so much. And I'll just say that there are a lot of advocates here from around the country because of the implications of this bill is nationwide, not just here in Connecticut, including several on Zoom who are also joining us, including Bill Breeden, who you mentioned, Reverend Bill Breeden. So hopefully we'll get back to him.
Sounds good. Yes, there are a number of folks who've signed up for this today, so we anticipate it being a robust conversation. There are some questions for you, however, so I'm going to turn over first to Representative Eckert.
Thank you, Mr. Chair, and Representative Elliott, good to see you. Thank you for being here and testifying. So I guess my quote is more the business aspect, regardless of just the component that that company may make and the thought of what the purpose is. These businesses, do we know the number? But you mentioned Windsor business, I believe.
Yes, there's
Windsor and then a
well,
Ham-
there's one in Windsor and one in Hamden that we know of right now.
Okay. Do these businesses make other products other than this product? These products?
Yes, absolutely. And I think that's a great question. We know there's a concern about whether that would shut the business down. This is not a major part of their business. In fact, Absolute Standards, the Hamden-based company, has already committed publicly to not supplying these drugs again. It was a chemical company. They were not FDA approved they don't make drugs for human consumption. So it was sort of wild that they went down this path to begin with, but they've already made that public statement. This is not a major part of their business. They can continue to operate in their main business lines.
Thank you. And do they know if these businesses that you mentioned have other offices that they could just move that operation to?
Absolute Standards, I believe, is here based in Connecticut, and I don't think that they have others. Walter Surface Technologies is actually the corporate parent of the subsidiary, which is based in South Carolina, that is manufacturing the respiratory mask. So certainly they could go there.
Again, thank you for your time, and thank you, Mr. Chair.
Absolutely.
Thank you. Representative Turco.
Thank you, Mr. Chairman. Just for my clarity, these particular drugs and medical devices, do they have any other use for them that you would consider as a legitimate use for any other purpose?
In most cases, yes. But this bill limits the ability for the state to revoke or deny a business license based on the intentional distribution for the purpose of the death penalty. So it would not impact their use for other legitimate purposes.
So they could still manufacture, if I'm understanding correctly, the same exact drugs and medical devices they may be now if their intent is not to use them towards
Correct.
death
Our
penalty
intention is
purposes.
to specifically box specific sales for the purpose of the death penalty, which in every case so far, we have seen that specific intent.
Thank you. And has similar legislation like this already been passed in some other states? Did you say that?
No, so we are not aware of other similar legislation in other states, but this is something that is actually quite familiar in Europe. So throughout the EU and other international, spaces, this has been done before.
Thank you very much. Thank you, Mr. Chairman.
Chairman Maroney.
Thank you very much for being here. I just had a request. So, this is a subject matter public hearing. It's a proposed bill. We don't have language yet. Would you be willing to share some language with us so that, because, in the testimony that was the Connecticut Hospital Association was
That's right.
opposed, but they said the unintended consequences, the way you explained it, intentionally for the purpose of the death penalty would seem to avoid those unintended consequences. So if you'd be willing to share that.
Absolutely. So we actually do have proposed language that I guess has it not been introduced yet? I think it has been introduced. There is language. It may have not been when the hospital association, we did see their testimony. We do not take issue with their intended proposals. So we will discuss that to ensure that that is sort of met, but we saw that and don't have any issue at this time with it.
Great. Thank you.
And for point of clarification, I think we have language. I think your testimonies helped to clarify some of the concerns that we have. So our
Very technical because it
Yeah.
goes into weird business license stuff that you don't expect us to talk about with the death penalty.
so
yeah,
as
it's long.
in the past, I'll rely on you to kind of correspond with our attorneys
Sure.
here to help us clarify some of that language.
Absolutely. Thank you, Representative.
Representative Acker for the second time.
Thank you. Flipping to a different area. So besides the penalty of death, does any of this drugs or products be used for aid in suicide? So like a dignity in dying. Did these use for those products also? Do you know of like if somebody there are states now that allow that you Vermont being one of them, I believe, and Oregon. So does this product it have a dual purpose or is it just for the death penalty?
Well, as I mentioned when Turco was here, that it has other purposes, like, medical devices, for example, a respiratory mask certainly has many purposes.
Yep.
So these drugs have purposes other than killing people, whether that's sort of intentional or aided. I will say I think that's a separate matter for a different discussion. I don't think we are certainly not the advocates to discuss sort of assisted suicide or things of that sort. But I do want to mention that there is a pretty big difference between someone's willingly, deciding that they want to end their life and then killing somebody who is perfectly healthy against their will.
So this is only for the sale for that purpose.
Correct.
The drug could still be used for other purposes, but not for the sale of that. That's the
Correct.
clarification. Perfect.
Yes.
Thank you for that clarity. Thank
Absolutely.
you. Thank you, Mr. Chair, for the follow-up.
Thank you. And it appears there's no further questions. Thank you again for your testimony today, and thank you for your willingness to work with the committee moving forward to make sure we get language that
Absolutely.
is reflective of what the ultimate goal is here.
Great.
We
Thank
appreciate
you so
it.
much. Thank you, committee.
I'm going to go back a few. Is Brian Sullivan in the room? Not seeing him. William Breeden online. William, are you there? I'm seeing William online. Oh, there we are. William, the floor is yours.
Thank you very much, and I'm honored to be here. My name is Bill Breeden. I'm Minister Emeritus of the Unitarian Universalist Church in Bloomington, Indiana. I'm the minister of record to a man on federal death row, having visited him monthly for 18 years. In January of 2021, I volunteered to serve as minister to Corey Johnson, one of the last 3 victims of President Trump's murder spree of 12 men and 1 woman. Corey was mentally impaired from birth and abandoned at the age of 12. He found family in a gang, and at 19, he was one of 2 men convicted of killing 7 persons in a gang war. In spite of being able to read or write, and 29 years in solitude, Corey became a remarkable human being. He was known as the gentle giant on the row. No one had ever heard him raise his voice in anger, and he was never written up for an infraction. I spent close to 30 hours with Corey in the last weeks of his life. some of the most rewarding hours of my 60 years of ministry. I accompanied him to the death chamber and witnessed what French philosopher Albert Camus described as the most cold-blooded, premeditated murder one can imagine. There is no way to prepare oneself for the experience of standing within 6 feet and witnessing the brutal murder of a person you have come to love. Corey was strapped to a cross-shaped gurney in the small killing room, able to move only his fingers. I can't say how long I stood there, occasionally telling Corey that I loved him. He was calm and silent. His family was behind a glass in a room behind me. Finally, a member of the killing team stepped into the room and announced, "There are no impediments." A strange way of saying we can murder this man. I was not permitted to read Corey's last words of confession and his apology to the victims' families, which he had dictated to me earlier that morning. The leader of the team shouted like a carnival barker, "Let the execution begin." The victims' family members from behind the glass, behind the room, across the room, began cheering and whistling like they had just scored a touchdown in the Super Bowl. A man in medical garb came in and injected the killing fluid into Corey's arm. After a few minutes, Corey struggled to breathe, his chest heaving. He curled his fingers and said, "It feels like my mouth and fingers are on fire." Corey's brother began shouting, "I love you, bro," over and over, and did not stop until Corey was pronounced dead. I don't know how long that took. Every minute seemed like an eternity. When it was done, I was allowed to touch his body for the first time, blessing him and saying a final prayer. There is no humane way to commit murder. I believe every person who enables state-sanctioned murder through legislative inaction or the manufacture of killing drugs is morally guilty of aiding and abetting the executioners. As Albert Camus wrote, "In times such as ours, it is imperative that thinking people not be on the side of the executioners." Since that time in the death chamber, I've suffered PTSD symptoms of nightmares and claustrophobia. I urge you to do all that you can do to prevent state-sanctioned murder. I will provide a copy of this statement and a copy of Corey's last words to this committee. Thank you very much for holding this meeting.
Thank you, Mr. Breeden, for your testimony here today and for sharing that story. Are there any questions for Mr. Breeden? Seeing none, thank you again for joining us this afternoon.
Thank you.
We've got a few public officials who are not in the room, so we're going to jump to Representative Weir, who is in the room.
Button on the
Representative?
left? Morning. Just the button on the left, or do we say?
You can push red. As long as things light up red, you're good.
It's red.
There you go.
Good. Good morning, Chairs Maroney and Lamar, Ranking Members Ciccarella and Rutigliano. I don't see Senator Ciccarella here. The House Republican Caucus thanks the General Law Committee for raising Senate Bill 611, an act establishing a maximum charge for certain occupational licenses, certification permits, and registrations. This incorporates also House Bill 5570 as proposed by the House Republican Caucus. As you know, this committee unanimously approved Senate Bill 135 during last year's session, which capped fees for a number of licenses, certifications, permits, and registrations, impacting a range of occupations. Unfortunately, despite this unanimously passing out of the Senate, SB 135 was never taken up in the House. This bill will pick up where last year's bill left off and provides this General Assembly with a second chance to demonstrate its commitment to Connecticut's economy and the state workforce. Occupational licensing is not a new thing, but it is always on the rise in a number of professions. Our state's licensing strategy hinders investment, entrepreneurial spirit by limiting an important entry point for those interested in a skilled trade, but who may lack certain economic advantages. So the high cost of licensing holds our state back from achieving its true economic potential. It limits the number of professionals who can enter a profession, and it gives consumers less access to goods and services. And if you lack, if we're losing out on competition, prices rise and choice is less. So this bill would reduce the barriers to employment, improve upward mobility, and remove those roadblocks. You shouldn't have, frankly put, or simply put, you shouldn't have to pay to go to work. So thank you for the opportunity to support Senate Bill 611. I encourage you to pass this favorably out of committee, and I hope that we might act on capping and eliminating occupational fees to make Connecticut a more attractive place to work and to grow. Thank you.
Thank you, Representative. And you have a really compelling ranking member on this committee who made that a clear priority for us early on in our screening process. And it enjoys, I think, broad bipartisan support, including, I think if I heard the governor right, he's all in as well. So it seems like we have some momentum this year to really tackle this. And I think the framing of this is like making people pay to go to work. And I think reform in this regard is very much necessary. And so I thank you for your testimony here today. And you should thank your ranking member who made sure we took this on as a core priority for the committee this year.
Thank you.
Senator Kissel.
Thank you very much, Chairman Lamar. Thank you so much. Appreciate the House effort. Was there any consideration for the occupational tax that lawyers pay of $565 a year? And could that be viewed as paying to work as well?
Well, all I can talk to is the occupational licensing, Senator, but I think anytime we're talking about reducing fees and making it easier to do business in Connecticut, I think that's a good discussion to have.
Thank you. I very much appreciate that. Just wanted to give a shout out for some people in other areas of work. Thank you.
Yeah, those poor lawyers. Thank you, Senator Kissel. And look, I'm going to be up in Bolton all day on Sunday for my daughter's hockey tournament. So come over to the Bolton Ice Palace after 8 a.m. anytime. I'll buy you a coffee. So we'll talk about
Let's
it more.
meet at Munson's Chocolates across the street.
That's
How
right.
about
Yes, we know.
that? Okay.
We're-
Just making
we-
sure.
we'll be there.
Sure. Well, I'll Representative, I'll be happy to meet you over there.
We got a few questions from Senator Maroney.
Actually, no, it was just a comment. He didn't buy me a cup of coffee when I went to meet him in West Haven at the ice rink. So apparently you rate a little higher than I do.
Thank you, Representative Ware.
The Senator giving us a great idea to make up for the fiscal note on this bill. We'll just double the fees for the lawyers to make up for carpenters and plumbers and people who work.
That's Representative Ritigliano. If folks need to send their letters to anyone, the email is ritigliano@cga.ct.gov. We have Brian Sullivan in the room. Nope. Elisa Clements. Elisa, you online?
Yeah, can you hear me?
We can, Elisa.
Good morning. Thank you so much, Chairpersons Maroney and Lamar and the members of the General Law Committee. My name is Elisa Clements, and I am the Deputy Director of Outreach and Advocacy for the Pet Advocacy Network. On behalf of the responsible pet care community, we ask that you vote no on House Bill 5112, which would prohibit pet stores from selling cats, dogs, and rabbits. This bill will not stop bad actors. What it will do will be to eliminate the most transparent source of pets that provide consumer protection and drive prospective pet owners to unregulated and unlicensed pet sellers. Licensed and regulated pet stores are the only place that families can turn to offer them peace of mind when they're choosing a new pet. They're able to bring home a dog or a cat that was raised under federal and state care standards. They have a detailed medical history, and in many cases, protection by a consumer warranty. They are a valuable and transparent option for prospective pet owners. This bill is also bad for Connecticut's economic growth. Small businesses make up the majority of pet stores in our state. Most of the states this bill targets are local businesses that have been open for decades in their communities and have established lifelong relationships with pet owners, relationships that sustain their businesses. If this bill becomes law, these stores would be forced to close their doors permanently because they can't compete with the product prices offered by online and big box retailers. This is not in the best interest of your constituents, their beloved pets, or the state's economy. Passing a law to ban pet sales would also result in the growth of unregulated market for puppy sales. There would be zero oversight and no system in place to protect animal welfare or the families that bring pets into their homes. Dogs and cats are offered through pet stores. They have protection by federal and state laws that require licensing, regular inspections, specific standards of care, and detailed record keeping on their health, veterinary care, and source. Under the current law, Connecticut pet stores and licensed breeders are highly regulated, inspected, and offer consumer warranties, protections that are not required of any other animal source, including shelters and rescues. These regulations have been in place for over a decade, with records to prove their success rates. In fact, this system was put in place by this body that's been so effective that other states are adopting them. Instead of dismantling a system that continues to be effective, the legislature should be looking for ways to strengthen the system to prevent bad actors from operating in the state. We need you to reject House Bill 5112 and instead work with the responsible pet care community to strengthen Connecticut laws that protect pets and their families. Thank you.
Thank you, Ms. Clements, for your testimony here today. We have Representative Turco, followed by Representative Ritigliano.
Thank you, Mr. Chairman. Thank you, Ms. Clements, for your testimony. Just a few follow-up questions. First, I just wanted to get an understanding. Pet Advocacy Network. Who supports your organization? What is the membership of your organization made up?
So we represent the interests and expertise of retailers, companion animal suppliers, manufacturers, distributors, pet owners, and then others who are involved with pet care across the community. So we work with the well-being and responsible pet ownership retailers, like I said, to make sure that we're having safe pet ownership.
Thank you for that. And you spoke about, and one thing I think we can agree on is you spoke about that if this bill was to pass that prohibited, the sale of dogs, cats, rabbits at pet stores, that it wouldn't stop all of the situations where, to ensure that consumers are protected from these pets coming from, puppy mills or places that are, not protecting the consumers here in Connecticut. Because you mentioned there's still the situation where you could have, breeders or other unregulated entities selling pets. Is that correct?
The bad breeders or the bad actors would still exist, but we want to examine. I can also actually punt it to my colleague Alyssa Miller, who is on the line too, for any follow-up specific to that. I will say though that we need to strengthen the laws. We have laws in place that exist for these regulations, and what we want to do is, like I said, strengthen the laws so we can prevent these bad actors, these bad breeders. Targeting pet stores with these sales bans aren't going to do anything about that.
Okay, so that's the one everything we can agree on is enhancing the laws regulation on the bad actors from any entity selling pets to potential Connecticut residents where there could be an issue with those pets. Tell me a little more, though, on why you think that pet stores themselves are properly regulated, or do you see room to expand regulation on pet stores too, not just on, breeders?
I would actually, if that's okay, punt it to my colleague Alyssa Miller, who's been with Pet Advocacy Network a little longer than I've been. If she's able to join.
No, at this time,
No.
if you we'll get Alyssa. She's number 24 on our
Okay.
list. So we'll get her a little bit later. But for now, we can just say that I'll wait until she testifies.
Yeah.
Oh, no, thank you, Ms. Clements. I'll reserve those further questions then for your colleague if you think that's the person I should ask some more details to.
Yeah, I feel like she would have a better, she's been with the organization a little bit longer than I have been. So might be able to answer that question more thoroughly than I could.
No problem. Thank you so much. Thank you, Mr. Chairman.
Thank you. Thank you, Mr. Chairman. So just because I don't know, and I want to know, where do most people in Connecticut get their pets from?
I would say that that's a variety. I think it depends on the person you talk to. I mean, we obviously, we have a lot of pet stores that sell dogs and cats. They certainly can get them from shelters. We hope that they're being responsible when they do look for a pet to enter their home, though. But I can't answer that adequately because I think it depends on what the consumer is looking for. And that's what we care about too, is having that consumer choice be available, that folks deserve to select a pet for their family that fits their needs.
So are there any regulations on a private breeder, somebody who's just breeding dogs just for a hobby or whatever? Do we have regulations on those folks that sell animals, or do we just have regulations on pet stores?
That I can't answer for you. I think that would be a Alyssa question.
Okay. I think I'll hold back with the good representative Turco and wait for a list.
Sorry.
Okay.
That's all right. Are there any other questions? Seeing none, thank you, Ms. Clintz, for your testimony today.
Thank you.
I have Representative Corpus. To be followed by Lisa Brown. If Brian Sullivan comes in, we'll grab him too.
Thank you very much, Chairs Maroney and Lamar, Ranking Members Ciccarella and Ritigliano, and other members of the Distinguished Committee. I'm State Representative Tina Corpus, and I represent the 149th District, which includes Greenwich and Stamford. I'm here to testify in support of SB 611. Many voters in my district wish to see opportunity increase in Connecticut. They want us to be a place which attracts people to come and work and retains them, not a place where they're discouraged from entering and incentivized to leave. I was so happy to see Governor Lamont's address, Governor Lamont's budget address, which sought to expand opportunity in Connecticut. His budget, as stated earlier in this hearing, included reducing licensing fees for certain in-demand professionals. The proposal would relieve 180,000 licensees of approximately $20 million in fees. SB 611 has some but not complete overlap with the license fees the governor wants to cut. Therefore, I'm here to testify in support of 611 to, in effect, expand the list of professions to whom we give license fee relief. My testimony will relate specifically to CPAs. The genesis of my testimony is the inquiry of two of my constituents. First of all, on CPA fees, Connecticut is an outlier, with its fees substantially in excess of those of neighboring states. I requested from the Office of Legislative Research a comparison of CPA licensing fees in Connecticut compared to other Northeast states. We charge more than 3 times what the next closest state charges for a CPA license. Connecticut is at $565 a year. New York, by way of example, is at $97 and New Jersey at $45. My written testimony will include the numbers for 8 different states. While there are legitimate reasons for requiring licenses, obviously, of CPAs in Connecticut, the licensing fees are simply supposed to cover the cost of processing the paperwork and are intended to be nominal. The licensing fees that we have discourage CPAs to practice in Connecticut. My 2 constituents are affected in different ways. One runs a 6-employee CPA firm based in Stamford, where she pays these fees on behalf of each one of her CPAs on the staff. This adds up. As a sole proprietor, she simply pays her people less to make up for the fee. The other constituent is a retired CPA in Greenwich, who after a successful career now consults as an expert witness and does taxes to supplement his income. He says that the high fee is a deterrent to him and to others in his profession to continue working at all and to retire in Connecticut. The revenue impact, according to the OLR of the CPA fees alone, will be approximately $2.7 million. But rather than justify the decrease, I think the burden of proof should be on the state to show why it needs $565 to collect and process one fee, more than 12 times what it costs New Jersey to do the same thing. I'm sure there was a well-intentioned reason when these fees were put into place, and this is not about blame or finger pointing. Instead, if looking at it in 2025, it doesn't make sense, now is our opportunity to fix it, and it sounds like there's a lot of consensus to do so. There are lots of ways to increase opportunity in our state. Some policies are far-reaching and macro, and some are small. While this might be characterized as small, it's still important. It'll give immediate relief, it'll force our state government to be more efficient, and it will send a message to productive professionals in each of these categories that Connecticut is open for business, and we are, in fact, a state of opportunity. Thank you.
Thank you, Representative, for your testimony today. And as I said to Rep. Weir, I think it's got broad support at this point in time. Representative Retigliano, early on in screening, sacrificed his own House bill in this regard to make this a priority. So I think you've got broad support here.
Thank you.
And I appreciate the governor's remarks in this vein as well. Senator Kissel.
Thank you very much, Chairman Lamar. Representative Corpus, it's great to see you. At first, I'm just going to give you a little shout out. We both serve as ranking members on the Select Committee on Special Education, and I just want to commend the job that you've done there thus far. It's a real pleasure working with you, and if anybody told me that you're a freshman, I would just be overwhelmed, because you just are doing fabulous. And also, I think your testimony is spot on, right? Certified public accountants, 565. 565 is an odd number, right? It's not an even number. And it's incredible because attorneys are charged 565 as well for their occupational tax. So I'm going to take a lead from you, and I'm going to do some research on what surrounding states are doing with attorneys' occupational taxes. And if it's anything like the CPAs, then I'm going to have more ammo for my argument that what's good for the goose is good for the gander. But I appreciate the strong full court press of the House Republicans on this issue for the last few years. And if we were able to get the last bill out of the Senate, and for whatever reason it didn't get through the House, I agree with Chairman Lamar that with the governor's backing, this bill, at least as it's presented, might have a full head of steam this year, and hope springs eternal. So thank you so much. And again, thank you for testifying this afternoon as well. Thank you, Mr. Chair.
You're making that fiscal note go up and up and up, though. We'll see. We'll see. Thank you, Representative Corpus. No further questions. We have Brian Sullivan, who's still not here. Lisa Brown. Is Lisa in the room? Be followed by Senator Fazio.
On this one. Okay. My name is Lisa Brown, and I flew here from Texas to speak to you today. I'm an Army veteran and a retired civil servant with a total of 40 years of federal service, and a strong advocate for justice. I'm here to strongly support SB 430, which would keep Connecticut companies from profiting from the death penalty. In 2020-2021, the Connecticut company Absolute Standards provided the drugs for 13 federal executions carried out during the first Trump administration. My son, Christopher Villalba, was the 7th of those executed with these drugs. I researched the effects of the execution drug pentobarbital prior to my son's execution. It took my son 28 minutes to die after the administration of the pentobarbital. Before he lost consciousness, his cheeks puffed out twice and he appeared to yawn once. These are classic signs of someone who is having difficulty breathing and is trying to get more air. His skin turned bluish purple, indicating that he was cyanotic. There were tears coming from his eyes as he turned his head to look at me as he was dying. According to the U.S. Department of Justice review of the Federal Execution Protocol Addendum and manner of execution regulation, the autopsy performed on Wesley Perkey, who was the 2nd of those 13 executed, showed that he had severe bilateral acute pulmonary edema. The physician who performed his autopsy weighed Perkey's lungs and found that they weighed more than 3 times the normal weight. Corey Johnson was one of the last of the 13 to be executed. He suffered significant lung damage from being diagnosed with COVID-19 prior to being executed. So his lungs were already compromised before he was executed. It was reported by the Associated Press that Johnson suffered from pulmonary edema and that, quote, so much fluid rushed up his trachea that some exited his mouth, which would have caused him to have suffered excruciating pain while dying. My son's death certificate indicates that his manner of death was homicide. During the execution, I realized that I was witnessing the state-sanctioned, premeditated murder of my son. I am grateful to Connecticut for banning the death penalty, but it is deeply troubling to me that Connecticut companies are still profiting from it. I ask that you support Senate Bill 430. Thank you.
Thank you, Ms. Brown, for your testimony today. I can only imagine how difficult this must be for you. Your willingness to share your deeply personal story is to be commended, and your willingness to come up to Connecticut to talk about the impact that the sale of this drug beyond our borders is having is to be commended. So I appreciate the time and energy and effort that it took for you to get here today. Are there questions for Ms. Brown? Seeing none, thank you.
Thank you.
Again. We appreciate it. Senator Fazio.
Thank you, Chairman Lamar and Maroney and Ranking Members Rutigliano and Ciccarella. I'm here to testify in favor of Senate Bill 611. This mirrors a bill that I've co-introduced with Senators Maroney and Gordon and Representative Kavros-DeGraw for the last couple of years, and I'm a firm believer that third time will be a charm for us. And last year we passed it unanimously through the Senate, and the previous year unanimously through this committee. And I was very glad to see a very similar proposal in the governor's budget released last week, and appreciate the work and the communication that Senators Maroney, me have had with the Department of Consumer Protection, particularly who regulates these items, to understand this barrier that is being put in front of so many young workers in the state who are looking to climb up life's ladder and make a life for themselves in Connecticut. These licensing fees, as Representative Corpus said, can be exorbitant, in excess of $500, approaching $1,000 a year, even for professions like preschool teachers, tree trimmers, and obviously for the trades, which is what many of the DCP licenses touches. This inhibits economic growth for the entire state, raises cost of living, and hurts young lower middle and middle income workers who are looking to make a life for themselves here in Connecticut. I think that the return to the state from limiting the cost of these licenses will far exceed the revenue loss, which is why I think the governor was right to put this, after 3 years of this being discussed in the legislature, was right to put this in his budget this year. It's far exceeding the cost of licensing fees in other states. And I think it would be an enormous bipartisan victory to finally make this policy change, reducing the cost of these taxes and fees on workers in the state of Connecticut a reality, to improve economic opportunity and growth, reduce the cost of living, and create more vibrancy in our state. So I appreciate the support that we've gotten from this committee in the past, and very excited to see hopefully this bill move forward again this year, and again hope that this will be the year that we can make it a reality in bipartisan fashion here in Connecticut. I forewent my written testimony, which I'll submit to the committee as well with some facts and figures, and obviously I'm open to questions and appreciate your time.
Thank you, Senator, for your testimony here today and for your persistence on this issue. It sounds like you've got a lot of allies this year. I mentioned this a couple times. Representative Ritigliano and Senator Ciccarella made it very clear during our early parts of the screening process that this was a priority bill that we were taking up in this committee this year. So they definitely have your back, and I think it's got broad bipartisan and gubernatorial support. So
Thank you, Mr. Chairman.
it's a good. I mean, Senator Kissel's going to try to make you make this fiscal note explode, though. So I'd be worried about him. Senator Kissel.
Thank you very much, Chairman Lamar. I'm feeling the love. Senator Fazio, thank you for coming and taking the time. I just want to let you know that I've run upstairs, and so I cast my votes in Finance, Revenue, and Bonding. As my ranking member on that committee, I know you want to make sure that we're all duly marked down appropriately. And on this matter, I think you're exactly correct. Third time is a charm. I don't want to undermine this. I'm trying to let people know that there's other areas where people are paying what I would consider an arm and a leg, and not all lawyers are rich, but they're fun to kick around. I'll grant you that. As I had indicated to Representative Corpus, who hails from your Senate district, and she's doing a fabulous job as a freshman, but you know, we have a crying need for folks to try to get into pre-K as far as educators and paras and all of that. The fact that Connecticut is not only an outlier when it comes to surrounding states, but that we're undermining the ability of people even to consider going into a field that doesn't even pay a living wage before the state of Connecticut even passes around the cup to try to get their fees is incredible. So I think that not only are you helping people because it is just wrong to charge people to want to be able to go out there and work and make a living. But especially in areas where we can't even get enough people right now to serve the needs that we have as a state. So I really hope it goes from your lips to God's ears that third time is a charm, but having the governor on board certainly doesn't hurt, that's for sure. So thank you for doing what you're doing and coming and testifying. And thank you, Mr. Chair.
Thank you, Senator.
Thank you. See no other questions. Good
Thank
to see you
you all.
again. And I also went upstairs and cast my votes in finance. I know you weren't as happy about that, but good to see you again.
Have a great day.
We have Brian Sullivan still to testify. If anyone sees or knows Brian, let him know we're waiting for him. We have James Bias to be followed by Representative Morton Bello.
Good morning or afternoon. Co-Chair Senator Maroney, Representative Lamar, Vice Chair Senator Fanfara and Representative Turco, and Ranking Member Senator Ciccarella, there we go, and Representative Ritigliano, there we go. My name is James Bias. I'm the Executive Director for the Connecticut Humane Society, and I'm here today to ask for your support on House Bill 5112. An act prohibiting pet stores from purchasing or procuring dogs, cats, or rabbits. Having spent more than 40 years working with 6 animal control and humane organizations in 3 different states, I've had the ability to come in contact with a number of individuals that either support the Humane Society or the groups I've worked for, the general public, elected officials, and this particular bill will have a direct impact and change on dogs, cats, and rabbits, not only in Connecticut, but nationwide. It's our hope that the passage of this bill will reflect the wishes of those people that I've talked to over the years. Pet store operators will tell you that they only get sourced animals from licensed or approved USDA breeders. The USDA does not approve any breeder. They license them based on a snapshot of inspection and that application process. I've yet to see these trade organizations that represent pet stores introduce legislation to guide their industry in a more formal way. In fact, it's usually the exact opposite. We hope that this commercial sourced breeding mill retail model of selling dogs, cats, and rabbits shift to supporting our overwhelmed shelters that we hear about here in Connecticut and across the nation, rescue organizations, and responsible non-commercial breeders. Thank you for your support, and I'll answer any questions you might have.
Thank you, Mr. Bias. We have Representative Turkle to be followed by Representative Ackert.
Thank you, Mr. Chairman. Thank you, James, for being here and all the great work that the Connecticut Humane Society does in Newington and around the state to find individuals. Well, first, take care of the animals. That's the first priority, right? Make sure they have good homes with Connecticut residents. So I think it's really, really important the distinction that you just made regarding licensure, USDA providing a license to what are the facilities called that that raise the animals and things like that?
So the breeding operations, and these are going to be breeding operations that do not sell directly face to face with consumers. These are going to be selling to, research facilities. They're going to be selling to retailers. So they don't have a direct interaction with the family where these animals are going to. A non-commercial breeder is going to be somebody who is dealing directly with the consumer, the adopter, the buyer. And that's the big separation. Connecticut at last look has no USDA breeding facilities. So we're talking about animals out of state that quite often might be protected by their state animal cruelty laws, but most breeding facilities are not open to anybody to come in and just take a look around.
So a pet store we have here in Connecticut will purchase the dogs, cats, rabbits that they sell here in our state from one of these breeding facilities. And if I'm understanding correctly, these breeding facilities may have a license through USDA where they pay some sort of fee, fill out an application, but there's no inspection process to see how these animals are being treated, the breeding operations, rules, regulations around that.
That's correct. And if in the spirit of wanting to be transparent, if these sellers were really proud of where they're getting animals from, they would be showing you the exact facilities where these dogs, cats, and rabbits are coming from. But there's no desire or interest in being transparent because these operations are motivated by money. They're commercial enterprises.
And being a rescue, the Humane Society being a rescue shelter, do you receive animals that were purchased from individuals from a pet store in Connecticut that then perhaps the animal has a lot of medical conditions or problems, and then end up in your shelter? And if so, what does that look like for you all?
Most definitely. We do see animals that come from all sources. I'm happy to say we're seeing more people consider shelter and rescue organizations as their first point of acquisition, but there are still people that are moved by the retail model of seeing, the puppy behind the window, and even the retailers get fancy with their phraseology. They'll call it an adoption fee instead of the cost. But we do see animals that are genetically predisposed to issues because they're being bred for quantity, not quality.
And I think one of the important parts of this bill, I'd like to get your opinion on it, is that it does not prohibit a shelter like the Connecticut Humane Society from partnering with one of the stores who, let's say this bill passed and they were prohibited from selling the animals, they could partner with you and have the animals there for adoption. So they could bring people into the store and get business with people buying pet food and toys and all kinds of stuff for their pets, but adopt a pet instead of purchase one from these non-regulated, breeding facilities. What are your thoughts on that?
We already see examples of that. The big box stores, the PetSmart, the Petcos, they don't retail dogs, cats, rabbits. They invite rescue groups to come in and use their real estate. And they've learned that the markup and the money that supports their investors and shareholders are going to be on the products that go along with the adoptions that are happening under their roof. And so I think we're seeing fewer and fewer of the pet stores that are interested in buying from a commercial breeder and then selling directly to the consumer and partnering. And we're going to continue to see, I think, more and more of that. New York passed a similar law that went into effect last year. So we're seeing now some of those pet stores move to Connecticut because this is the convenient piece of real estate to move to. And we'll probably see more if we don't get a handle on this.
And do you have any concerns if this bill was to pass that it could result in increased sales from some other type of some other type of entity like online, some social media marketplaces and stuff where people are selling pets from around the country directly to consumers here in Connecticut where there are no protections as well, and if so, I just want to prepare for that possibility. How can we protect consumers from those situations?
I don't know what the numbers are for the licensed pet stores that are selling to the public, so I don't know what numbers we're talking about. Certainly, the Department of Agriculture maintains statistics for shelter placements. Online sales is an issue, and it'll continue to be an issue. We try to inform prospective families to know the truth behind the cute. You're looking at a cute little animal online, but what's behind that? And so, for us, it's really a matter of just trying to deal with this overwhelming number of animals that we do see coming into our municipal shelters and our private shelters and rescue groups right now.
Well, thank you. And I think I could speak for my colleagues when we say we're looking forward to Puppy Day at the Capitol again, as you do annually with the, rescue, pets. And I'm looking forward to getting another dog myself one day, and it will definitely be a rescue dog from the Connecticut Humane Society when I'm ready. So
we keep working on you.
I
every
know.
year,
I'm getting close.
but we will be back at her again this year.
Thank you for everything you all do. Thank you, Mr. Chairman.
Representative Ackert. Thank you, Mr. Chair. And again, thank you for being here. So I guess some more thinking about like the consumer side of it, right? Where if we had, you mentioned the best way to get animals if you wanted, but if you're looking for a specific animal, right? I need this type of, Labradoodle or something like that. Your suggestion on that is, if a pet store has it. I haven't seen many pet stores lately. I'm in an area where I see the bigger pet stores. They're, like you said, there's no any pets for sale at them anymore. But what is if you had the perfect scenario, what is that? Because you go to a breeder and, that's an individual sale. And again, remember, we talk about making money. The breeders make money. They're not doing this for a hobby per se. The stores are doing it to make money also. So where's that line of my consumer protection? That if I go to the local breeder and he's like, "God, too bad on you, sue me." But if I go to a commercial sales facility, that I have recourse that way. What is the best? I mean, I'm trying to figure out what's better for the consumer.
Most definitely if you're looking for a particular breed type, and right now anything that has oodle in it, whatever, golden retriever, poodle mixes, there are some breeders out there that will invite you to their home. They'll let you take a look. They'll at least have one and sometimes both parent animals there. And you're going to get to know the behavioral characteristics of the dog that they have there. The retailer doesn't have that ability. Animal shelters don't have that ability, but there are some inherent characteristics you're going to see with certain breed types. And those breeders, I will say, I don't see these private breeders lining their pockets in gold. They're moved by the passion of the animal, sometimes two types of breeds that they look at, and also breed rescue groups. So there are some rescuers out there that are very careful on who they place, sometimes young animals as well as mature animals that somebody's already done the hard work for. But there are opportunities out there if you are looking for a particular breed type that's not at the local shelter or pet store.
Thank you for that. And you brought up a good point there that, right, the breeders invested a lot of time already, right? So that's a great point as opposed to a retail store that gets it at the opportunity when all the work is done and then puts it in a front window for sale. So I'll listen to more dialogue on this. I thank you for your time and for what you do. Thank you, Mr. Chair.
Thank you. Seeing no more questions. Thank you, Mr. Bias, for your testimony today. Representative Morambello online, to be followed by Stephen Mendelson.
Good afternoon, Chairs Lamar and Maroney. Can you hear me?
We can.
Fantastic. I'm speaking in support of HB 5112, an act prohibiting pet stores from purchasing or procuring dogs, cats, and rabbits. I submitted this bill along with Rep. Turco in an attempt to slow the influx of puppy mill dogs into the state of Connecticut. A law prohibiting the sale of dogs has gone into effect recently in New York, and it joins California, Maryland, Maine, Washington, Illinois, Oregon, and Vermont. There's also hundreds of cities across the country, like Chicago, Boston, Philadelphia, El Paso, and Austin, who have also implemented bans. Let me be clear, this bill does not prohibit the sale of cats, dogs, and rabbits from breeders directly or from our shelter or rescue organizations. And as others have said, it includes language to allow a pet shop to work with a shelter or a rescue to house the animals for adoption. A good breeder won't be selling animals through brokers to pet stores or directly to pet stores. Good breeders are selling them directly to families to ensure proper placement and that they're able to meet with the people who are going to be owning their dogs. According to the Humane Society of the United States, the USDA licensing does not mean a facility is humane. In 2024, documents showed breeders with numerous and egregious violations spanning years were still licensed by the USDA. And the USDA, excuse me, lacks the sufficient inspection capabilities to inspect more than 8,000 pet dealers and exhibitors and research facilities. We can see health records for interstate transfers, and they show that thousands of puppies were imported to Connecticut pet stores from Midwest puppy mill breeders and brokers since 2021. Many of these puppies were purchased from massive Missouri, Ohio, and Iowa-based brokers rather than directly from breeders. So we're limiting the consumer's ability to easily find out breeder information. We just can't find out necessarily where dogs are coming from, the situation they're being raised in. And Massachusetts currently has a proposal, and its reports state, I'm going to quote it, of the top 25 pet store chains in the nation, only one is selling puppies. The others are thriving by selling products and offering quality services such as grooming, training, and boarding. They also partner with shelters and rescues to hold adoption events at their stores, saving animals' lives and driving more consumers into their stores to buy all the supplies a new canine family member needs. So, of the top 25 store chains in the nation, only one is selling puppies currently, and they're still able to survive and do business. So I hope we'll join other states and cities across the country to protect the lives of our pets and prohibit the sale of dogs, cats, and rabbits in pet stores in Connecticut. And I thank you for your time today.
Thank you, Representative, for your testimony. Representative Turco? No, we're all set. Thank you, Representative, for your time. Seeing no further questions, thank you again. We have Stephen Mendelson. If Senator Anwar is back in the room, we'll take him. But after Mr. Mendelson, we have Ms. Correa Brown, followed by Mr. Langley and Ms. Walker.
Am I on here? Okay. Yes. My name is Stephen Mendelson. I am a disability rights advocate. I am also a member of the board of directors of the Euthanasia Prevention Coalition USA. I'm testifying in opposition as proposed to Senate Bill 430 regarding drugs and medical devices used to execute the death penalty. Again, you have my written testimony. You have my friend Kathy Ludlam's written testimony. I'll try to summarize here. Senate Bill 430 constitutes selective indignation with a vengeance. There's no moral reason to prohibit drugs and medical devices for capital punishment while omitting what are often the same drugs and devices for euthanasia and assisted suicide. This is, in fact, lethal disability discrimination. Assisted suicide and euthanasia constitute capital punishment for the so-called crime of being old, ill, and disabled, with far less transparency or oversight. All the legitimate arguments against the death penalty, opposition to state-sanctioned killing, the corruption of the medical profession by turning doctors into agents of death, the wrong people dying for the wrong reasons, racial and class inequities, the inability of medical science to guarantee a quick and painless death apply all the more so to assisted suicide and euthanasia. If the state has any legitimate reason to take a life, it should be the lives of those like Linda Mai Lee, formerly Stephen Hayes, and Joshua Komosarjevsky, who by their murderous actions have forfeited their moral right to live. Connecticut needs to take a strong stand against exposing vulnerable elders and disabled people to enable a system of state-sanctioned medical killing. And I deal with all the different abuses. Again, we said that somehow it's voluntary. I show, again, all the people who are not voluntary, where there's coercion, there's no witnesses. There are people who are getting these drugs who have anorexia, people who are qualifying simply because they voluntarily stopped eating and drinking. And Representative Elliott has openly said he wants to further expand the law once he passes it to allow more and more people to qualify. And we have a move to euthanasia in California. Specifically, what I'm concerned about here is we just heard from one of the proponents about a death that took, I think, 8 minutes, if I heard correctly. We have deaths here from assisted suicide that are really horrible, that are detailed in my written testimony. One, according to the latest Oregon Death with Dignity data summary, that took 137 hours, nearly 6 days to die. Many of these deaths are much more simply because it requires that the drugs be taken orally. If you think lethal injection is inhumane, imagine how much more so these experimental oral compounds have been. They burn the drugs burn the throat, and the fact that we have Senator Anwar and Representative Elliott claiming falsely that this is a peaceful death is a lie. Also the fact is, again, there are no witnesses, unlike what we saw with the lethal with capital punishment. And in fact, the death certificate is falsified. This has actually led our own state's Division of Criminal Justice to repeatedly testify against assisted suicide bills at least 3 times. And also the other thing is, because of the self-administration requirement, doctors can't intervene and then put the patient down if there's complications from assisted suicide. So that, I mean, if anything, we're seeing more agonizing deaths from assisted suicide than we are from the death penalty. We just have a lot more reporting on it. So I urge this committee, if it's going to move, not move with this bill until we also cover the drugs used in assisted suicide and euthanasia. As regarding the Connecticut Hospital Association's testimony, while the individual components have legitimate medical uses, the combination of diazepam, digoxin, morphine sulfate, amitriptyline, and phenobarbital compounded by a compounding pharmacy has only one purpose, and that's to kill somebody in an assisted suicide. Thank you very much. I'm happy to take any questions.
Thank you, Mr. Mendelson, for your testimony. Just want to make it clear, the bill related to assisted suicide or death and dignity is not up for debate in the room today. So I don't want to go too far afield of what's under consideration.
We are asking that you not move forward until you include that in this
as a
bill
prohibited
here,
sale.
as a prohibited sale.
Right. Perfect. Thank you. Senator Kissel.
Thank you very much, Chairman Lamar. And just to make it clear and I've been on this committee off and on for over 30 years, and once upon a time was chair of this committee. Typically, in the last few years, the physician-assisted suicide bill came before the Judiciary Committee. I want to assure you, and I oppose that bill.
Yeah.
Adamantly, for a variety of reasons.
Appreciated.
On this bill today that we're talking about, I'm still listening to testimony. But as far as the Judiciary Committee goes, as the ranking member thereon and having had our final screening, there will be no bill in our committee, whether it's raised somewhere else in this building, maybe the
Public
the
Health.
Health Committee,
Which is
but
where it's been
certainly
raised,
not.
yeah.
But that whole concept is not going to be before the Judiciary Committee this year unless it's a referral from somewhere else. So at least I think you should relax about that.
I
at least as
understand,
far
but
as
we've
that
been
goes.
up here almost
But I
every year since
appreciate-
2013.
I gotcha. But I appreciate, they say consistency is the hobgoblin of little minds, which is probably a little tough on some people. But yeah, there seems to be a disconnect in a lot of this stuff that's trundling along towards passage or not passage. But I'm not aware that that has any legs this year, so I would not be too concerned. Thank you. Thank you, Mr. Chair.
Yeah, I'll just answer. I just, again, it's part of it is here is the moral consistency of it. It's that, yeah.
Thank you. Seeing no other questions for Mr. Mendelson, thank you for your testimony today.
You're very welcome.
Senator Anwar. After Senator Anwar, we have Ivelisse Correa Brown and Scott Langley.
Good afternoon, Mr. Chair, Senator Maroney, Representative Lamar, ranking members Paul Ciccarella, who I think has just stepped out for a bit, and also ranking member Representative Rutigliano and distinguished members of the General Law Committee. I'm here to speak about support for Senate Bill 430. This bill is to prohibit individuals and businesses licensed in our state from manufacturing, compounding, selling, testing, distributing, dispensing, or supplying drugs or medical devices intended for use in executions. It aligns with the state's policies, both ethic and medical standards and human rights principles. And again, this is supported by the American Medical Association, American Pharmacists Association, World Medical Association as well, who strongly oppose the use of medical products in execution. Connecticut abolished the death penalty in 2012. To uphold this stance, we must ensure that no entity within its jurisdiction profits from or enables executions in other states. Our laws should be consistent with our values, and I just happened to hear about the other testimony, so I will not put that in my testimony, but if you would ask me questions, I can answer those, and that would be your chance. Thank you so much for my opportunity to speak today. Thank you.
Thank you, Senator. I don't want to necessarily discuss bills that aren't before this committee as part of this committee. I will ask you, though, as one of the lead proponents of this bill, if this was amended to prohibit the sale for use in physician-assisted suicide or death with dignity purposes, would you be opposed or in opposition to that potential amendment?
I would be opposed to that. Thank you.
Thank you. Senator Kissel.
Thank you very much, Chairman Lamar. Senator, always great to see you, my friend and colleague from the Senate chamber. What if some manufacturer, first of all, I have concerns, I'll leave them for another day regarding interstate commerce and constitutionality. But on the bill that we have before us, what if we have an otherwise good manufacturer here in Connecticut that is producing something that could be tied into an execution that's taking place lawfully in one of our sister states in the country. And I know that some of the previous speakers wanted to allude to President Trump. I don't think that on the federal system it was just in the Trump administration. I'm sure that under the Biden administration and Obama administration, I mean, if it's federal policy, it's federal policy. So let's just set that whole distinction aside for now. But the product has a lawful purpose, but could be used in an execution or not. How do you draw a distinction whether Connecticut on its own should be banning that? You know, something that you fasten someone to a table so that they can't move. Yeah, those fasteners are used in the execution room, but they also could be used because someone acts out violently and they just want to restrain them. So are you limiting it? And again, even if we get down to molecular components, what if a dosage could be used for positive health ramification or health treatment, but a dosage that might be larger than that could actually kill someone? Where do you draw the line?
Thank you so much, Senator Kissel, for your very valid question. So this is about execution. So if a medicine is being proved to help take care of an individual's health, it's allowed. But if it is going to be used for execution, if the company is in the state of Connecticut, it's manufacturing in the state of Connecticut, the Department of Consumer Protection regulates that, they're licensed by that, or if that individual is also licensed to be able to work in the state of Connecticut, that is where we are saying as a state of Connecticut, that's what we stand for, and we're going to ask through this bill that they would not be allowed to knowingly and directly and indirectly use it for execution purposes. That's the difference. But if the same medicine can be used for health benefits, by all means, they can do that.
Well, I have real problems with this bill proposal. I'm not going to pontificate about it, but it's one thing to have our treasurer make decisions with our pension fund as far as investments and have that comport with our publicly stated philosophies regarding what we like as a state and what we don't. When we have manufacturers, on the other hand, that are otherwise acting lawfully, I have a real hard time reaching in and telling them, oh, you can't do this and you can't do that, because that's different than an investment in my view. And I think that it's also sort of scary when we're going to try to legislate things that's a very gray area. And you said, well, if it's going to help someone's health versus not help someone's health, I mean, I can go into any CVS up and down the aisle, and if you take too much of almost anything, it's going to harm you or kill you. But most of that stuff is completely appropriate for treating certain symptoms. So I get, I appreciate the moral feelings of the proponents. I get that, and we can agree or disagree. But when we get to the minutia of how are we going to craft a bill that doesn't throw the baby out in the bathwater, A, and B, doesn't drive businesses out of our state or make them fearful of coming to our state, because oh my God, that's Connecticut. They could wake up tomorrow and say, oh, you can't manufacture this otherwise legal product because somehow it's tied into something that they're not happy with. That creates a very chilling effect if we're thinking about economic growth as a state. So I just wanted that on the record because I'm getting concerned with what I'm hearing this afternoon on some of these proposals. Thank you, Mr. Chair.
Thank you. I can respond, but
Please do. Yes.
so I appreciate where you're coming from. This is very specific on a specific area, which is you'd be surprised that almost most part of Europe has already moved in this direction. Many of the other countries have moved in that direction. It's just one state which is staying, that we do not believe that the products made over here should be used for execution in other parts of the country. And that's what this is about. Is that going to result in all the companies that are using execution material to not come to Connecticut? I think we can look at the pros and cons of those options. I know that we are doing some very smart scientific work that we are doing. We are doing a lot of medical research in our state. Would that be a detriment to the economy of our state, that people are going to the businesses doing execution work in the state of Connecticut? I'm not convinced that's going to be a huge loss, because in our industries that we are promoting, there's so much that's happening that's outside of that realm. So just my perspective. Thank you for your question.
Seeing no other questions, thank you, Senator
Thank you so
Anwar, for your
much.
testimony
Thank you.
today. So next we have Evelise Correa Brown, followed by Scott Langley and Jennifer Walker.
Good afternoon. I'd like to thank the committee for allowing me to speak today. My name is Evelise Correa, Vice President of BLM 860. I'm here to support several bills, beginning with HB 6857, an act concerning the Attorney General's recommendations regarding social media and minors. When I worked in education, I'd watch a student download Instagram in the morning and delete it on the bus ride home. I vowed to never allow my own kids on social media till my youngest went behind my back and created an Instagram account. While my older kids don't care about social media, my youngest enjoys testing me, possibly because a catered algorithm is much more interesting than her mother. I don't think this bill goes far enough, but it's easier to pass this bill to get our foot in the door and add additional protections through future legislative sessions. Unlike cigarettes or liquor, social media apps are free and accessible. The US as a whole needs better data protection laws, but children at least deserve something. Next, SB 430, an act prohibiting certain drugs and medical devices used to execute the death penalty. I actually have an article written in 2002 that's published over at the Dodge Centers for Humanities against the death penalty, and I'm the granddaughter of a victim of gun violence who was never able to meet her grandfather. My life is shaped by gun violence as a result. Connecticut outlawed the death penalty in 2012 and fully abolished it in 2015. It was found to be cruel, unusual, and racist. It takes a grave amount of cognitive dissonance to produce drugs and medicines that end a human life in a state where it is outlawed. Connecticut deserves no credit for outlawing the death penalty if they still assist in the practice. In the same manner that Connecticut shouldn't get credit for its textiles in outlawing slavery before the South um, abolished slavery because they were still producing textiles using Southern slave labor. It is imperative that Connecticut laws catch up with Connecticut practices. In the same manner that quercetin is now controlled from meth dealers, but it's still possible for people to, pick it up while they have bad colds, Connecticut can produce certain products without selling them to agents of death. Finally, HB 6856, the price gouging bill. I am the mother of 3 teenagers. Both of my sons are taller than me. My family just met their out-of-pocket deductible for both in-network and out-of-network coverage, but none of that matters because my kids are eating me out of house and home, just like every other teenager is with their families in Connecticut. I don't believe this bill goes far enough, but anything helps. Labeling will help consumers make choices on where to spend their money, and if Arizona iced tea is holding strong, consumers need to be informed about what companies are not holding strong. Thank you.
Thank you for your testimony, Evilise. Is that okay?
Yes.
Sorry, I called you Ivalise like 3 times. I apologize for
I'm
that.
used to it.
Evilise. I'll get it right. So thank you for your testimony. I do appreciate you testifying on each of the 3 bills that you mentioned. I want to touch back again on the social media aspect of this. This is something that I think on a bipartisan basis, multiple chambers, really frankly, legislatures across the country are grappling with. What are the appropriate controls that government can put in place or restrictions that we can apply to social media companies, and like how to protect minors best, considering I'm 48-year-old man who did not grow up with any of this stuff. I've downloaded some apps on my phone that allow me to peek into my 15-year-old son's phone anytime I want. I can set limits. I can request him to take pictures, but really his mind and his ability far exceeds mine in getting around the very controls that I personally would put into place.
Yeah.
And with the limits that I put into place, he already knows ways to counteract them. He can already, and I can't take away every aspect of it because that's how he talks to his friends. That's how he arranges his social activities. That's where he does his homework. That's how he checks his grades. It's all incumbent upon the very device that we know is being used as a tool to either market to him or to get him addicted to whatever activity there is. You've been here the whole day. You saw, I think the allegory that Representative Acker raised with Attorney General Tong about they're into fishing and like they want to look up like what's the best rod and tackle to use on my afternoon that I get once a month, and within 4 or 5 videos, they're being pushed towards the most extreme fishing imaginable. Right. And like I talk about it all the time, like a teenager struggling with body health images, or a teen looking for skincare, or a teen wanting to know like, hey, what kind of sweatpants should I wear? Like very quickly gets pushed in some very dangerous places. And the rise of anxiety and depression, suicidal ideation amongst teens is at all-time high. And people say it's correlation. No, there's a lot of research in national medical journals that say it's directly causal. The amount of time that you spend on social media and your exposure to images and marketing leads you in those directions. So this is one parent to another. This isn't
Yeah.
this isn't chair of a committee. This isn't we got to get this legislation right.
Fellow frustrated parent.
Fellow frustrated parent. We've got thoughts and ideas. Are there specific things that you can think of that would help parents beyond just we're going to make those social media companies create a process by which there's got to be age verification and time limits, and they can't send notifications between midnight and 6 a.m. What do we do to help each other? What do we do to help parents navigate this?
That's $1 million question right there. So kids can get around the firewalls at their schools, or at least my son got in trouble for it. So
Right. I mean, that's the thing.
um,
I'm positive your kid, like my kid, can figure out a way around anything that I think of. And so I think that's going to be a challenge for us too. It's like put these rules in place, but we've got to figure out
I
something.
think, and I mean, this is just me. Besides the lawsuit, monetary compensation for there's now causation that's been found. So monetary compensation to the states for the increase in mental health costs for children. Um, companies really don't care until they have to come out of pocket. So you can show them, studies, you can show them the impacts of this. I mean, they're they know the impacts of it, which is why they hire the people they do. This is why they've created the algorithm in such a way where you're not going to look away. In fact, I prefer Twitter's videos because they just automatically scroll. You don't have to do anything. Once one video pops up, it just keeps going. Um, but companies aren't going to care about how addictive anything is unless there's some sort of penalty. And there's going to be an uproar if it's banned. Um, but if companies are forced to pay some sort of fine, some sort of something, I think they might start to care because it'll start impacting their bottom line. Um, no one's really checking to see whether or not someone is 18 or 13 when they're signing up for a social media account. You can report the accounts a million times, and the accounts aren't going to be taken down. So that's my perspective on it. But because age verification, you're going to click right through it. If you've got to upload your parent's ID, if you've got like Roblox, you have to have like a parent email. So my kids are constantly, oh, mom, what's the code? I got to do this for Roblox. And my email's tied in as like a parent email, which I didn't even know was possible. Um, firewalls are going to be taken down. I mean, I was using, I forgot the name of the website, but when I wanted to get on MySpace when I was in school, you couldn't really stop me. So, yeah, kind of dating
I
myself.
just went to the library, right? Like the library the other day.
No, I actually, so,
That's how I got around. I went to the library.
no,
Use the library computers.
I forgot the name of the website. It was a VPN. Well, before VPNs were like actual VPNs, I would just go on the website and then afterwards I'd be able to browse just fine. You couldn't. So,
Yeah. Well, thank you. I appreciate the conversation. Any other questions? Senator Kissel.
Thank you very much, Mr. Chairman. I completely related to the good chair's questioning because I'm going to date myself. Forget about the cell phones. Like we used to be able to adults, you can program your cable TV and all this stuff. And I'd have to ask my son to help me do that, to block him. So yeah, they're just way in advance of us. My question, I'm going to stay away from a couple of the other areas, but has to do with the price gouging.
yes.
And I've sort of seen that sort of rise to the forefront a couple of times. One time was we went through this horrific winter where we had just tons of snow over and over and over, and things like roof rakes were going at a premium and people were going crazy. And so there was allegations that there was price gouging regarding to anything that had to do with clearing snow. And then the other obvious great period was during the pandemic, where who knew that, toilet paper and other sanitizers for your hands, just really basic stuff that you would never think that would be at a premium. And if you went to the store and they said, it was crazy because during the height of the pandemic, I knew when the toilet paper delivery was going to be. Every period of time at the CVS, you would time it perfectly so that you would have a chance. And obviously, people felt that they were getting ripped off as the prices went up. But we live in a capitalist society where if things are dear, then the sellers are going to try to maximize how much they can get for it. And then it's even trickier than that because then if you plumb into that or drill down deep, they'll say, well, the manufacturer is the one that's jacking up the price to us. We can barely even get it. My concern is this, and again, I had the good fortune to serve with our current Attorney General and was co-chair with him 2017, 2018 when the Senate was tied. We had two Senate chairs, and so I was a tri-chair with now Judge Doyle and our Attorney General. So I didn't want to grill him when he was asking for that authority, but I do have concerns. We have given the ability of the governor to declare an emergency and to sort of so that we as a government can get our arms around price gouging. But what do you think about now extending that authority to the Attorney General A? And I want to commend my ranking House member, Representative Tigliano, because this 60-day automatic unilateral extension, I have the utmost respect. I consider Attorney General Tong a friend. But anybody in that position having that kind of unilateral authority that's unchecked by anybody else, and yeah, there's a consultation requirement, but there's not a veto with the Department of Consumer Protection or the DECD. What do you think about that? Do you think we really need to give the Attorney General that kind of broad authority when it's sort of a tricky question as to whether anybody's gouging or not?
Well, I have a question before I answer. So yeah. So if the governor decided that there was some sort of price gouging involved, who would he pass that off to? Who would handle it?
See, I think the Attorney General has the ability now to bring an Unfair Trade Practice Act under CUTPA if they feel that there's a violation and that's violating public policy. I don't think that you need the declaration to have a successful lawsuit. And in fact, the Attorney General is bringing lawsuits all the time now and being very, very successful. He does a great job against people that are bad actors in the commercial field. So I don't think that you need this declaration authority, and I think it opens up sort of a Pandora's box a little bit. That's my answer, but I'm more interested in your answer to my question.
Okay. I don't really think it's a declaration that would be abused, if that's what you mean. I think that while lawsuits are certainly part of William Tong's toolkit, um, how do I put this exactly? Um, Court cases are already hard enough to win. And whatever can be done to strengthen anything with consumer protection, to keep these types of cases from being dismissed in court if that's where they have to go, um, especially with I believe CPFB, I think it's called, is no longer Consumer Finance Protection Bureau or something, the federal agency, um, since they're gone now. Um, I think it would just be, it would allow the Attorney General to do his job easier and consult with other people. So that's just my view on it. I don't think he should have an overarching, power to do everything, but it would just allow him to, it would make his job easier.
Yeah, so you don't think there should be any safeguards or checks and balances. You just trust the Attorney General. And I know Attorney General Tong. I trust him too, but I have to look at the broader picture. Thank you, Mr. Chair.
Thank you. Thank you, Evelise, for your time today. I really do. Oh, did you have a question? Oh, sorry. Thank you, Evelise. I appreciate your time today. Scott Langley, to be followed by Jennifer Walker.
Good afternoon. I'm Scott Langley, and I am co-founder of a national nonprofit organization called Death Penalty Action. We work against executions and the death penalty. I'm also a volunteer coordinator with Amnesty International USA, serving to do death penalty abolition work for the Northeast of the United States. I'm not here speaking on behalf of Amnesty International, but I had worked closely in the past in Connecticut with the Connecticut Network to abolish the death penalty and our other Amnesty partners here to eliminate the death penalty here in Connecticut in 2012. I'm here to speak in favor of SB 430, surrounding the death penalty here in relation to the businesses in Connecticut. I fortunately am not a person who has direct experience with the executions. You heard from Lisa Brown earlier, the mother of Christopher, who was executed by the Trump administration. But I have on countless times stood outside of prisons during the moments of executions, and I've been in the presence of mothers like Lisa in those traumatic moments of having had a loved one executed. Reverend Bill Breeden that you saw in the Zoom earlier, who spoke in favor of this bill also. I was outside of the prison in Terre Haute, Indiana, when he emerged from the prison after having witnessed the execution under the Trump administration, an execution which was committed through the drugs provided by Absolute Standards here in Connecticut. And he mentioned having some PTSD around that. And I was there to bear witness to that, to see him in that very visceral moment of coming out of a prison, having seen an execution. Normally in my work, I've been doing this work for 25 years. Normally I'm trying to tell people why the death penalty is wrong. And I know that's not why I'm here. I'm here as a part of death penalty action to put a face to the trauma that comes out of the death penalty, not to tell you that the death penalty is wrong, but to point out that Connecticut, in the way things have been going with executions at the federal level and the state level, Connecticut has been complicit in executions. And I'm here to bring that face to it, not my own face, but the face of Lisa Brown that we heard earlier, the face of Bill Breeden that you saw on the screen earlier. And then later today, you'll hear from Reverend Sharon Risher about her experience with the death penalty. And Connecticut is in a unique position to make sure that those executions are not happening while the state is complicit in that by allowing companies to profit off of executions. In addition to showing that there's a face to the death penalty, I brought this photo. This is another Connecticut-based company that is providing the respiratory masks for executions. There was an execution we heard from my colleague earlier, Bianca, that there have been 4 executions in Alabama utilizing this mask. There was one just last week in the state of Alabama. This is coming from a subsidiary company in Connecticut. So if we talk about putting a face on the death penalty, just imagine this mask strapped to a human being and what that means. And Connecticut has already said that we are a non-death penalty state, that the death penalty and executions will not happen here. And by allowing complicitly businesses to continue providing the medicines, the drugs, the apparatus to continue executions, masks like this will be strapped to prisoners and they'll be executed. We're going to see more mothers like Lisa leaving prisons, literally having watched the government take the life of their child. And Connecticut knows better. When Connecticut allows businesses to participate in that indirectly or directly, you're being complicit in the death penalty. And that's already been legislated on and decided here that Connecticut will not be complicit with the death penalty. And this bill is an extension of that effort to make sure the morality of the Connecticut law aligns with what has already been decided 13 years ago. And it's an important issue. Lisa flew all the way from Texas to be here, to have 3 minutes to tell that story of losing her son to the government using drugs from a Connecticut business. And I drove only 2 hours to be here, but it means so much for us to speak up at this level. And I think that we really owe it to Lisa to stop this from happening. Like, there is a way to stop, like, if those drugs hadn't been available, the government could not have executed her son. We owe it to her, to the memory of her son, to make sure it doesn't happen again. And when you're going to hear later from Reverend Risher, we owe it to her to do this because the Trump administration is back in power and they have the desire to continue executions. And Reverend Risher, that you'll hear from later, the family members that she had murdered, that prisoner is on federal death row and could be possibly executed by the drugs coming from states like Connecticut. And so I just want to also just quickly, the issue of from a business perspective of of companies being scared to be present in Connecticut from a manufacturing position. Just to reiterate, what's being provided from the companies in Connecticut are not affected if they're being used for anything other than death penalty. This only applies to the death penalty. Over 60 pharmaceutical companies have come out against the death penalty, and they realize they're not losing profit over not selling. We heard earlier that it's a very minor percentage of what these things are being used for in terms of execution. It is, from a business perspective, it's a minor thing. Absolute Standards has already agreed publicly to no longer continue selling the drugs, but we need a safety mechanism mechanism in the state so that it doesn't continue. And it is such a small fraction of the business model. Pfizer, who has connections here in Connecticut,
Mr. Langley,
already said they're against the death penalty as well.
Thank you. Just a quick reminder, broad reminder. We're gonna try to keep testimony to 3 minutes. I never want to interrupt someone who's in the middle of testimony, but if we can try to keep our testimony to 3 minutes and submit additional testimony in writing or allow for questions to continue, that's helpful for everyone. Just a broad instruction. So Mr. Langley, I have one I think general recognition here is like, I think the best argument on behalf of this isn't that Connecticut is complicit in this, because I don't think it's an accurate reflection of what either the definition of complicit means or the nature of our relationship with the business that may be selling this. But I think the best argument in favor of this is when we construct regulations or limits, or we place restrictions on an activity, we make something illegal in our state for sale, for production, for usage, we often at that same time say the manufacture or distribution of that product is also illegal. In this very specific case, it wasn't thought through that when we were banning the use of the death penalty in Connecticut, it wasn't thought through to continue that ban towards the manufacture or distribution of chemicals that are used in that purpose. Like, you know, we limit the production of cannabis to what our state regulations say the limits of THC in products should be, not what New York says the limits should be. Similarly, we do that with a variety of products. When we establish limits, we usually apply them to the distribution and manufacture them as well. And this would be a circumstance where that just was not done at the same time. And perhaps that's a way for us to revisit this conversation in that similar vein. I think that's probably the best argument legislatively that we've got if we're going to have a conversation. Because I think the other arguments aren't necessarily, for purposes of a state structure of legal merit, aren't as compelling as that one. I think that might be the vein where at least I would want to entertain this conversation down. So I think it makes it a little bit easier for us to understand what a state's role is in regulating the production of a product that one private business sells to another person. So I think that's probably the vein I want to go towards.
Certainly.
Senator Kissel.
Thank you very much. And I really appreciate those remarks made by our good chairman, Chairman Lamar. My question is this, and I know there's a philosophical divide. First of all, historically, Connecticut never voted to get rid of the death penalty. We voted a bill to get rid of the death penalty prospectively. When that bill came down the road, and it had to get through prospectively because we were still feeling the fallout from the Cheshire triple homicide that was so horrible, committed by Hayes and Komisarjevsky. And how he did it, I don't know, but the sole survivor, Dr. Pettit, ended up being a good state rep here for a number of years. I don't know if I could ever have picked up the pieces and done that. Given the fact that we passed a law prospectively, and one of my arguments in opposition to that was it formed the foundation to allow across the street the state Supreme Court to say they weren't going to enforce the one that we had on the books. Because even though it was prospective law change, they used it as a basis for the feeling of the public as a whole. And there was a legal theory behind that. One of the reasons why I thought it was not being completely honest regarding what we did as a legislature. The question I have, though, is you and previous speakers have mentioned specifically President Trump. And I know President Trump makes people feel strongly one way or another. But he won the overall popular vote in our nation this last cycle. He totally took the electoral college. Every single swing state in our nation went with President Trump. That's A. B, death penalty laws are not just federal, but they're also state. I had visited my grandparents in Florida, and it blew my mind that there was actually, they stopped the middle of the television during the day, like on a Tuesday, to say, we're conducting an execution, and they like showed it. And so my understanding is, right now, the death penalty is in full force and effect in a variety of states in our country, and it has nothing to do with who's president. So why do you keep referencing President Trump like he's in charge of having the death penalty go forward when it's also the law of the land in a variety of states in our nation, and that this bill proposal would apply to them as well? Wouldn't that be fair to say?
Well, I mentioned Trump specifically because from a federal level, and the drugs that came out of Connecticut were specifically used for federal executions. And Trump was the first president to use federal executions in a number of years, and in fact had carried out the death penalty more than the last 100 years. There was 13 executions during his presidency. So when we're talking about Trump, it's not to say that all the other presidents have been fine on it. Biden wasn't great on the death penalty. Like, no president has been great on the death penalty, but Trump is the only president that actually oversaw executions to continue or be carried out at the rate that they were, and it was from drugs from Connecticut.
Okay. And I have I have more correctional facilities in my district than any other state senator. And up in there used to be where we had death row. I toured death row. I saw the electric chair. And if we were going back in time 30 years and you want to stop an implement of the death penalty, you'd have to stop electricity. So now we're talking about a very narrow thing about chemicals. And is it your intention that this bill would only affect federal executions, or if these companies said, well, all right, you don't want us to use them on the federal side, but guess what? We've got a bunch of states on the state side. We can sell our products to them. Or is your argument that we don't want anything manufactured in Connecticut used in an execution, period, whether it's the federal system or another state like Florida, Texas, or any number of states that still have a death penalty on the books?
Yeah, I mean, the intention of the bill is it would apply to any execution in any capacity. So it could be federal or state level.
Great. And so as much as you may personally not like President Trump or others, I just want it pointed out that this is not just a federal issue, that the proponents of this bill are going to reach down into other states as well that may be governed by, Democratic legislatures and governors. Who the heck knows? But it's a policy issue. It's not driven by one person, whether you like them or not like them. It's driven by a policy issue. And I just think the discussion should be honest and addressed that way. Thank you, Mr. Chair.
Thank you, Senator. I do think there's some clarity that you did help provide and why the reference to Trump has been appropriate. I mean, it's been because of the nature and number of executions that took place in the prior administration, the fact that Biden like for the executions of a number of federal folks who were on the list. So I think there is a relationship to President Trump and the death penalty and the Connecticut company that was selling these products during that time. So I do understand that. I do think there is merit also to the consideration that this ban would go beyond just sale to federal usage of these drugs for purposes of carrying out a death penalty order. It would go to states as well. So I think we're getting some clarity on the probable scope and extent of the bill that'll be before us. And if we were to ban the production of this type of drug, it would have broader implications than just at the federal level. So I think,
just to clarify, it's not banning the production of it. It's pertaining to the use of the drugs,
right,
for specifically the death penalty.
Right. That is a good clarification as well. Thank you. Are there any questions from Mr. Langley? Seeing none. Thank you, Scott, for your time.
Thank you very much.
Jennifer Walker, to be followed by Annie Hornish, and then David Fay.
Good afternoon. Thank you for allowing me to testify today. My name is Jennifer Walker, and I am the owner of Muddy Paws Barkery. And I'm here today to express my strong support for HB 5112, which would ban the sale of dogs, cats, and rabbits in pet stores in Connecticut. This legislation is critical to shutting down the cruel pipeline from large-scale breeding operations, commonly known as puppy mills, to pet stores in our state. Connecticut has an opportunity to take a hard stand against this exploitative industry, following the lead of states like New York, which has already passed a similar ban, bringing these stores now to Connecticut. Puppy mills prioritize profit over animal welfare. These breeding facilities are notorious for the horrific conditions. Dogs are confined to tiny wire cages, denied proper veterinary care, and bred repeatedly until their bodies give out. They often suffer from malnutrition, untreated infections, genetic disorders, and extreme psychological distress. Many of these facilities are perfectly legal, despite the fact that the conditions would be considered abusive in any other setting. These animals are treated as commodities and not living beings deserving of care. I know firsthand the consequences of this broken system as I currently own a dog that was purchased from a Connecticut pet store by an elderly woman who was unaware that these dogs came from puppy mills. Like so many consumers, she assumed that a pet store was a trustworthy place to buy a healthy puppy. Unfortunately, that was not the case. My dog suffers from several medical issues directly linked to overbreeding, issues that my other rescue dogs do not. His health problems have required ongoing veterinary care and management, which has been both financially and emotionally challenging. No one should have to go through this simply because they wanted to bring a pet into their home. The consequences of these cruel practices extend beyond individual pet owners. Many consumers, after purchasing a sick or behaviorally challenged animal, find themselves unable to properly care for them. Too often, these dogs and cats end up surrendered to already overwhelmed shelters and rescues, or worse, abandoned. Connecticut's nonprofit rescues and shelters are already doing everything they can to save the lives of unwanted, abandoned, and neglected animals. They should not have to shoulder the burden of cleaning up after the commercial pet industry's irresponsibility. As a business owner, I can confidently say that profitability does not have to come at the cost of ethics. The argument that banning the retail sale of commercially bred dogs would harm small businesses is simply false. In fact, many pet stores and related businesses thrive by partnering with rescues, offering adoption events, and selling high-quality pet products and services. Supporting humane alternatives benefit both our community and the animals who desperately need us. Instead of enabling the mass breeding and sale of more animals, we should be working to support the responsible pet ownership, spaying and neutering, and adoption from reputable breeders and rescue organizations. Many pet stores across the country have already successfully transitioned to these humane business models. This industry does not need to rely on the cruel and exploitative sale of commercially bred dogs, and I urge this committee to pass HB 5112 to help make Connecticut a leader in humane pet policies.
Thank you, Ms. Walker, for your testimony today and for sticking with us this afternoon.
Thank you.
Representative Turco.
Thank you, Mr. Chairman. Good to see you today, Jennifer. Appreciate you being here in your testimony. So we heard today from Representative Amy Moore and Bella that there's thousands of actual pets coming into Connecticut from these breeding facilities since 2021, I believe she stated. And then we heard from the Connecticut Humane Society that the USDA licensed, but there's not regulations. And then we just heard briefly from the pet store organization that they believe that Connecticut laws that are in place do protect consumers when these pets come from these out-of-state, unregulated breeding facilities to the state. So I want to get your perspective. Are Connecticut consumers actually protected, under our current laws from the sale at the pet stores?
So it's my understanding from several of these that they have what you would consider a lemon law for cars for these puppies. So I recently heard from an owner of one of these stores that if a puppy were to get sick within 6 months, you could bring it back, and that's going to be the burden of his cost, is to take that dog back. So what? Like, it's beyond that sick puppy. It's how that puppy got here and what its parent had to go through to get it here. But your dog might not be sick in 6 months. Mine wasn't sick in 6 months. He's now 6 years old, and he's ill now, and he's been ill since then. So having a lemon law of 6 months to return your pet is really, to me, not a law that really is effective. If you go to a reputable breeder and you have an ill dog, or you come across a circumstance that you can no longer keep that dog, most reputable breeders will take that dog back and help you find a home for it. And I don't really know that just because the law is on the books that it's actually being enforced.
Thank you. So from what I'm understanding, there's definitely a problem when it comes to dogs. Can you speak to the part of the bill regarding cats and rabbits? Because I haven't heard much about that today.
So cats and rabbits also come from these type of facilities. I think dogs are, the biggest the biggest population out there with the puppy mills that has gotten the most attention. But it's the same thing with cats and rabbits, right? They come from these same type of facilities where they are just overbred over and over again, and used as a commodity so that these pet stores can make money off of them. When there's also hundreds of thousands of cats out there and bunnies to some extent that are also in need of homes and find their ways to rescues and places like the Humane Society as well.
So that's what I'm to ask you. If there was a ban on any of the sale from the pet stores, would people here in Connecticut have a difficult time becoming an owner of a dog, cat, or rabbit? For to add to their family.
Absolutely not. You go to any rescue. Most of our specific places are overrun. They don't have enough room for dogs or cats or rabbits. Fosters are, bearing the brunt of having more than one animal in their care at a time. And so it really becomes the job of these rescue organizations that are typically nonprofit to find homes for these animals. And you can get a purebred from a rescue. My daughter just had a purebred golden retriever that was a foster that bore 11 golden retriever purebred puppies. So the argument that you can only get a purebred from a puppy store because that's what you want is that specific breed is not necessarily true. A lot of rescues are finding purebreds now being dumped and in need of homes as well within a rescue.
I've heard and read through COVID, a lot of people either purchased dogs or adopted dogs that then, now they don't want any longer. They're not working at home and it's more difficult, or their costs have. I'm sure dog food and cat food with inflationary costs has become more expensive too, and maybe it's a burden, veterinarian bills, and a lot of these pets are now being found in our shelters and need homes. So it sounds like from what you're saying, there's plenty of, lovable animals out there to adopt without having to purchase, coming from a industrial breeding facility.
Yes, and rescues, they're typically the most loving because I think they know that they've been rescued and know what it was to have a bad life and now a loving family. So
Thank you very much. Thank you, Mr. Chairman.
Thank you. Thank you again for your time this afternoon.
thank you.
Annie Hornish, followed by David Fay.
Thank you. Honorable members of the General Law Committee, I'm Annie Hornish, Connecticut State Director for the Humane Society of the United States, and on behalf of our Connecticut supporters, I urge you to support HB 5112, which would ban the sale of dogs, cats, and rabbits in pet shops. This is due to the serious animal welfare and consumer protection issues posed by puppy mill retailers. Banning sale of dogs, cats, and rabbits is more important now than ever because New York's puppy mill pipeline law recently went into effect, stopping 60-plus pet shops from selling dogs, cats, and rabbits. While many New York pet shops transition to a new business model that doesn't rely on the sale of puppies, some are merely looking for new states to call home. At least 3 former New York puppy stores, all with terrible records, have already moved over to the border into Connecticut. So what are some of the major issues that this bill will address? First, puppy mills. Public records show that Connecticut puppy stores import puppies from awful Midwest puppy mills that no customer would knowingly support. In my written testimony, I've attached some recent research that we've done, and it contains photos of some of these commercial breeding facilities that supply Connecticut pet shops. Second, deception. Puppy stores tell customers what they want to hear to convince them to buy a puppy, often for thousands of dollars. Third, sick puppies. From the puppy mill to the transport to the in-store conditions, these poor, weeks-old puppies have the health deck stacked against them, and their new families often suffer a grave emotional and financial toll. Fourth, sick people. The American Medical Association and the Centers for Disease Control have warned people of an ongoing antibiotic-resistant infection outbreak from contact with pet shop puppies and sounded the alarm about reckless antibiotic use. Fifth and finally, predatory lending. Few can afford pet shop puppy outright, so stores push puppy loans through third-party lenders, which often just lead to more financial hardship. In closing, no pet shop needs to sell puppies to remain profitable. Indeed, the overwhelming majority of pet shops, including industry leaders PetSmart and Petco, utilize a humane business model and do not sell dogs, cats, or rabbits, but instead partner with local shelters and rescues in hosting adoption events. No resident needs to buy from a pet shop to find the pet of their choice. Responsible breeders never sell to pet shops. So please support pets and their families by supporting House Bill 5112. And thank you for considering this bill.
Thank you for your testimony, Ms. Hornish. I appreciate it. Senator Kissel.
Thank you, Mr. Chair. Annie, always great to see you. It's great to have a constituent come and testify. Obviously, this is Rep. Turco's bill, or I guess a lot of other folks are on board as well. And I look forward to studying all the materials. You know, in my heart of hearts, I'm coming at this, which, I have a soft spot for the old-timey pet stores. But maybe I'm just living in the past, and maybe their practices are substantially different than what I remember back in the day. I'm not aware of any old-fashioned pet stores in our neck of the woods anymore. We have the mega stores like the Petcos and stuff like that, but apparently they don't engage in this. So if all that remains are stores that are selling poor little creatures that have illnesses or are abused, then I think that we could do well in pursuing this bill. But I don't want to inadvertently knock out somebody who's actually doing the right thing. So I'll read your testimony, and if you're aware of any further data. I don't like the idea that it's being shut down in surrounding states and then they're looking at us as like easy pickings because we don't have any laws. I certainly, when you say they're jumping from New York to Connecticut, that's a concern. But I haven't seen it in our neck of the woods. Maybe you mean like the western part of the state, but I think a lot of interesting issues have been raised. And again, since you're a very vocal constituent, thank you for taking the time to come and testify. Thank you, Mr. Chair.
Thank you. And you're correct, Senator, they're not in our neck of the woods, not in the 7th District. Correct.
Thank you, Ms. Hornish, for your time today.
Thank you.
I have David Fay, to be followed by Sai Prakash. Good to see you, Mr. Fay.
Thank you. I was taught very early in my theatrical career to know your room and play your room. I have to tell you, this has been a tough room this morning. I'm here to talk about entertainment. So forgive me for.
I'm pretty easy. The rest of these guys, right? I don't know.
Well, I won't take a lot of your time. I'm here, in support of our Attorney General's efforts on the consumer protection side. And there are a number of bills that he's working on right now, and we have been in active conversations with him, very supportive of their work on trying to manage and control some of the abuses that continue to take place in the secondary ticket markets. I'm an old guy. We used to call them scalpers. Not allowed to do that anymore. So the secondary ticket market. And I could sit here all day and talk about the way the secondary markets work. But I'm going to focus on one thing because this has to do with the Bushnell. Oh, and I'm David Fay, the president and CEO of the Bushnell right across the street. So I spend my day trying to entertain people across the street while you guys do your thing here. But
what do you think I'm doing up here?
Entertaining? I don't know about that. But so the one thing that really, we're a 2,800 seat hall. We have a small 900 seater, and we have a couple of other facilities there. We also are actually working. We've taken over the management of the Warner Theater out in Torrington to help them out. They're a much smaller venue, and we've had a great time working with them over the last year and a half, 2 years. The problems that Taylor Swift and the Super Bowl have with the secondary ticket market is very different than what we have. What we have is abuses that take place because we have a lot of customers who are going to buy tickets on the internet. They use their phones, they use whatever, and they wind up on a site that is not the Bushnell site. And these sites do everything they can to not be the Bushnell, but still look like the Bushnell. I'm not going to say they are fraudulent or anything like that. It's just the game that gets played. We call it whack-a-mole, where I come from. So I'm just going to give you one example. We have a show coming up here in June that some of you may be, familiar with, Back to the Future. And there's a great new musical out that's touring the country. It's not until June. And I just asked our folks to just go Google and take some screenshots, and we'll submit this in our written testimony. So the screenshots come up that there are tickets available, but they're very scarce. So, you gotta hurry. And I consider that sort of creating a false sense of urgency, which under the consumer affairs laws would be fraudulent inducement. Again, I'm not an attorney, so I can't declare that. So a ticket that is right now for sale through the Bushnell for $39 with a $7 service fee and actually a public access or parking fee in there for a total of $46 is for sale. Urgent, got to get it now, only a few left, for $221. Now, I'm not going to sit here and tell you that most of our customers that go to that site and several others that are pricing it at about that same way, are buying those tickets. They do. We have it. When we do get closer to the date, about 43% of the tickets are sold right now. So 57% of the tickets available during that week in our house are absolutely for sale. So there is no great urgency at this moment. Come June, we'll see. I hope there's urgency because, that'd be a great thing. But at the end of the day, the biggest problem that we face in that is when the moms and dads and the kids and are saying, hey, I want to go see Back to the Future. Oh, okay. And they Google Back to the Future Hartford and they see it's $221 to get a balcony seat. They go, sorry, kids, we're not going. They close the book. They never think about it again. That kills our business. And not only does it kill our business, it really prevents a lot of folks who don't have that kind of money from even thinking about coming to the Bushnell. So these abuses, and as I said, we'll submit this to you in testimony. We can give you 20 other examples of different kinds of things. But it's a problem that we really have to deal with.
Thank you, Mr. Fay. I think this is illuminating for the committee, certainly for myself. So generally how it works is these companies would buy a fake URL, not even a fake URL. They would buy a URL so that and then pay to have it elevated on Google.
Exactly.
And essentially, so if I type in Bushnell, Back to the Future, Hartford, they actually appear above you in the listing.
Yes, definitely.
And then they would go to that site, they utilize it. Generally, it's not a fraud in that they're taking people's money and not giving them tickets.
Right.
What they're doing is they're telling someone this is the price to buy these tickets here at the Bushnell.
And they haven't bought the tickets.
They haven't bought the tickets yet. They take the money from the customer at $221, and then they turn around and buy the tickets from you from $39.
Exactly.
And that person never knew they were actually not buying from the
Right,
Bushnell.
Right. The brokers take zero risk in doing this. It's one thing if they're buying up a swath of tickets and then they're really, they got to sell them. If they don't, they're screwed.
Right.
That's not what's going on. And this is the thing that really pervades a majority of the theaters across the country, and certainly in the state of Connecticut. This is the problem we really face. I wish I could tell you it was every show sells out on the first day, and I really, have to struggle to beat the brokers to my own tickets. It's a serious problem in our industry. It has been for a long time. And the biggest problem is enforcement, because there are literally tens of thousands of brokers. Some of them are owned by the big platforms, but someone described it to me one day as saying this is some guy in the middle of Oklahoma living in his parents' basement who's just looking to cash in and make some more money. And they can set up at one of these sites very quickly using the large platforms. actually to sell the tickets. And the platforms get a piece, everybody else gets a piece. And it really is, it's really hurting the business in general. We read about Taylor Swift. You don't see about this, on the front page of the news. We appreciate the Attorney General taking this up too, very, very much.
Yeah, of course. I mean, I can see it, like, there's a potential, like, moving this forward 5 to 10 years. You'd think every small business in the country would be concerned that someone could set up a fake website, essentially pretending to be a retailer that you have a trusted relationship with, and then selling their products out from under them and buying them from them and selling out. Yeah, you could see it, the potential expansion of this practice to not just theaters and tickets, but to any consumer product.
If there was any kind of transparency, and you'll hear the brokers argue that, well, they're providing a service because not everybody can be at their computer at 9 a.m. on a Tuesday morning when the tickets go on sale, or not everybody has the time to blah, 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 blah. Great. If you are selling a service, tell me what the ticket costs and tell me what your service fee is. But they're saying their ticket on this, our ticket's $39, theirs is $166. Our fees are $7, theirs are $50 plus.
Ranking Member Rutigliano.
Thank you. The good chair asked a couple questions already. I really do appreciate you helping us over the past few years with some of the ticket, because I remember when we first got it started on this, the Bushnell came in, and you guys, I think, were in favor in all-in pricing, and I appreciate that because I thought it was important. But I have to admit that I go on looking for tickets for the Bushnell, and the first 2 or 3 are always. Sometimes even I get trapped that you have no. This is my question. Do you need the Attorney General for this? You have no legal recourse because most of them say Bushnell Theater dot whatever, not Bushnell. I think you're Bushnell.org, right?
We're Bushnell.org, right?
Right. And this, most of the time for me anyway, it's 3 down. The websites are near identical. And I get trapped every now and again where I have to say, well, this doesn't make any sense. Do you have any recourse at all at the fact that they're using the Bushnell name in any of those URLs?
Do I have recourse? Yes. I could sue them.
I mean, you can't go to
But
Google
who
or
am I
whoever it is
doing
and say
is the
that this is a
problem.
fraudulent site. You could take it down. There's no recourse for you.
There's no recourse. And the reality is there is recourse, and it's all about enforcement. What we have done is if a customer comes to us and they've actually been duped and they go, geez, those tickets were so expensive, and I hear about it, I say, find out who the customers, come on in. And now this usually happens the night of the show.
Right.
When someone walks in and they're coming up to the window and they have a question about something, and we find out they paid $500 or whatever for a $29 ticket. We tell them we will cancel the order with the broker because we can trace it to where it actually was purchased. We don't know this person is walking in because that's another sale, but they will then have to go to their credit card company. And they'll have to pay twice. We say, we'll sell you the tickets for the original price, but you'll have to get your money back from your credit card company. What we need is the ability to work with those customers and then be sure they're going to get their money back from the credit card company when this kind of fraudulent activity has been taking place. And we then have been challenged by some of the brokers who say, well, no, that was those 16 tickets that I bought are from my family there. And I go, oh, okay. We canceled our order and we say, have them call us. We'll hold these tickets aside, have them give us a call. Well, no, I'm not going to. And I go, well, then we're canceling your order. They don't sue us. They just go, okay, we don't mess with a Bushnell. And that one broker says, I'll forget about them. And they move on. There's plenty of other fish in the sea.
Well, that's very nice that you've done that for some people because it is a serious problem. And really, you said what I would agree with the most is it does prevent people from enjoying the theater because they think it's cost prohibitive before they even made the purchase. So in the bill specifically, what mechanism is the Attorney General going to have that you don't have currently? He's going to sue the broker. He'll have the ability to sue them directly.
Well, yes. And right now there's you have to go through the consumer protection laws to begin to bring a suit that is about fraudulent inducement. Then you're going to have to define what fraudulent inducement is in this industry. And we're going to have to sue them. You know, so if consumer protection can create a transparency, if it were possible to say, you're going to do your secondary ticketing, you have to tell that tickets are available and here's what they are costing. If you want our service, here's what our fee is going to be. If something like that were put into law, it would change this abuse. It wouldn't change it for Taylor Swift, because those tickets are gone like that. But in our world, what really is damaging is this.
Thank you, Mr. Chairman.
Representative Yacarino.
Thank you, Mr. Chair, and thank you, Dave, for testifying.
Yeah. This happened to me in New York City at the Radio City Music Hall, where I bought tickets for me and my wife a few years ago, and I got there, and I actually couldn't get in at first. Somehow, I did overpay, not to the extent you're talking about, but I did overpay. But they didn't transfer the tickets.
Yes.
And I had luckily I could navigate at the ticket window. The gentleman at the window was really helpful, and the show was starting in like 20 minutes. And I learned a valuable lesson there. But what I would suggest potentially in this piece of potential legislation is you're going to have brokers, people sell, just have a cap. Legally you could sell, but not more than 10% over, 15% over. And then they have to disclose who they are. I mean, I think about it. You have to, if I'm going to advertise, I have to give full disclosure. So I'm a Dave LLC ticket broker. And so that's transparency for everybody. To have the Attorney General, he might want to sue, but it's going to be a long process. And I think that there's a way to, unfortunately, there's going to always be people selling tickets like they're not supposed to sell tickets.
Yeah, I think ultimately we have to protect our patrons. The theaters have to do it. We're the ones who are going to have to bring the actions. We have to know, though, I will tell you the way that would end it tomorrow. And that is, if we had the right to put up on our website, and we've done this, we haven't followed through all the way on it yet, that if you are a broker, that you are not allowed to buy from our website. And actually, in this state, we're under 3,000 seats. We're allowed to do that. Okay, anybody over 3,000 isn't. But we could say, if you're a broker and you're buying this with the intent to resell, we have the right to cancel your order and keep the money.
This is sort of to my point where
Now, if
maybe
we
not
had that right,
but full disclosure.
there's
no disclosure.
Yes, full disclosure.
It's got to be full disclosure.
The thing is, people go, yeah, but you can't tell the intent. I say, yes, we can. First of all, our system's after the fact. I mean, we can't do it while it's going on, but after the fact, we can trace, and we can understand, we can find out. And when we do, the minute we start actually canceling orders and keeping the broker's money, they will stop. They will just go, okay, forget the Bushnell, we're moving on. So it's that kind of weapon that we need, then we can police it. Because they won't sue us. They'll lick their wounds for $500 and move on.
Agreed. Thank you, Mr. Chair. That's you got us all thinking up here now. Good. Any other questions? Seeing none, thank you again for your testimony.
Thank you
here
very
today.
much.
We appreciate it. Sai Prakash online, followed by Chris Herb.
Good afternoon. Am I audible?
We can hear you, yes.
Oh, awesome. Great. Good afternoon. Thank you for allowing me to testify here today. My name is Sai Prakash, and I've had the privilege of working with Safari Stance Pet Center for about 2 years. I strongly oppose the proposed legislation, HB 5112, that would allow the ban of sale of dogs and cats and rabbits in pet stores. I strongly feel that this bill would harm both animals and families by reducing access to ethically sourced pets while pushing consumers towards unregulated breeders and organizations with little oversight. Customers deserve the right to choose where they get their pets from. As a very specific example, let's say a family may have a need for a dog who is hypoallergenic, under a certain size, or a pet that has been properly socialized. Um, Regulated pet stores provide that choice, offering transparency, health guarantees, responsible sourcing. Removing this option forces families to take those risks with unverified breeders or rescues that may not provide the same level of care or accountability. At Safari Stance, we are committed to the highest standards of animal welfare. Once in our care, our animals receive weekly veterinary checkups, kept up to date on their shots. We spend a major portion of our day training, socializing, and caring for them. When they do go home, they all go home with multiple warranties, one of them longest up to 3 years long, providing transparency and accountability, unlike many unregulated sellers who offer no recourse for the pet owners. Connecticut already has some of the strongest pet store regulations in this country. This bill would eliminate a well regulated, ethical option and drive consumers towards riskier alternatives. I urge you to oppose this legislation. Pet stores like Safari Sense provide a safe, responsible path to pet ownership, ensuring that animals are treated humanely and placed in loving homes. Um, Let us support strong regulations and not remove them to protect both animals and man. Thank you for your time and consideration.
Thank you very much. Are there any questions? Hearing none. Thank you so much for your testimony and taking the time to speak to us today. Next,
Thank you.
Mr. Erb from the Energy Marketing Association.
Good afternoon. My name is Chris Herb. I'm the president of the Connecticut Energy Marketers Association. Our members are energy marketers engaged in the sale of heating fuels and motor fuels. Our motor fuels members own, operate, and distribute fuel to over 1,000 convenience stores in our state. We are here today in opposition to the Attorney General's House Bill 6856, which has been referred to as the gouging bill. A decade and a half ago, we worked with the Office of the Attorney General and the members of the General Assembly, specifically the chairs and vice chairs of this committee, on gouging legislation that actually protects consumers and provides guidance to local family-owned businesses about what gouging is. Since then, Public Act 10-176 has allowed the Attorney General to protect consumers. Prior to the change that were made at that time, gasoline retailers in particular were in the dark as to if and when they are gouging. Connecticut law provided no guidance to the industry or to law enforcement officials as to when gouging occurs. Fortunately, that is no longer the case. We are concerned that House Bill 6856 takes a step backwards, a big step backwards, in adding undefined language to the statutes like unconscionably excessive prices and grossly disproportionate pricing. These terms fail to provide local businesses with guidance on how to comply with the law. Passing a bill that does not define unconscionably excessive makes it impossible for businesses to understand how they can lawfully operate. This is unfair to consumers and businesses that serve them. In contrast, Public Act 10-176 provides the exact parameters in which fuel can be priced during a declared emergency. This type of guidance has effectively protected consumers for 15 years. HB 6856 takes the opposite approach by leaving it up to the eye of the beholder, or the Attorney General in this case, when gouging may have occurred. I travel from my home in Naugatuck to my office in Cromwell every day. I have to drive on Route 8, I-84, 691, and 91, and there is a clearly posted speed limit as I drive to work every day. If the rationale in HB 6856 was to apply to the speed limit, the speed that I could not exceed would be one that is unconscionably excessive, empowering the police to pull anyone over whenever they determined they were going too fast. Do not allow this ridiculous standard to make its way into the profiteering statutes. This bill also allows the Attorney General to acquire new powers by allowing him to declare an abnormal market disruption. While we respect the legal authority of the AG, we do not believe that their offices possess the expertise to determine if a market is abnormal. And even in consultation with the departments referenced in the bill, we still don't think that it comes close to the governor's ability or the President of the United States, who can also declare these emergencies, to have access to all of the information on when there is something that's actually abnormal. The current profiteering statutes rightfully places this power in the hands of the governor, who have vast resources available to them. Expansion of this power to the AG is unnecessary, overreaching, and should not be passed into law. Gouging consumers is unacceptable, and we support prosecuting businesses that take advantage of the public to the full extent of the law, but this proposal does not accomplish that. So we urge you to oppose 6856.
Thank you. Are there any questions? Okay, I do have a question, right? And so, given that, we heard the Attorney General's testimony and in past years talking about during COVID when, this is needed to allow them to go up, right, the food chain, because a lot of times, you went into a little a food mart or, a convenience store or grocery store and they were selling Purell for $20, but they had to buy it for a lot more. So given that the powers are needed, and I think we all would agree that that's necessary for him to be able to do that, or he or she, right? It's position, not the person. So would you then state, what would you think if it was exempted, if fuel is already covered, exempted issues that are already covered to allow for those powers where they don't have, where we know it's needed right now?
Yes, we would support if there was a declared emergency or abnormal market, that if the current statutes that were in place were the ones that were deferred for the products that are covered, which are petroleum products, that would be an acceptable to us. I would also say, looking up, there are a lot of obviously different, just in general, there are a lot of different agencies, whether it's the Federal Trade Commission, the United States Attorney General. There are people who have the power to look at that. Maybe staying in our lane and focusing on what's happening in Connecticut makes the most sense. But to answer your question specifically, we would be good to be exempted and push back into that public act that I referenced.
Okay, great. Thank you very much. Are there any further questions? Okay, hearing none. Thank you for your testimony. Next, Reverend Sharon Risher.
Greetings. Reverend Risher is my board chair. She had to attend a different obligation. She was here until 1 o'clock. Would it be okay if I read her statement?
Yes, please.
Super. Thank you. This is Reverend Risher, and she is currently attending a meeting of the survivors' families, the families of the Charleston church shooting that took place in 2015. And the killer, the shooter of that church, is on federal death row. As chair of the Board of Death Penalty Action, I wish to applaud you for taking up this important legislation. Death Penalty Action led the on-the-ground protests against 13 federal executions that were conducted by the federal government in 2020 and 2021 using drugs manufactured by a Connecticut company called Absolute Standards. Last year, in partnership with Worth Rises, we helped secure a promise from Absolute Standards that they will no longer seek to profit from the death penalty by manufacturing drugs for use in executions. Death Penalty Action opposes every execution, and we are grateful that Connecticut, a state that abolished the death penalty more than a decade ago, is taking steps to ensure corporate responsibility by making it illegal for people to profit from executions. Thank you. We also led a coalition of more than 400 organizations that urged President Biden to commute every federal and military death sentence under his authority. He did commute 37 of the 40 federal death sentences before leaving office. The legislation before you today is important because the Trump administration wants to drastically increase executions in this country, and in an indirect but important way, by passing this legislation, you will reaffirm that Connecticut will not support executions. Just in case anyone wants to dismiss this effort as some kind of coddling of criminals or uncaring for victim families, I want you to know that I understand the anguish of the families of the victims are feeling, because I am one of them. I would never tell anyone how to feel, but I must share the basics of my own story. Dylan Roof, a white supremacist, murdered my mother, 2 cousins, and 6 others in 2015 at Mother Emanuel AME Church in Charleston, South Carolina. For that, he was sentenced to death, and he remains today on the federal death row. I do not want him freed, but I also do not want him or anyone else to be executed by our government. Thank you for your attention today. Please pass Senate Bill 430. I'd be happy to entertain any questions.
Great. Thank you very much. Are there any questions? Thank you for your testimony and sharing that on behalf of Reverend Risher.
Thank you.
Okay, next, Leslie Anderson.
Good afternoon. Can you hear me?
Yes, we can. Please proceed.
Thank you. My name is Leslie Anderson, and I represent the Propane Gas Association of New England. We are an alternative energy trade association operating in the 6 New England states. And in Connecticut, we represent 67 propane companies, most of them small family businesses. I'm here today in opposition to House Bill 6856, the gouging bill, as it's being referred to. In our industry, we work very hard every day in a very competitive environment. We try to earn our customers' business, and if we do not price our energy competitively and meet the expectations of our customers, they will switch to another company. They have 67 to choose from in Connecticut. This bill adopts undefined language like unconscionably excessive and grossly disproportionate pricing, but it fails to provide local businesses with any guidance on how to comply with the law. How can anyone selling a fuel adhere to a law that fails to spell out what you shouldn't do when you're pricing your product? Our prices vary depending on how much you use. In general, the more you use, the lower the cost per gallon. Why is that? It's because we deliver our propane to our customers in a $250,000 delivery truck with a highly paid driver navigating in all kinds of weather. Then we pull a long hose up to 150 feet in length through snowbanks across icy surfaces to deliver our clean propane energy into our customers' tanks. Lots of factors affect the price per gallon. It includes the delivery, transportation costs. It includes whether you own your own tank or if you have one of our $1,000 tanks sitting there provided by our propane companies. It depends if you have a full service supplier that will come out 24/7 to start your unit back up, or if you're using a small cash company. We're very competitive, and our customers are free to choose the type of company size and level that they want that serves them best. We oppose this bill because it creates undefined language and uncertainty. Under the current law, the law is clear, and you heard my colleague Chris Herb speak of this 2 speakers prior. When the governor declares emergency today, there's a specific formula in the statute that tells fuel sellers what is considered gouging and allows them to price their fuel within the limit, protecting their consumers and the businesses they serve. Gouging is not acceptable, and any business that treats its customers that way should be prosecuted and can today to the full extent of the law. We endorse laws that are fair and clear, and they're ones that accomplish what they're designed to do, but this bill fails short of both of these standards. How can a consumer be protected if you can't understand what the standard would be considered to be for price gouging? So we believe the power to declare an emergency should remain in the hands of the governor and the existing law, which is clear and easy to follow, and the best way to protect our consumers from gouging. And we encourage you to exclude delivered fuels from this bill if you decide to move forward to address other issues of concern with gouging. I'm happy to answer any questions if you have them, and I thank you very much for your consideration today.
Great. Thank you very much. Are there any questions? Okay. Hearing none, thank you very much for your testimony. Next, Gary Noodleman. Is he online? Okay, I apologize. Yeah, back. I had someone else crossed out.
You know, I'm unmuted. How are you?
Yeah.
Sorry about that. Little bit of us lost.
Yeah, I apologize. Yes, Mr. Nguyen, please proceed, and then I'll go back to the order.
I want to thank everyone for having me here. My name is Gary Noodleman. I'm the owner of CT Breeder with locations in Norwalk and Newington. We oppose House Bill 5112, and I appreciate the opportunity to share my perspective on the proposed ban on pet stores selling puppies. We established our Norwalk store in 2016 after moving my family to Connecticut in 2015. Believing in the state's quality of life, we decided to expand here. Since 1984, we have been providing healthy puppies to our customers. The renovation of our Norwalk store location alone cost nearly $1 million. Equipping with the latest in ventilation, exercise areas, and other facilities to ensure that every animal would get enrichment and care. Before opening, we underwent rigorous inspections by the Connecticut Department of Agriculture to secure our business license. Our stores currently employ over 25 people, all local residents and animal enthusiasts who go above and beyond to care for our animals. We contribute to the state through sales tax and have been welcomed by a supportive, educated community in Connecticut. Our success and reputation as a trusted experts who provide happy and healthy puppies here has drawn customers not just from Connecticut, but also from neighboring states like New York, Rhode Island, Massachusetts, Vermont. In 2024, we revitalized an abandoned property in Berlin Turnpike in Newington for our second location, transforming it into a community asset that now employs local residents and generates additional tax revenues for the state and provides a safe space for families to come meet their potential pet. Like our first store, the location was subject to numerous inspections and adheres to the strict guidelines of Connecticut. Our puppies come from licensed, inspected breeders who exceed USDA standards, many of whom we worked with for over 3 decades. All breeder information is transparently available to our customers per state law. Did you know we also have a vet coming every week? The proposed change to our business model, suggesting sourcing from rescues, is impractical. There's no assurance rescues would even work with our small local business. And in many cases, nor is there any guarantee that a rescue or shelter that agreed to work with us would be able, that could supply the variety of dogs consumers want, like small non-shedding breeds, potentially driving customers to unregulated sources where they would lack protections. There would be no consumer protection through the state. Additionally, the animals that we would be required to provide space for would not come with some kind of records and information that many families are looking for when considering a pet. This is not a sustainable business model for small businesses. One only has to look to to California and New York that have similar bins in place, and over 95% of all stores selling puppies closed. Outside of large corporations and national chains, a bill like this would result in near total loss in revenue per store. This could lead to loss of state revenue from sales tax and would not guarantee the welfare of any animals or consumer satisfaction. Current laws are stringent, ensuring consumer protection, including covering medical bills for a puppy that does fall ill. There have been very few issues with consumer satisfaction in pet stores across the state. Additionally, claims about people moving to New York to start pet stores are unfounded. This claim is nothing more than the latest tactic being used to push this legislation, and this could be easily verified by checking licensing applications. What a statewide ban would do is to create an unregulated black market for animals by driving consumers to unscrupulous actors. This isn't a theory. We have seen it happen in California, a state that has had a ban since 2019. Rather than acting a ban, we welcome the opportunity together to strengthen existing regulations. We all want the same thing, to care for animals, to make sure the bad breeders are put out of business. Thank you for this opportunity to speak. I invite any of you to visit our stores to see our operation firsthand. If you have any questions, please feel free to contact me.
Okay, thank you. Are there any questions from the committee? Representative Turco.
I'm just trying to get you guys on.
Thank you, Mr. Chairman. Mr. Nullman, thank you for your testimony. One of the things that you said is contradictory to what we heard earlier from the Connecticut Humane Society, also located in Newington. So I just wanted to get your perspective.
I'm deaf and I'm reading this because I can't get you to grow and read your lips. So someone's going to help me.
He's saying some of the things that you're saying are in contradiction to what the Humane Society said in Newington.
Yes, I agree 100%. And I've heard some things and I've been taking notes, but I'm sure we don't have time now. Representative Turco, I'd love to have the time to spend with you in your Newington location.
Well, I'm going to ask the question on what I heard the contradiction about, if you're able to answer that now.
Can you answer it now?
Yes.
We could talk about it at a later time. So from my understanding and what you just stated was that you purchase the pets from USDA licensed and inspected facilities. But what we heard today from the executive director of the Connecticut Humane Society is that there's a licensure process from the USDA of these industrial breeder farms or whatever they're considered, facilities. But there is not a licensure. There's a licensure. There's not an inspection process by the USDA. You stated there was an inspection process. So can you clarify that?
Yes, as a matter of fact, James Bias saying there was no inspections. That's 100% not true. In order to get, first of all, if you're licensed, you have to be inspected. And then they have to be inspected a minimum of once a year, which you guys can check on the USDA website how often they're checked. If someone makes a complaint against them, the USDA has to go out. So there's 100% inspections and surprise inspections. They don't call and say, we'll be there soon. They just show up. And matter of fact, if you're not there when they show up, they give you something called an indirect violation. Now, that means if you're buying eggs, you're somewhere buying something and you're not there, you will get an indirect. If you have 2 indirects in the state of Connecticut, you cannot buy from that breeder. I mean, there's so many things that I've heard that are not true.
Well,
Right.
thank you. I appreciate you clarifying that. And this committee, because we're hearing contradictory testimony, will have to get to the bottom of what's accurate with these statements. But I appreciate you giving us your perspective. So we want to protect consumers from purchasing, pets that are coming from these out-of-state, large, breeding facilities. And we want to make sure that the animals that are being brought in are healthy and being treated in humane ways. And you've stated all the stuff that you do in your store to make sure the animals are cared for. But can you talk a little bit more about how you can ensure that the confidence of the animals that you purchase to bring into the state and then sell to the Connecticut consumers? What measures do you do? Have you gone to these actual sites in Missouri or Iowa personally? What do you do to make sure that the pets you bring into this state and resell are healthy, are coming from reputable places, so we can ensure we're protecting the Connecticut consumer? Thank you.
Reverend Turco, I'm 65 years old. I've done this since I'm about 18. I'm in business professionally 41 years. Prior to that, I was animal behaviorist working with government dogs, working with individuals forever. I've been literally trained probably over 30,000 dogs. So I could actually analyze a dog myself just by looking at them. Secondly, they're saying these large, massive breeding facilities. That isn't true. There probably are existing. I'm sure they do exist. And a lot of them are unlicensed. However, if these are filthy and this and all that, we can't buy from them because they've gotten violations, either indirects, directs, and we don't actually, when we buy, we make sure they don't have them for 8 years, or they can't have any violations for that. And the question of, have I been to them? Yes, I've been to them on several occasions, and I do get to meet them. They literally will come to Connecticut. We'll take them to Greenwich, or we'll take them to eat, and we show them things, our area, our neck of the woods. They want to see our stores. I'm sorry, my wife is interpreting things as I'm doing this. I can't read that. So yes, I've been to the places. No, we don't deal with these giant manufacturing facilities. I mean, we have one particular breeder that, we have our own breeders after doing this so many years, that she maybe breeds, I don't know, 6 or 8 breeds, which is not a lot when you live on a farm. They also do other things. They're inspected. We have cameras in there 24 hours a day. The breeders do. It's not what you're hearing. It's not this filthy thing. I've also heard they say that dogs never see the outside. In order to get a USDA license, you have to have unfettered access to the outside. That means the dogs can come and go as they please. Some of these facilities are gorgeous. They're through the Purdue did a study, which I would love for you guys to check out, which actually showed that a lot of pet store dogs, or I guess pet store dogs are better socialized by these particular Purdue sanctioned stores. I don't want to sanction because they're not sanctioned, but they follow their Purdue guidelines. There's just so many things that are wrong. And if you could check with your Department of Consumer Affairs, I saw the man there earlier, ask him how many complaints we have. I mean, just as an aggregate to the whole community in the state of Connecticut. Just isn't true. They're making us as a villain so that they can be a hero. And the dogs that they are rescuing aren't local. They're bringing them in from all other states. We see them at auctions. They're having people breed. They're advertising for puppies. It's not what you're thinking. It's $1 billion industry. I mean, HSUS, I think 1 penny goes for the dogs and 99 cents for the rest of their thing. Not to get on HSUS, I have my own problems. Sorry.
Thank you, Mr. Nolan. I know we're going to have a lot more people testify on this bill today, so they'll be able to respond to your testimony, and hopefully we can figure out a little bit more information about, the industry and how it's being regulated and how, our consumers are being protected. So thank you. Thank you, Mr. Chairman, allowing me the question.
Great. Thank you very much. Hearing no further questions. Next is it Kristen Reckel?
Yeah. Yep. Close enough. It's Kristen Rokel. Nice to meet you.
Rokel.
Thank
Okay.
you so much.
Thank you. Please proceed.
Okay, great. So good morning. My name is Kristen Rokel. I'm a resident of Greenwich and an advisory committee member at Lucky Dog Refuge in Stamford, Connecticut. I've been a dedicated rescue volunteer for many years at Lucky Dog and many other rescues across the country. I'm here today to testify in strong support of HB 5112, which would prohibit the retail sale of cats, dogs, and rabbits in Connecticut pet stores. After testifying for a similar bill last week, HB 6832, there was a ton of information being shared, and I'm actually really happy that I get to follow the testimony that just came, because I'd like to use my time today to put forward 4 myths that we keep hearing and provide you with indisputable facts, because these numbers and the research does not lie. People do. So myth 1, pet store puppies come from responsible, ethical breeders. Truth. It is proven that the pet store to puppy mill pipeline exists, and it's been documented by many humane organizations. Not only that, it has been used as the premise and the name of our neighboring state, New York, their legislation that banned the live sale of animals. Puppy mills are inhumane, profit-driven commercial dog breeding facilities that ignore animal welfare. Approximately 90% of pet store companion animals come from these puppy mills and factories. All of the statistics you're going to hear today have been cited in my testimony and come from reputable, peer-reviewed sources. Cutting off this puppy mill to pet store pipeline, which 90% of animals come through, would disrupt this unethical supply chain. And while there is still work to be done for these puppy mills, the pet store endgame is where we can focus here in Connecticut. According to the U.S. Humane Society, who some people seem to have trouble with, they say that ethical breeders maintain transparent records of both the parent and the puppy health. And they keep puppies with their parents until at least 8 weeks old. Just a little local example here in Connecticut. On Tresser Boulevard, Connecticut Puppies in Stamford has advertised puppies on site without their parents at 7 weeks of age. I'd like to share with you another example that busts this myth here in Connecticut. Ross is a dog that was surrendered to Lucky Dog Refuge. He was purchased from yet another pet store in Stamford, Smart Puppies. He was sold to his family with breeder paperwork, which seemed legit at the time. He was so sick that his family could not afford him. They surrendered him to Lucky Dog for medical care, life-saving medical care. After looking at that breeder paperwork, he was actually sourced from a terrible puppy mill that lands on the worst 100 list every year. Specifically, this puppy mill was in Oberlin, Ohio, named Creekside Kennels. So that's myth 1, right? Pet store puppies do not come from ethical breeders. To be an ethical breeder, you must vet the person in the home. Let's talk about myth 2. Pet stores sell to irresponsible and pet stores sell to responsible and prepared buyers. That's a myth. They actually are not required to vet their buyers in a uniform or diligent way, and they simply sell to people with a credit line. The individual who actually testified right before me, when I checked out their website, the second tab from the top actually is a link to a credit union. So if puppies are not able to be afforded in full by those buyers, are they really preparing for the lifetime cost of a puppy? Or are we capitalizing on cuteness?
Would you please summarize? Your 3 minutes have expired, and then we can go to questions.
Yeah, absolutely. In conclusion, what I'd love you to hear is that retail bans do cut off that puppy mill to pipeline supply chain, and we can help puppy stores or pet stores become profitable in other ways other than live animals.
Thank you very much. Are
Sure.
questions? Okay, Representative Turco.
Thank you, Mr. Chairman. So we heard, thank you so much for your testimony.
Yeah,
What we
yeah.
heard from the previous individual's testimony, which you heard and you're responding to,
Yeah.
is that what's the other word besides not calling them puppy mills, but the
A
industrial
facility,
breeder
an
facilities,
used
I think is what
facility,
the
yeah.
Connecticut Humane Society called them,
Yeah.
are ethical places, are licensed, are inspected. He's inspected them himself and feels
Mhm.
confident in the animals that are purchased there and then are being sold here in Connecticut. It sounds like you're saying something different than that, and I just wanted to get a little bit more of your perspective. Thank you.
Yeah, there's a ton of work and research that demonstrates this. The Animal Defense League is a legal group that actually has documented the puppy mill or facility, let's call it, to pet store pipeline. And it demonstrates that these puppy mills, as well as the USDA, PETA, many others, they've documented that these puppy mills actually have inhumane conditions for dogs. Many dogs living in small cages. When we reference access to the outside, actually many dogs permanently live outside. Dogs in these commercial breeders, is what they're often called, are not, they do not have enriching environments, and they are not valued for what they bring in terms of personality that way. They are valued for their reproductive organs and the amount or volume of litters. I'd encourage you to check out the Humane Society of the United States, the ASPCA, et cetera. I submitted all of that documentation of puppy mills, including, I think most interesting, the American Veterinary Society did a review of 10,000 puppy mills in the United States. And I think you'll find the findings shocking. Again, facts versus perspective.
Thank you. And are you aware if there is indeed an inspection process? And because we heard the Connecticut Humane Society say earlier that there was not, we just heard the previous testifier say that there is, and that these facilities are randomly checked and could be shut down if people complain.
Yeah.
That there's regulations. What's your thoughts on that?
Yeah, I'm not an expert on the laws of the USDA. However, what I will say in my deep research and the work I do with Lucky Dog, I have found multiple peer-reviewed references and multiple national organizations that have demonstrated and depicted those federal guidelines as very irregular and very unregulated and managed. It is very challenging to get to 10,000 puppy mills at a regular cadence, right? So you can imagine the work being done there is extensive and requires many hands-on visits. I do not know the exact legal requirements for inspection. However, like I said, many of these organizations have published deep inspections and exposés into these organizations.
Thank you. And this may not be your expertise either, but I wanted to see if you knew, based on the previous testimony, does Connecticut receive a lot of current complaints from individuals regarding dogs that they buy in pet stores?
100%. So I volunteer and I'm on the advisory committee at Lucky Dog in Stamford. I provided 2 examples, Smart Puppies being one of them. We have 2 dogs that were recently surrendered from there. One because their parent was unable to afford the care of the dog in the future. They were surrendered to Lucky Dog. And one because they were not able to afford the veterinary care. There's actually a statistic from a shelter organization. They source information from 7,000 rescues nationwide. And 60% of dogs that were relinquished last year in 2024 were relinquished by their owners and purchased in pet stores. I provided that documentation and that survey as well.
Thank you very much for your response. Appreciate it.
Thank you. Are there further questions? Representative Yacarino.
Thank you, Mr. Chairman. I don't know where she went. Is she here? Okay. Kristen, thank you for testifying. I actually watch Lucky Dog. There's a TV show on Saturday mornings.
Oh, it's my favorite. One of my favorites. Yeah.
It's a pretty big corporation, though, Lucky Dog. Am I correct?
So Lucky Dog Refuge here in Stamford is a 501c3 that was started in 2020. Lucky Dog, the show you're referring to, happens to have the same name. And that seems to be, it's a CBS sponsored show, not related to us.
But they started first.
I believe, yes. And Lucky Dog Refuge has a different name. Lucky Dog from CBS is just a name of the show.
Thank you. I have a dog. It was my wife's dog. She got it on Facebook, actually.
Yeah.
Many years ago, the dog was given up by the owner, came from a breeder. I love Cody. We were just on the front page of the Hartford Business Financial paperwork a few weeks ago. So are there any regulations against buying a dog on Facebook? Because I don't think there's any regulations. We got our dog on Facebook. She did years ago.
Yeah, I don't believe there are, not my area of expertise, but I think one thing that people have talked a lot about today are ethical breeders or specific breed rescues. I have 2 dogs. One I got from a border collie rescue specifically because I was looking for that type of dog. And those organizations often do use Facebook as their main form of communication. Facebook, while many people would write it off as a older form of social media, the rescue network actually really exists on Facebook. And that's because it has a component that is for messaging, where rescues and rescuers can message each other about the status of animals. So on Facebook, I would imagine many rescues do have postings there. And I would also imagine some ethical breeders are using Facebook as a way to reach out to ethical owners or potential owners.
I think some ethical and unethical, I would guess.
Oh yeah, I mean, bad actors everywhere, right?
So that gets, I don't really have a dog in the fight in this. I love my dog, but the fact is, I think Connecticut businesses have to follow regulations. And I think you could buy a dog or get a dog for free on Facebook. You could get it from just an ad somewhere. I would look at the Department of Consumer Protection and see how many complaints there really are and go from there. And then we should actually have a safe environment for our pets. We all love our pets and we should love our pets. But I would think instead of us all talking, we should actually get the facts. And if there's a violation, there's a violation, you pay the penalty for that. But we got our dog with no regulations. I love Cody and he's a great dog. My point is, I think we need to really get the facts before we start throwing stones. Thank you.
Okay. Thank you very much. Are there any further questions? Hearing none, thank you for your testimony.
Thank you. Have a good one.
Thanks. You as well. Next is Alyssa Miller of the Pet Advocacy Network.
Hi, can folks hear me? I think it's not letting me turn my camera on. Thank you so much. I appreciate it. Thank you, members of the committee, for the opportunity to speak to you today regarding House Bill number 5112, a bill that would ban the sale of cats, dogs, and rabbits in retail pet stores. As a representative of the Pet Advocacy Network and a representative of the responsible pet care industry, we wanted to come to you today and register our opposition to this bill. I also, before going into the strict laws that Connecticut already has, want to quickly address the claim that the pet care industry does not introduce legislation to regulate or address existing problems. In fact, just a session ago in Pennsylvania, we worked directly with the legislature and other members of the responsible pet care community, including the shelter rescue community, to overhaul dog law and completely tighten and strengthen existing regulations, making it harder for these bad actors to be able to work with Pennsylvania pet stores, rescues, or shelters. Connecticut already has some of the strongest regulations in the country to protect both consumers and animals. In 2014, after a month-long task force that was chaired by Senator Bob Duff, the legislature enacted Public Act 1477, which was a comprehensive and sweeping regulation to govern pet stores. These regulations create a specific set of limitations on what breeders' pet stores could or could not work with, which really went to addressing the core problem that we're all talking about, which is getting these bad actors, these bad breeders, out of business. Pet stores are not allowed to work with any breeder or any other entity, regardless of what state they're based in, who do not possess a current USDA and current state license, or have committed, 1, a direct violation of a USDA pet dealer regulation, or 2, 3 or more USDA indirect violations related to the health and welfare of an animal within a prior 2-year period. So if you were looking at a breeder and today, and in 2023, they had committed violations, you could not work with them. It also established the Pet Lemon Law, which is unique to pet stores. This law covers the reimbursement of veterinarian expenses and mandates that a pet store must reimburse a customer or for veterinarian expenses incurred after they take home a dog or cat. Within 20 days after the sale, if your dog becomes ill or dies of an illness that existed at the time of sale, or within 6 months after the sale, if your dog is diagnosed with a congenital defect that adversely affects its health. At the customer's option, the pet shop can either replace the animal if that's what they want, or refund the animal's purchase price. This kind of consumer protection is unique and only exists for pet stores, despite the fact that animals coming from a shelter or a rescue quite often get sick at that shelter or rescue. As a former volunteer at the Arizona Humane Society, something I loved doing, I am all too aware how often animals do get sick in shelters and how often, unfortunately, animals can be diagnosed with congenital disorders after they get brought home to no fault of the shelter or whomever was providing them. But there was no recourse for those adopters to be able to get any kind of financial help in paying for those vet bills. Rather than enacting a bill like this, we would recommend building on current regulations to strengthen sourcing restrictions while also creating regulations that could guard against illegal importers and
Could you
further.
please summarize? Your 3-minute warning had sounded.
Yes, thank you. Essentially, what we want to do is strengthen the regulations, and we want to make sure that Connecticut doesn't enact a ban that could potentially create an unregulated black market for animals that leave animals and consumers at high risk, similar to what we've seen in California, who now in this legislative session is having to take further action to try and undo some of the damage that has happened because of the ban they put in place in 2019.
Great. Thank you very much. Are there any questions? Okay, hearing none. Thank you for your testimony. Next, Matthew Wells.
Thank you, Chairman Maroney, committee members, for organizing the hearing today on SB 430. My name is Matt Wells. I am Deputy Director of the nonprofit Reprieve, and I'm here in support of the bill. I'm going to focus on 3 issues related to drugs used in executions and on why this bill's passage would protect public health and safety and keep Connecticut out of an illicit, inhumane business. First, this bill aligns Connecticut law with the clear, long-standing industry standard. As Bianca said in her testimony earlier today, and key to the discussion here, every FDA-approved manufacturer of the drugs sought for executions opposes their use for this purpose and has put in place controls to prevent it. Pfizer, Lilly, Johnson & Johnson. Professional associations of doctors, nurses, and pharmacists have all likewise said their members should not be involved in executions. It's fitting that leadership for this bill comes from a physician, Senator Anwar, together with Senator Marr and Representative Elliott. SB 430 reflects the unambiguous position of the healthcare industry. It reflects the position of pharmaceutical manufacturers. That brings me to my second point. There is no legitimate market for lethal injection drugs. The trade and use of lethal injection drugs happens underground, often violating manufacturers' controls, as well as state and federal drug safety laws. That's what this bill targets. Investigations into the supply of execution drugs have uncovered a litany of drug safety violations by those involved. Suppliers of execution drugs make illegal sales from back rooms in shopping malls and in parking lots in exchange for briefcases of cash. Passing this bill helps protect Connecticut from this black market activity and would have no impact on legitimate trade. Which brings me to my third and final point. Public health experts and drug regulators have made clear again and again that breaking drug distribution systems for executions endangers public health and safety. Multiple public health experts, including a former FDA commissioner, have warned that the supply of execution drugs opens unregulated channels, allowing dangerous drugs to circulate and harm patients. That puts the residents of Connecticut at risk. Our own research at Reprieve shows these illicit deals also increase the risks of prolonged and excruciating executions, and Black prisoners are disproportionately at risk of suffering a botched execution. The illicit market for execution drugs, for what are primarily controlled substances, is dangerous for prisoners, it's dangerous for the wider public, and it goes against the healthcare industry's position, violating manufacturers and distributors' controls. The supply of drugs for executions is a fraught, unregulated business. This bill would rightly ensure that Connecticut is not in that business. It would help ensure Connecticut companies respect drug distribution controls and supply chains, as well as drug safety laws. I hope SB 430 will have your support.
Nice timing.
Thanks.
Are there any questions? Yeah, well rehearsed. So, are there any questions? No. Thank you very much for your testimony. Next, Chris Cardy.
Hello.
Hi, Mr. Cardy. Please proceed.
Hi there. Hello, members of the committee. My name is Chris Cardy, and I'm the owner of the Doghouse Pet Shop in Manchester, Connecticut. I appreciate the opportunity to address you today regarding House Bill 5112. The Doghouse is a family-owned business, and we have served our community for 25 years. Over the years, we have helped tens of thousands of families find their perfect pet. We employ a staff of 16 people who are all animal lovers and go above and beyond what is required by the state to provide the proper care each pet deserves. As you may be aware, Connecticut pet shops are currently regulated by the Connecticut Department of Agriculture. In 2013, a task force organized by the Environmental Committee thoroughly researched and ultimately implemented our current animal care regulations governing the sale of cats and dogs. These regulations ensure uniform standards of care across all pet shops in Connecticut, making our state one of the most highly regulated in the country. As a result, pet shops not only provide animals with exceptional care while ensuring that consumers are protected, but are also the only source for pets with such regulations in the entire state. At the Doghouse, we strictly adhere to these regulations. Our inspection reports conducted by animal control officers demonstrate our commitment to compliance and excellence in animal care. We work exclusively with USDA licensed breeders, and we carefully monitor their inspection reports. I would like to clarify that yes, they are inspected at least once a year. We monitor those reports very closely to make sure we're sourcing from responsible breeders. Our puppies receive weekly veterinary exams, all the necessary vaccinations, a high-end food, and are cared for by our experienced staff. In cases where a pet requires extra attention, our caring staff members will even take them home. We go above and beyond what the state requirements us to do to ensure our customers are treated fairly and that our pets receive the highest level of care. Many of our customers return for their second, third, and fourth dog because of their positive experience with us. They trust our expertise in matching them with the perfect pet and appreciate our commitment to both their needs and well-being of their new companion. I actually have a unique perspective on pets from pet stores and pets from shelters and rescues. In 2018, I founded a dog and cat rescue. The rescue works with high kill shelters and other rescues from such states as Virginia, Tennessee, and North Carolina. I have personally volunteered at a shelter in Virginia and witnessed firsthand the challenging conditions many of these animals come from. A common argument against pet stores is that our puppies are typically sick or not well cared for, but this is far from the truth. Pet store puppies receive proper vaccinations, undergo routine veterinary exams, and are provided veterinary care from the time they are born until they find their forever home. Additionally, pet store customers benefit from health warranties that protect both the pet and the family. Shelter and rescue pets, unfortunately, are not required to receive the same standard of care. Shelter pets typically have no medical history, and many, many will have both
Could you
health
please
and
summarize
behavioral
your-
issues. Sure.
The 3-minute warning just went off.
Okay, I'm sorry. Yes. So a lot of the shelter pets will typically have health and behavioral issues, and unfortunately, we see these animals return to the very same shelter that they were adopted from. As the owner of a pet store, my association with the rescue began to have a negative effect on the rescue. So I literally turned the operation over to one of my staff. So that begs the question: if my mere association as the owner of a pet store with the rescue that I founded had a negative effect on the rescue, what assurances are there that the rescue would even work with a store as this bill proposes? I sincerely appreciate your time and consideration on this bill 5112, and respectfully urge you to vote no. Thank you.
Yeah, thank you for your testimony. Are there any questions? Hearing none, thank you for taking time to testify to us today.
Thank you.
Next, Jennifer Sullivan.
Red light?
Yep, you have the red up.
Okay.
And then the other one too. There's,
this one as well?
yeah, both. Thank you. Please
Okay,
proceed.
Thank you. Hi, my name is Jennifer Sullivan, and I am here in support of the Bill 5112, which is to prevent the sale of dog, cats, and rabbits to puppy stores for profit. You've heard from a lot of my constituents. I'm not going to regurgitate a lot of what they said. Puppy mills, we know it's a known fact that the majority of dogs sold to dog stores come from puppy mills. I have several examples I'll talk to you about, but I wanted to first address and maybe clarify for you. There are pets sold in pet stores, and then you have what they kind of call your backyard breeder, who are just people doing it for hobby and maybe trying to make a few bucks. But then there are the purebreds, and if somebody wants a purebred dog, there's nothing wrong with that. They just need to find a reputable breeder, and you can do that by going to the AKC. They have them all regulated. When you adopt a dog, you should receive their lineage, who their parents are, so there's no inbreeding, their health records. You don't get that. You don't get the lineage. They call them champion dogs. They're not champions until they go through the whole process of becoming champions and becoming certified dogs. So I am an experienced dog owner, rescue volunteer, and I also actually did have a dog who was an AKC certified and showed and was from a really high standard breed. Again, they had to do a check at my house. They wanted to make sure my house was in proper condition. They went through my lifestyle, my family. They wanted to make sure that the dog was going to somebody who was going to keep and love that dog for the rest of their lives. So I'm going to share with you some examples. I have one friend who did online testimony. She purchased 2 Chihuahuas from a pet store in Southington. This was maybe 10 years ago. Both of them came home and both of them had ringworm. My friend went back to the store and they said they would reimburse, but they wanted the puppies back. And she did not want to give these sickly puppies back to them, not knowing what would happen. So after incurring, numerous costs, they're fine, but it was very expensive and they had to deal with the issue of the dogs being sick. Another example is actually my husband, Brian Sullivan, who wasn't here earlier that you were calling for. He's sick. I tried to cancel him, but prior to our relationship, he purchased 2 Papillons from a dog store in Wallingford. They both came home. They both had parvo. Very sick, thousands of dollars in medical bills. Of course, they kept them. Of course, they cared for them. Of course, they loved them, but it wasn't easy. I personally have an experience. I rescued one of my dogs from the Aetna, she's my employer, from the animal control pound in Hartford. And it came up online saying that he was up for adoption, the cutest, furriest little dog you would ever see. So I went to the pound to talk to the ACO. I'll just finish this last thing, then I'll stop. And I asked her, how is this dog here? And she said that people on impulse will go into stores, buy dogs. They want that instant satisfaction. They don't consider the type of breed, how it, builds into their family. And they end up kicking them to the curb. And that's how they found my Lenny, walking the streets, a little designer dog. And nobody claimed him. They've got to wait 2 weeks to see if somebody claims him. And then I was fortunately able to, but he was very sick, probably over $12,000 in medical expenses his entire life.
Thank you.
So again, just thank you for letting me testify for this bill.
Thank you for, let's see if there are any questions from the committee. Okay, hearing none. Thank you for your testimony. Okay, next, Barbara Batista.
Hello, I'm Sister Barbara Batista. I'm a Sister of Providence from St. Mary the Woods, Indiana. That's near Terre Haute. I'm a physician assistant and a pharmacist, and I am grateful for you allowing me to speak to you today. I am speaking in support of Senate Bill 430. I urge you to close this back door to to capital punishment in your state. I had the, I don't know whether to call it the privilege, the honor, the horror of companioning two men into the death chamber a few years ago. There is nothing quite to compare to capital punishment and the actual execution of a living, breathing person. I want to speak as a medical professional and as a chaplain. You've heard from other presenters today, there is this allowing the sale, the manufacture and the sale of medications, of chemicals really used to execute another person. There's nothing, the FDA does not approve it. No medical association allows for the participation of a healthcare professional, a nurse, a physician, a PA. None of our professional organizations support capital punishment. And yet it continues in 23 states in this country. You're really 27, but 4 have a moratorium. Anyway, I want to use my time well here. Connecticut does not allow capital punishment. You all know this. To my mind, this is a backdoor. The sale of a chemical, and I'm calling it a chemical, not a drug, because drugs generally are used to support health and well-being. This chemical is not used in that capacity. In fact, it's used to kill someone. This, the manufacture and sale of execution drugs is just another way to say we support capital punishment. And I know you don't support capital punishment, at least from a legal perspective. I also would like to clarify something I heard in an earlier presentation, that I think you know euthanasia is not allowed across the entire United States. Medical aid in dying is allowed in about 10 states, if I have the number accurately. However, this medication that's used for executions is not ever the same as what's used in medical aid in dying. Medical aid in dying requires the person themselves to administer the medication. They're not going to do an injection on themselves. This is a totally different process. Medical aid in dying is a voluntary process, not at all to be confused with executions. I would urge you to support Senate Bill 430. I also want to remind you that one of the early executive orders from our current president was entitled Restoring the Death Penalty and Protecting Public Safety. In it, in one of the sections, I believe it was section 4, mentions that the executive order is supporting the sale and distribution of drugs used for executions. I just urge you to not become the supporter, the state where that drug is manufactured, the place where other states go to get their get their drug, get their chemical to execute a person. One last statement I would like to say. I companion Keith Dwayne Nelson and William LaCroix.
Summarize your 3 minutes have expired, sister.
Thank you. I'm finished.
Okay, thank you. Are there any questions? Okay, hearing none. Thank you very much for taking the time to testify to us today.
Sure, thank you.
And next, Judy Michael.
Good afternoon, committee chairs and members of the committee. My name is Judy Meikle, and I'm grateful for this opportunity to testify today in support of Senate Bill 430, prohibiting the export of drugs and equipment from Connecticut for use in executions. I'm a member of the Religious Society of Friends, better known as Quakers. I live in New Haven, Connecticut, and I worship at the Quaker meeting in Wilton, Connecticut. And I've been engaged in prison ministry for 20 years in Connecticut, New York State, and Alabama. During that time, I've been an advocate for the abolition of the death penalty. My concerns regarding the death penalty are deeply rooted in a guiding truth of my faith, that there is that of God in all people. As such, I'm clear that each person is uniquely valuable and none is totally beyond redemption. I oppose the death penalty in all circumstances, and I'm so thankful that legislators in Connecticut had the fortitude to abolish capital punishment in our state in 2012. I understand why the climate at that time was for the legislative change to be prospective. The nature of reform is often incremental, and abolition is achieved in steps. I'm in communication with one of the people who was on death row in 2012. He's now in general population at a maximum security prison in Connecticut and engaged with college through Yale. It is through my lived experience with incarcerated people that I know redemption to be a reality. As a Connecticut resident, I'm deeply disturbed that the drugs used to kill 13 federal prisoners in 2020 and 2021 were manufactured by a Connecticut company, Absolute Standards. And as a Connecticut resident, I'm equally disturbed that the masks used to suffocate Alabama prisoners are made by a wholly owned subsidiary of Walter Surface Technologies, another Connecticut company. To date, 4 men have been killed by this cruel gas suffocation method. Most recently, Death Penalty Action held vigil for Demetrius Frazier as he was killed using nitrogen gas delivered by a product originating in Connecticut. We heard during this vigil about his transformation to a man who spoke of knowledge and preached change and mercy for others. We mourned his death with his family and friends. I believe that the death penalty degrades the humanity of the society that endorses the act. This includes corporate entities that profit from transactions with systems executing the death penalty. This is why I support SB 430, and I ask for your support of this bill. Thank you.
Great. Thank you very much, Ms. Meikle. Are there any questions from the committee? Okay, hearing none, thank you for taking the time to testify to us today.
Thank you.
Okay, next, Sheila Soterio. Okay. Okay, if you could please proceed. Oh, Sheila? Okay, do we want to promote the next person, and then maybe going forward we could just promote 2 at a time to make it a little. Yeah, I'm back on track. Sorry about that. Is Sheila Soterio?
Yes. Hello, can you hear me?
Yeah, we can hear you. Can you please proceed with your testimony?
Okay. Okay, yes, thank you. I'm sorry, I'm at home and my dog may bark a little bit. He's sitting outside my office. Good afternoon. First of all, thank you for allowing me to testify on this bill. My name is Sheila Soterio. Ask for bill HB 5112, which is being considered for our state to take away our choices as citizens in Connecticut. Why should this be other rights about puppy mills? The statement about sense. Not all USDA breeders have puppy mill puppies. So why everyone had the state of the Department of Stores, and we have a high set of standards that we have to adhere to. I personally am involved in every asset of the business, from cleaning kennels, bathing puppies, assisting clients with choosing their next fur baby, to bookkeeping. Also, before my husband and I opened the business, we took over a week to go visit with some of our breeders to make sure they did have high standards in their breeding. In our shop, we also offer a 3-year health warranty for congenital or hereditary issues, which actually goes beyond the state of Connecticut 6-month required law. We also, I've heard a lot about rehoming puppies, and if people don't want their puppies, then they give them up to shelters. We encourage our clients to not take care of the puppy to please get in touch with us, and we will actually help them rehome the puppy ourselves. I have done that several times. We're also constantly here.
I apologize. We cannot hear you. Okay. So I apologize. Hopefully you've submitted written testimony so we can review your written testimony. Okay. All right. We apologize for the technical difficulties. And when I'd say for other people who are online, if you're having trouble with your sound after initially introducing yourself, if you wanted to turn off your camera to reduce the what you're consuming on the bandwidth, that may assist us in hearing you more clearly. So next, Tara Fleming.
Hello.
Hi, Ms. Fleming. We can hear you. Please proceed.
Hi, my name is Tara Fleming, and I have been an owner-operator of multiple long-standing and reputable pet stores that carry live animals. We are a small family-owned business that prides itself on morally and ethically supplying the community with all types of pets. We are a trusted source of animals and expertise that families have been relying on for nearly 2 decades. Businesses like ours often rely on word of mouth and reputation and the standards we hold ourselves to. Connecticut has very strict animal sourcing laws, inspections, veterinary care, bookkeeping, and paperwork regulations in place, some of the strictest regulations in the country. Connecticut also enforces a consumer protection law that ensures the customer is covered for anything that may arise after the purchase. The number of incidences families are facing while obtaining pets outside of a retail store has significantly increased and has negative outcomes. A ban on pet stores would eliminate the safe space for families to meet their new pets and the experts that help match the right pet with the family based on their current situation. This is so important because it eliminates the likelihood of surrender. I work with great breeders that I've had relationships with for years who are all heavily regulated and inspected and have no violations. These breeders care about the health and well-being of their puppies and kittens. I receive follow-up calls from breeders after the puppies arrive to see if the pups are doing well. I like to interview my breeders before purchasing from them as well. With the years of experience I have, I can pick the best of the best. Eliminating pet stores negatively impacts the consumer in so many ways. Many people want to choose the right pet for themselves and want consumer protection that is enforced with Connecticut's strict laws. I've heard many stories from customers that have had experiences that led to heartbreak and financial burdens when trying to source a pet outside of a pet store without the protections that a pet store provides. The joy I have brought to countless families has been the most rewarding aspect of my job. I love what I do. I've been doing it for nearly 20 years. I have proven myself to the community by being upstanding and reputable. I follow all the laws and regulations, and my store is spotless. Our pets are happy and healthy, and I hire animal lovers that give their all, going above and beyond what is required by law to ensure the pets are properly cared for. I do not believe a ban that will shut down our small businesses is a benefit to the state of Connecticut's consumers. It will create a market for underground sales of animals from online sales, backyard breeders, retail rescues, all of which are not regulated and do not have consumer protection in place. My hope is to put a stop to the breeders out there that are unscrupulous and are not being inspected or following humane practices. Connecticut pet stores are not the source of that. I worry about pets, my family, my employees, and the community if this law is passed. I oppose 5112.
Great. Thank you very much for your testimony. Are there any questions from the committee? Okay, hearing none. Thank you again for taking the time to testify. Next,
Thank you.
Brianna January.
Good afternoon, Mr. Co-Chairs and esteemed committee members. Brianna January with Chamber of Progress in respectful opposition to HB 6857. Chamber of Progress is a tech industry coalition advocating for the progressive future of tech. Our members include Google and Amazon, but they do not have a vote or veto on our positions. Committee, one of our top priorities is making the internet safe for young people, and we share a lot of the concerns that you've heard today. However, we do believe that HB 6857 is not the appropriate approach and would disproportionately harm Connecticut's most vulnerable youth. We are particularly concerned that the bill could be weaponized by anti-LGBTQ guardians to prevent queer kids from accessing community resources and safe spaces online, for example, and these are often lifelines for these kids. Additionally, while well-intentioned, HB 6857 would, in practice, actually promote toxic posts over healthy content, having the direct opposite effect of what the bill intends to do. Committee, algorithms play a critical role in promoting safe and healthy content. Content curation allows platforms to downrank or even remove unwanted and targeted interactions like coordinated racial or gender-based harassment. Requiring chronological feeds over curated ones risks exposing Connecticut's kids to greater harassment and cyberbullying. Committee, if you may, imagine, for example, an LGBTQ kid in your district spends the entire day being bullied at school, unfortunately. They come home, they get on social media looking for community, and instead of being served curated content based on their interests, they see several classmates posting targeted harassing content one after one, simply because they're forced into a chronological feed instead of a curated one. That would be the reality under HB 6857. I'll also caution that other states have enacted such laws have had them challenged and or stricken in courts, including California, Texas, and Maryland in just the last 2 weeks. As such, we respectfully ask that you oppose this bill at this time. Additionally, I'd also like to suggest 2 short amendments to HB 6858, and I also have included these in written testimony for the committee. This is the ticketing bill. First, the bill uses the term address, which can be ambiguous for industry interpretation. This could lead to interpretations encompassing the entire URL, including subdirectories and pathways, rather than the domain alone. So we suggest simply amending address to domain. And second, the bill's requirements for resellers to disclose the face value price of tickets when the primary seller initially sold them really presents considerable challenges, especially for smaller resellers that do not have the resources to track sale prices for various events, especially when things move so quickly. By nature, that would force smaller resellers out of the Connecticut market because they do not have the resources to comply, and instead the bigger resellers would basically own the whole Connecticut market. We understand that that's definitely not the committee or the Attorney General's intent, so we encourage you to simply remove that requirement from the bill. Thank you for your time, and we look forward to working with the committee on these 2 important bills.
Great. Thank you. Are there any questions? Okay, I have some questions. You mentioned, some of your members, and you said they don't have a vote or a veto on your positions. How are your positions formulated?
Thank you so much for asking that, Senator. That's correct. We are a tech industry coalition, but unlike pretty much every other industry associations, our members do not have votes or vetoes. We're actually a center-left organization, and our staff lead our positions based on our center-left values.
Thank you. Now, you mentioned the lawsuits on the other states. One of the things that seems to be consistent across the rulings is that age verification is being found to have a restraint on speech or to be unconstitutional. I'm just trying to think of, we know, obviously we all have a common goal of protecting children, right? And protecting them online. Through the algorithms, I've heard that it can be determined, maybe not right away, but as you interact on a social media site, an adult interacts with their social media very differently than a child does or a teenager. And I'm just wondering of, instead of requiring the upfront verification, if we could go the other route and go with ongoing assessment, and when it's determined that it is a child or likely to not be an adult, there could be additional, then go to either the parental permission or some other route. Just like to get your thoughts.
Thanks, Senator. That's an interesting concept. I will note that on age verification in general, there are very few companies that actually provide the services. We're talking like 3 or 4 nationally, and those that do have really, really bad track records when it comes to cybersecurity. We're talking about private personal data, whether you're requiring someone to upload a picture of an ID or some other way to verify their age. So I do caution the committee in general around age verification. I'd like to suggest that at Chamber of Progress, what we really support to approach the issue are 2 things. One, tackling it at the root, which is by simply increasing resources and programs for youth mental health, whether we're talking about in our schools, in our families, in our communities. That is an easy way to get at the issue and crisis that we're seeing in teenagers in particular around mental health. And secondly, a personal suggestion of mine, I very strongly feel that social media and digital literacy should really be the next step in our K through 12 public education civics curriculums. It's here to stay. Our kids need to know how to be safe online. Adding social media and digital literacy and ways to stay safe into K through 12 public education, I think will be key for the next generation going forward. And there's already tools and resources that exist to do just that. And I'd be happy to connect the committee with existing resources if that's helpful.
Great, thank you. I think agreed digital literacy is key for not just children, but the entire population.
Absolutely.
I guess one point of not disagreement. I mean, in an era of constrained resources, asking the government to put up resources for a problem that potentially was caused by the private businesses doesn't, it seems like there should be a shared responsibility there. That would be my pushback. The other is, I'm just thinking through, right now, we don't require the age verification. Our children's privacy laws in Connecticut, it's actual knowledge or willfully disregards. And I'm wondering if we go through, if you aren't performing those ongoing assessments, you'd be deemed to willfully disregard that someone is under the age of 18. So that's another thought that I'll be just putting that out there as I'm thinking out loud. But thank you very much for taking the time to testify. Okay, next, in person, Bruce Morris.
Thank you, Mr. Chairman from both chambers and ranking members and members of the committee. Glad to see everyone, and thank you for this opportunity to come and testify in support of HB 6858. We've submitted written testimony. That testimony will be amended because we noted after the fact there's a section 12 that had to do with all-in pricing, which obviously we support to the hilt. But we're prepared to have former Representative Stallworth provide oral testimony, and I'll answer whatever questions that you may have. If we can do that, expediting your time.
Thank you. Yeah, we got a twofer. Former representatives, please proceed.
Depends on what you mean by miss. Feels like freedom and longevity on this side of the table. Of course, as Bruce has said, my name is Charlie Stallworth, and I'm here on behalf of Ticket Network, a leading ticket resale marketplace based here in Connecticut. We support safe marketplace transactions for consumers looking to attend live events across the globe. In this role, we connect buyers and sellers of tickets to sporting events, concerts, theater shows, and other events, both here in Connecticut and residents in this nutmeg state. Section 1 of this legislation is something that Ticket Network supports without hesitation. Better disclosure that help consumers understand the nature of their purchase is a win for buyers and sellers regardless of location. Section 2 uh, should be modified slightly, limiting the restriction of the use of outline terminology to website's domain rather than the entire website address. Such a modification would bring this language in line with the Ticket Act recently passed out of the committee in the United States Senate. As written, Section 2 could be interpreted to make illegal the standard best practice of including important search keywords in the entire website address. This would have a significant consequence for search engines and the visibility of the marketplace. Also, some concern about Section 12 that requires to state the face value when the ticket was initially sold. Connecticut is already a nationwide leader in the consumer ticket buying experience. The proposed new language, including our suggested modification of HB 6858, will continue to ensure our status as such. We look forward to our continued work with members of this committee, the AG, and all other lawmakers to ensure transparent and competitive ticket landscape. Thank you for your time.
Great. Thank you. Are there any questions? Senator Kissel and then Representative Vitigliano.
Thank you, Chairman, Mr. Chairman. Gentlemen, it's great to see both of you again. And yeah, were you in the room when the gentleman from the Bushnell testified?
Yes.
All right. So I think the gist of his thing was the people that are sort of gaming the system don't have skin in the game because they're going to make their sale at an exorbitant price and then turn around and make their purchase at the regular price from whomever the vendor is. In his instance, it was like $46 versus $200, give or take, for something that's coming up at the Bushnell. And I thought it was terrific in your testimony that you really drilled down deep into the language and some things you like, some things need fixing. But what's your feel as to how to what should we really try to do to try to address his problem? Because above and beyond who's making dough and which way, I definitely thought it was unfortunate for all the venues if people go online and for whatever reason they think everything's super expensive and they get discouraged and they just throw up their hands and say, kids, we can't go and we'll have to do something else.
So we were here and the gentleman addressed a few things that the bill actually addresses, or the bill doesn't address, the Federal Ticket Act does. So let me break them out for you if I can. The language that's in the current bill involving speculative ticketing and the way that is written has a lot to do with disclosure, because that's what you're talking about. Someone's selling you a ticket that they do not have in hand yet. The language in the bill handles that. That must be disclosed. I mean, the language is very extensive in terms of making certain that a purchaser knows that you don't have it. You're providing a service similar to Instacart or something else, and you must break it up. In fact, the federal act that was just passed out of a Senate committee and is likely to become law because it was a bipartisan bill, and you'll be ahead of the curve by getting this done. It makes certain that that service that you're providing is not the ticket fee, and that is fully disclosed. So one of the things the gentleman was talking about, and you're going to come back and you're going to pay and get it later, there's a certain clientele that uses that service, and it's based on different levels of entertainment. The gentleman who's here is in a facility that's 3,500 seats or less. Current Connecticut law exempts facilities such as his from the majority of the ticket law that we passed in 2017. So he has an awful lot of control, whatever he can do with restrictive tickets if he were to choose to do so. But again, the point he was bringing up is there's a service that someone is providing for a ticket that they don't. There's usually a clientele that does that. That isn't someone's children not being allowed to attend. It's people that maybe in a larger event like a Taylor Swift event, when they find that they're getting locked out of that event because if you try to get tickets to some of those kind of events, You go into a room, you think that you're going to get a chance to get a ticket only to find out that you can't get the ticket. So some people decide, listen, with dynamic pricing, which we'll talk about a little bit of that, please don't let me forget it. The prices continue to go up. And by the way, at all venues, based on demand, price does go up. The interesting thing is that most people in the primary side of the market, they want to restrict what happens on the secondary, but they're really controlling it by them raising the prices up on the initially. Okay. So 3,500 seats or more or less, this is not restricting them. Speculative ticketing, you've actually covered it. Spec ticketing has been passed in several states already. It has been deemed to be the solution to allow people to have a service that they want to have. It's clear that they have it. I need to also advise you that Connecticut law already also says that when you go to click on a website, it must disclose that it is a secondary website. So you're automatically telling someone, I'm not the Bushnell or whatever that place is. So I let you're all bright enough, if you've already done something, some of what you may hear in testimony here today or other things, you have to evaluate how much merit it may have if it's already been handled. Also, in the AG's law bill that he's done, he's got URL restrictions, which is we support primary and secondary. But let's be clear, when you talk about the URL, because the gentleman talked about websites, there's one thing, and it's been passed in Virginia, Colorado, Michigan, has been proposed in many other states, legislation around the URL. That's normally where you go look to go find out about a website. I want to go to ticketnetwork.com or the bushnell.com, whatever. That's where you go. You type it into the URL. Well, the URL has domain and subdomains. The across the board practice to deal with the concern that was raised today is to do exactly like the language that the AG has, with one clarifying point. His language says anywhere in the URL address. It doesn't say in the domain or subdomain. By saying the address, that means I can't advertise for anything. You can't search for anything. So anyone asking for that, they're really trying to restrict and get rid of resales. In real earnest, if you want to do it, you use the language, and that's what I refer you to Michigan, Virginia, Colorado. You will handle that address. In a subsequent meetings, I look forward to working with this committee. He raised an issue that I'm not as well versed on, but it deals with the Google search and paid ads. Because he says, listen, you go look for something, you put in Bushnell or whatever, but some people pay more. And that is true. They do paid ads. But if you'll notice, it says paid ad.
Did your colleague ever, you're so kind to let him do all the talking. You understand it.
Well, he did that when I was in office, so I've been trained well.
Yeah. I just have one quick follow-up. It's this dynamic pricing. And you said that it's like a moving target. And by the way, it's fascinating. This committee's we've been chasing our tails on this for a long time. Like whenever we think we've got the golden solution, it's like, I don't know. So one of the issues that came up was this dynamic pricing. It's like dynamic pricing from the original venue or dynamic pricing in the resale arena by whoever's doing that. And other than transparency, I'm not sure how we get our arms around this. When I said can't get it or sorry kids can't go, I wasn't talking about the Taylor Swift thing where you just can't even get a ticket. But up in my neck of the woods, maybe I'm just been in public service too long. But like to me, a $200 ticket is like, you do that for 4 tickets. Like now I can't spend $1,000 just for 2 hours coming in and seeing one little show. Whereas if it was like $200 total for 4 tickets, I can rob from Peter to pay Paul and make that happen. So when I say you can't go, is like if the cost is just too high. That's assuming you can even get a ticket, right? So I'm probably living in a little parsimonious 4-person's world, but I can't figure out any solution to stop people being creative in marketing other than saying you got to say what you're doing to people and then let the buyer beware.
I agree. So dynamic pricing is controlled by the venue or the primary seller. Secondary market has nothing to do with dynamic pricing. we are subject to dynamic pricing. And someone will always tell you, well, gee, they got all these fees and things that are all so high. And like, that's what created the price. But unfortunately, you'll never be able to track what that original price was because it does move. It's just not doable. All right. But you can always at least do the all-in pricing where upfront on the first page, you're given the full price, you're given the detail of that price so that a person knows all that detail and it cannot change throughout the entire process other than delivery fees and sales tax. Last fact for you, and I'll make sure I send this to the committee. A study was done on how much the secondary market actually saves consumers. Millions of dollars. There's a study is done almost by state. Because the reality is you have some people that, yes, are speculating on buying tickets, but when they can't sell them for the price they thought they wanted to sell them for, they sell them for less than market price. Consumers are for the norm. If it's regular baseball games and stuff you do on the norm, they're actually purchasing tickets for less than the original purchase value.
Representative Vitigliano.
Thank you, Mr. Chairman. Good afternoon, representatives.
Good
How are you?
afternoon.
Just a couple questions on that dynamic pricing issue. You said that the secondary market would have do you have your own version of dynamic pricing? So you're saying that the original venue may have dynamic pricing, Ticketmaster, right? Would that be
Ticketmaster.
Ticketmaster?
Or
So you're not Ticketmaster, you're the aftermarket StubHub type situation, right?
Right.
So if they have dynamic pricing for a show at the Bushnell, can you have your own version of dynamic pricing for a show at the Bushnell? I don't know, unless I'm not making sense.
I was following you till up to a point. So dynamic pricing again is controlled by the primary market. So
Can you have your own version of that in the secondary market?
To my knowledge, we don't have that. That's the case. But I'm thinking of a scenario that may appear to be. That's why. So I want to be clear. A scenario where a ticket was posted on, say, one of our sites at, I'm just going to use a number, $355 and another $50 worth of fees and was fully disclosed. And let's say through dynamic pricing, the price from the primaries goes up so much higher than what we really were at. I don't know, and I will get you an answer on that though, whether that price that was originally posted on ours changes or not. I don't know immediately.
So
I need to
your
get back to you.
resellers don't actually own those tickets when they offer them for sale.
We don't own them. Oh, no.
Does anybody own the tickets?
Yes.
So they would know what they
We
paid
don't
for
own
it.
them. Yes.
But so before the gentleman from the Bushnell had testified that there's ticket brokers out there selling tickets on an aftermarket that they don't even own yet. Then they turn around and buy them. A speculator. So if this is where I got confused when you said dynamic pricing.
Yeah.
If dynamic pricing was in play, as you say, the person knows what they paid for it. Because if you're reselling tickets that are owned by somebody, then we know what the base price was. Even if that was fluctuating when they were buying it, they purchased it and now they're reselling it. So that's why I ask, are you involved in that speculative market where they don't actually own the tickets? I have season tickets to a professional sports team, and I am so grateful that I get to resell them. And you're right, I could set the price up, I could set the price down. Team does terrible, I lower the price, but it's set when they sell. You know what I'm saying?
Yours is, you can raise yours up or down, correct?
I can.
Because you are the seller.
I am through whatever service they use, right?
So similar to us, it's on our platform. Whoever that seller is that has agreement with us to sell, if they want to change their price on their ticket, they have total control over whatever.
Right, but they have to set the price before somebody buys it, so we know what the price is.
They are the one that sets whatever their price is.
Right.
Yeah.
And then you have a fee that's disclosed.
Correct.
And then we know that. That's why I was confused. I was confused with the dynamic pricing because it made it seem like the tickets you were reselling on your platform weren't yours yet or weren't owned by somebody. You never own the ticket, right? It's always somebody else.
Unless it is a spec ticket. That ticket is owned.
Okay.
That ticket is owned.
So do you deal with spec tickets at all?
On ours, there's a name that we have for tickets that are not like your typical spec tickets. They're in an air. They're zone price tickets is what We're gonna
Zone
offer
price
Zone
tickets?
price, zone price. So you'll know the zone that you're gonna go in.
Zone meaning spot inside the venue or?
Correct, inside the venue.
Okay.
And you are guaranteed. You fully know, we fully disclose to you. We will provide you this ticket at this price within this area. If that or equivalent, if not, you get 100% of your money back. So remember, that was like
I think
Instacart.
I think we are all more confused than when we started. First of all, I just say that for myself. And when you and I have had many conversations.
Yeah.
But back to the good representative, you said you had something about section. I'm going to let you talk just for a second.
Okay, all right.
Please.
I don't remember him talking this much when he was elected. Yeah, I have to be honest with you. I'm just teasing. You said I just went over section 2. I'm not sophisticated enough to figure out how to pull your testimony up on my computer that quick. But if you could just go over the other issues that you have with section 2 one more time, I didn't quite understand what.
Okay, so two really. One was the URL not being able to use the language that you can use in the URL versus a domain. As when Mr. Fay, I believe, was saying that you could almost present yourself as the Bushnell.
Yes.
And so we're saying maybe you can specify where it has to be, but to say you can't use it at all is not to appear anywhere in anybody's Google website. That was the first one. And the second issue is the one in section 12 that talks about having to state the face value of the ticket for the initial person purchase it. You may not know that. I mean,
Right, but we just went over that.
Right.
And that's
But
confusing.
those were the two items that
Right.
I mentioned.
And that face price again,
so-
Representative Rittick, if it were the Bushnell, if they started the ticket at $39,
Yeah.
next week that same ticket is going to $49. The face value has changed.
Right.
You bought the one at the 39, you got the one at the 49. It keeps moving.
But your business, Ticket Network, do you have specific sites like, for lack of a better word, StubHub or all these other aftermarket sellers, or do some of your people participate in sort of that thing we were complaining about, that Bushnell dot whatever, that where there's a name that's close to the Bushnell and it's an aftermarket that way?
We will not allow it.
Okay.
That's the beauty of having a secondary market. For better, for worse, the secondary market provides the kind of protections that you want and the kind of regulations. And we're the ones that provide, we take the liability for any dollars of money that's spent on our webpage, even though our arrangement is with the seller. We go after the seller, we deal with that. We make certain that the consumer is always protected.
So I know that your Ticket Network. So is that the website you go by, or are there many aftermarket companies that are sort of under the umbrella of Ticket Network?
No, we have our corporation, Ticket Network Corporation. All right. And there are brokers who, yes, have agreements with us. Anyone who wants to resell is their ticket. They can resell by agreement on our platform.
That's
Similar
with an
to
individual?
StubHub, similar to Vivid Seats,
Okay.
similar to you, Representative Ritigliano. You would have to have an agreement.
Okay. And that's, are you laughing because you don't understand either? Or am I just, I totally don't get it. I thought it was me. You think it's over what? Well, that's initially. After that,
We miss each other. I mean, come on.
it is awkward as the
Yeah. All right,
Thank you for your time. We're always available for committee, whatever we can provide for information. Please don't hesitate to ask.
Great. Thank you so
Thank you.
much. Okay, and then for anyone who's online, we would just ask you, if you get promoted to be a panelist, please accept that. That's how we allow you in to testify. And then the other is we are not really going to allow use of filters when you testify. There shouldn't be a filter on your Zoom. So with that, next is Marlene Wilhelm, to be followed
Yes,
by Nate Fleming.
I'm here. Can you guys hear me?
Yes, we can hear you. Please proceed.
And I don't think you can see me. But that's okay. Thank you, committee members, for allowing me to testify today. And I'm here in support of HB 5112, the puppy mill pet store bill. And I don't know if Representative Turco is still there, but he had made a comment before about he didn't know much about rabbits. So for his edification as well as others, I just want to let you know that rabbits at Easter time, a lot of pet stores were getting rabbits from commercially bred sources to sell rabbits at Easter time for Easter gifts. Many of you may remember over the past several years that the House Rabbit Connection, which I'm president of, we used to have billboards on 84 and 91 saying that rabbits are not an Easter gift or a Christmas gift, that they're a lifelong commitment. And just like every time 101 Dalmatians comes out, there's an uptick on people that want to adopt Dalmatians. Unfortunately, we have to deal with Easter every year. And of course, with that comes purchases. And I'm here to testify in support of the bill because as a rescue and president of a rabbit rescue, I've been doing this for 25 years. We make sure that we match the right family with the right rabbit. And the bottom line is we want to make sure that whatever we're doing is primarily in line with what's best for the rabbit. So that's something that, we're dedicated with doing. I would like to see a statewide ban in Connecticut. And again, I've heard testimony today about the bad players, and of course we need to eliminate them. But other stores that had sold animals in the past, Petco, PetSmart, etc., they have gone to not selling pets in their stores, but selling product, and they are thriving with that. So I think on that note, I don't want to get into too much more because really it's been kind of covered by a lot of people, including James Bias from the Connecticut Humane Society and Jennifer Walker. I ask you, committee members, to please support HB 5112.
Great. Thank you very much for your testimony. Are there any questions? Okay, hearing none. Thank you for taking the time to testify to us today.
Thanks.
Next, Faith Fleming.
Hi, can you see me and hear me okay?
Yes, we can.
Hi.
Please.
Hope you all are doing well today. I am testifying opposing HB 5112. I have worked at A to Z Pet Shop with my mother, the owner, for many years since we opened in 2011. I personally have worked with many customers finding the perfect pet for their families. I think letting the consumer have the ability to choose where they get their pet from that they're going to have in their home is extremely important due to the fact that every single consumer and every single customer has their own needs that is hard sometimes to be met. I personally have worked with a lot of children that have had special needs or have had anxiety or things that they need a specific type of pet to help them with. And I think being able to spend time with that child or with that person and find the proper pet for them is really important. I also believe that letting consumers have a choice and have the consumer protection of if this pet doesn't work for them, we always will welcome it back into the store. We always say if it doesn't work, we have a lot of customers who have moved and couldn't keep their animals, we always take them back. Very rarely do our animals end up in a shelter or a rescue due to the fact of a consumer not being able to keep it. We always want it back so that we can then find another great home for that animal. So I just wanted just to kind of put some perspective on that, definitely to oppose HB 5112. Thank you so much.
Great. Thank you for your testimony. Are there any questions from the committee? Okay, hearing none. Thank you again.
Thank you so much. Have a good day.
You as well.
Bye-bye.
Next, Anupama Mohan.
Hi, are you guys able to hear me clear?
Yes, we can hear you. Please proceed.
Awesome. Thank you. Dear members of committee, thank you for the opportunity to testify today. My name is Anupama, and I'm a proud resident of New Haven. I'm here to express my strong opposition to the proposed Act, HB number 5112, an act prohibiting pet stores from purchasing or procuring dogs, cats, and rabbits. I'm the proud owner of two beloved pets, Morty, my cat, whom I adopted from New Haven shelter, and Rick, my Pomeranian puppy, from who I got from a reputed pet store. My experience with Morty's adoption process was long and tedious, and while I'm grateful for her, the road to adoption was filled with hurdles, long waiting periods, and extensive paperwork. The process was further complicated by Morty's neurological issues, which requires ongoing veterinary care. While I wouldn't change my decision to adopt Morty, the reality is that the shelter adoption process can be unpredictable, time consuming, and stressful. When I thought of adding a new member to my family, I wanted to adopt, but most of the rescue didn't have a small dog that would be perfect match for Morty. I soon realized that adopting a dog from a rescue isn't as easy as getting a cat. During my search, I came across a group on Facebook and was scammed out of $300 for a dog that didn't even exist. This experience was frustrating, not knowing where to go. In contrast, getting Rick from Safari Science Pet Center was much smoother experience. From the moment I walked in, I could see the difference. The staff were incredibly knowledgeable. They provided me with detailed information about his care, be it his health, his parents. They even showed me pictures of his parents and what to expect in his transition to our home. This kind of transparency and support demonstrated how regulated pet stores ensure that animals are treated with the utmost care and new pet owners are fully prepared for responsible pet ownership. In fact, data from the Connecticut Department of Agriculture indicates that pet stores must maintain extensive veterinary records, comply with strict sanitation protocols, and source animals only from USDA licensed breeders. This oversight provides an essential layer of protection for both consumers and animals, protections that would be lost if we're allowed to ban pet sales in stores. If the sale of pets in regulated pet stores were prohibited, we would be removing a crucial safety net for consumers like me. Rather than driving people to shelters or reputable stores, such a ban would force them to seek out unregulated breeders or potentially dangerous alternatives, opening the door for more fraud, scams, and animal mistreatment. The harm caused by pushing people towards less regulated sources would far outweigh any intended benefits. A key concern in this debate is the risk posed by unregulated breeders, which would become a primary source of pets if regulated stores are prohibited from selling animals. According to the Business Bureau, pet scams surged by 39% in 2022 alone, with thousands of consumers losing money to fraudulent breeders selling sick or non existing animals. The AKC report, the American Kennel Club has reported that an estimated 80% of online pet sales come from
Ms.
puppy mills
Mohan,
or
your 3 minutes are up. Would you mind summarizing?
Oh, yeah, sure. I strongly urge you to reconsider this legislation. They provide well cared for animals, follow ethical practices, and offer a safe and reliable option for families looking to add a new pet to their home. Banning the sale of pets in regulated pet stores would not only make it harder for people like me to find healthy, well treated animals, but would also increase the likelihood of people falling victim to scams or buying from irresponsible breeders. Thank you again for your time and considering my perspective. I trust you will make the decision that protects both animals and families who love them. I'm open for questions if you have any.
Great. Thank you. Do any members of the committee have questions? Okay, hearing none, thank you for taking the time to testify.
Thank you.
Next, William Taylor from Veterans Guardian.
Good afternoon. My name is William Taylor. I'm a 23-year Army veteran and have 6 operational combat deployments to Iraq, Afghanistan, and the Balkans. I am the founder and CEO of Veterans Guardian VA Claims Consulting. I have over 200 employees that work for me. Most of them are veterans, spouses of veterans, or spouses of active duty. We provide a vital service to veterans around the country, the world, and specifically here in Connecticut to help them navigate the difficult and many times arcane VA disability process. We are an ethical, transparent, and upfront company, and I am proud of the service that we provide to our veterans every day. We are providing, last year, we helped over 30,000 veterans around the world. achieve their VA benefits. We have a 90% success rate, and our average veteran is getting a decision in 85 days or less, which far exceeds the standard of all other people that are providing assistance, which that average is sitting at over 150 days right now. When we look at veterans here in the state of Connecticut, I've helped over 300 in the last several years here in Connecticut. 70% of them come to me for assistance after having tried to utilize one of the free services that was mentioned earlier. 70%. Where do those veterans go if you take me out of this ecosystem? When we look at here in Connecticut, you have 24 registered veteran service officers for the entire state. 24. There are over 153,000 veterans here in the state. That's an average of about 1 to 6,400. Those 24 are doing great work. Many of them are providing essential services, but in many cases, veterans are looking for another option. My concern with HB 6858, particularly Section 3, is that we don't want to unintentionally take away an option from veterans. We share the concerns about predatory actors. We know that it's out there. We know that there's issues, but we feel a better solution, that we need to ensure that the solution goes over after those predatory practices through consumer protections, rather than just getting rid of an entire industry. I do need to address, and I respectfully disagree with the Attorney General, our business model is 100% compliant with federal law. We are acting as consultants to veterans and not as their agents or attorney, which is what the restriction under federal law is. We also would like to be accredited, but current accreditation models at the federal level do not allow us to operate as a business under those models. We are working actively to try and change that at the federal level. And so I would ask you to consider, as we're looking at this bill, that we provide the consumer protections without getting rid of the industry. Thank you. I'd be happy to take any questions.
Thank you very much. Senator Kissel, followed by Representative Acker.
Thank you very much, Chairman Maroney. First of all, sir, thank you for your service to our country. I listened intently to the concerns raised by Senator Austin, and I'm in agreement. We have some wonderful, I guess, service officers that are really familiar. But I have a conundrum in my neck of the woods. I have like all are part of 8 communities, some large, some small. The service officer in one of my most small towns, they are just incredibly good. Now, we have a law in the books that says every town should have one of these folks, but it's impossible to make them do that. And the problem that I have is because these folks and I won't name the town, but they're so good that all the other towns, large or small, really say, well, we don't want to spend the money, or we don't have anybody ready to do this, and there's really no penalty for this state law. And the person, or actually there's 2 people in the small town, they're doing it out of the love of their heart. They just want to help. So, and the next service area is like way down in like Norwich or something like that. So the dilemma is out there. And so I see that you guys are performing an extremely valuable role. I get it. If these are free benefits, why pay someone to get you something? But these are really complicated. I have veterans coming up to me all the time, but for this small little community that has a dedicated part of their town hall as an office and 2 people that essentially have adopted this as their full-time job for like nothing, there would be no service up in North Central Connecticut. So I don't want to throw away the baby with the bathwater. So if there's anything that we can do in this area, like a disclosure or something like that, but I'm in full agreement with you. I don't want to see what you're doing eliminated by law. I guess that's a long way of saying I support you. And I just would ask that for your footprint in Connecticut, specifically geographically, whose ox might we be goring? Like, where's your offices, or
So
if you have more than
we're
one?
actually all located in Pinehurst, North Carolina. I am servicing clients in all 50 states and about 24 countries around the world. We've set up a system that allows veterans to access us completely remotely, and we communicate with them in whatever means works best for them, whether that's video teleconference, phone calls, emails, text, snail mail, if they want us to be physically mailing things. And so we go to where the veteran is digitally, and it allows us to help veterans wherever they're located, and it avoids the issues of someone not being in their area.
Great, I appreciate it. You flew up here from North Carolina?
I did.
Yeah, my
This
brother
is so
lives.
important to me.
I appreciate
believe
it.
in
My
the
brother
service
lives in
that we're-
Raleigh, and my nephew goes to Appalachia State. Thank
sir.
you.
One other point I'll put in there is under the current bill that's being proposed, I actually don't think there's enough consumer protections in here. We can provide some recommendations where you can go even a little bit further. Start talking about fees having to be contingent on a successful outcome, requiring disclosures that there's free services available, requiring disclosures upfront that we're not accredited, that there's that we are a fee-based service, requiring us to use HIPAA compliant servers. We talked about concerns about data. I can tell you right now, my data is more secure than any VSO out there. Many of these VSOs are operating off of Hotmail accounts, Gmail accounts, AOL accounts. I'm running CrowdStrike and HIPAA compliant servers that I control on my own. My data is secure. There's a host of other issues, and we can provide recommendations to all of you on some of those additional protections.
Yeah, and if you could make sure the leadership of the committee gets those recommendations. The only thing with CrowdStrike is I did have that green screen of death happen to me, so it's a little scary, but thank you.
I do have questions for you, and I'm going to follow up, but I'm going to let Representative Ackert go first, and then I'll go.
Well, thank you, Mr. Chairman, and thank you for being here. I think that the good senator asked my questions, and I think you brought up a good point. I was concerned, is there something that we could put in language that would make, you're still viable business serving but also puts in, some better protections?
Yes.
I think that's what it is. So I'll heed my question, because that's what I was interested in asking about.
We actually have proposed
Thank you.
legislative language that we are working around the country right now. Louisiana has passed a version of what we call the SAVE Act, which puts these consumer protections in place, creates an avenue for the AG to come after us if we're violating them, gives the veteran a private right of action. It also allows your consumer protection bureaus to come after. We believe that there are about a dozen plus states that will probably implement similar legislation this year.
Great, thank you. And that was along the lines of my question. One, I wanted to say, like, from my prior business before here, I worked in an industry that really was marred by some bad actors,
Yes,
right?
sir.
And not all. Sometimes we paint a broad brush that all for-profit is bad, all nonprofit is good, and obviously that's not the case, right?
Yes, sir.
That everything, there are shades of variation. But so just back to the bill, right? So I think from the way you were testifying, you made item number one, right, of the requirements that we'd put on you. So it sounds like, the next couple items where you had to be federally compliant, it sounds like you feel that you are compliant. So that wouldn't be an issue because you're a consultant versus representing. But number one, where it says obtain all qualifications, certifications, and accreditations necessary, you're saying there's no really official accreditation?
There is an official accreditation process right now at the federal level. The problem with it is that as an accredited agent, you are only allowed to charge a fee to assist with appeals. So prior to 2006, no one was allowed to assist for a fee. In 2006, they allowed lawyers to come in and provide assistance on the appeal level. We are working to try and move that line so that an agent can provide assistance at any step of the process for a fee. But as of right now, if I become accredited, 90% of my business model, I can't provide service to my veterans because we focus on getting it right up front so the veteran doesn't have to get into the appeals process. So I'm actually doing my veterans a service by operating as an unaccredited entity because it allows me to look at them holistically. The concern with the language in the current bill is how do we interpret being in compliance with federal law? I obviously am interpreting it as we are 100% in compliant, but the AG stated earlier that he sees it as we are violating federal law, and that's where we have some concerns with the current language.
So you need clarity. Item one, I guess, if instead of, if we added an additional to register with the state, would that?
We would have no issue with
That
that.
would suffice.
And actually, that's what's required in Louisiana. We have to register and we have to provide a report every year to the state.
Okay. Let me just write that. And then. Sorry, just taking my notes. And then you'll send us information. I mean, they do require, it's more of a disclosure the way I read it in
Yes.
here, but you would have language for additional
We would
disclosures.
actually recommend an even stronger disclosure than what's included in your bill. I'm coming into as an industry, as a representative of my industry, asking to be regulated. We
Right.
do understand that there are bad actors, that there are bad practices, and we think that we can go out after those practices while still maintaining the industry and veterans' freedom to choose how they want to pursue their claim.
Great. Well, thank you very much.
you,
And
sir.
please send along your written suggestions.
Yes, sir.
Okay. Next, Togi Kutamperor.
Hey there, guys. Can you see me and hear me?
Yes, we can. Please proceed.
Okay. Sorry. Dear honorable members of the General Law Committee, my name is Toji. I'm a small business owner, and I started Safari Sands Pet Center, which is a local pet store in New Haven, in 2013. So that's about 11 years. Over the past few weeks, I've seen two bills being introduced, one being HB 5112 and then HB 6, I forget the number. But there's a lot of misinformation that's been going around, and I just want to clarify some of that misinformation. So in 2014, a task force was set up, and there were groups from both sides, a veterinarian. They all got together and they eliminated one source for where we get puppies. We used to get them from what we call hobby breeders. And those are people that just breed one or two, puppies. And so we're not allowed to buy from hobby breeders, but instead forced us to go to regulated sources like commercial breeders. So this law went into effect in 2014 or so. And with that came a lot of regulations that regulated pet stores. We're not just licensed, we're also told how to operate. There's requirements, and we're inspected regularly on a complaint or yearly. Now, they also came up with standards of where we can source our animals from. So they had to be USDA licensed breeders. They also requirements for vet care. The requirement was 15 days, but we do ours weekly because puppies need to get vaccinated and checked out by a vet. And then there's also access to information for our consumers. We had to post signs and provide information of where the puppies come from. But we go above and beyond that. We actually have pictures, videos of all the puppies and the parents and the kennels they come from. So, just to clarify, it's been said that stores are moving from New York to Connecticut. That's not true. The two new stores that opened up before the ban in Connecticut, and the third store was a second location of an existing owner here in Connecticut. I also saw some pictures that were posted by the Humane Society saying that those pictures are totally misleading. If you guys know how to use Google Lens, click on that picture and it'll show you where all it's been used. So if it's been cited, it's been used in, yeah, you can do the research there. Also to bring, sorry, I'm jumping around.
That's your 3 minutes. If you could please summarize.
Oh, that was quick. All right. I'll just so we have zero complaints. We don't have any problems from our consumers. We take backup puppies. We have a program that helps educate people about puppy ownership. It's not just a 1-minute process, it's a 3-hour process. So questions, guys. All right.
Thank you very much. Are there any questions? Representative Ackert.
Thank you. And how many stores do you have in Connecticut?
I have one now. I used to have two. I closed down the store in Stamford because we were getting harassed, and I had a lot of young staff, teenagers that were getting harassed by people, I'll say.
For animal rights people or just?
Yep. I rather not discuss that.
Oh, okay. All right. So you have one store and how many employees?
I have 15.
15?
Yes.
Thank you. And what is your stores? Is it just animals, or you got all the products all?
Uh, So Connecticut allows and has defined what pets are. So there's 14 of us that do all the animals, from puppies to reptiles to birds, fish. So we do it all, what's regulated and what pets are. Yeah, so it's a full line pet store, and supplies are a small portion of it. I also heard that, we should follow the Petco model. We can't even compete with Amazon or Chewy's, and Petco and PetSmart are big warehouse distribution. We don't have that. We have to buy it at a price. If they buy something for $5, we have to buy it for like $20, and we're just one store buying. Our buying power is not as great as all these big box chains.
Okay. Thank you. Thank you for your testimony. Thank you, Mr. Chair.
Yeah.
Thank you. Are there any further questions? Hearing none. Thank you for your testimony.
Thank you.
Next, Aisha Khan.
Hi. Okay. My name is Aisha. I'm here to oppose the gouging bill, so 6856, and I also have a small comment on the SB 430, the death penalty, but I'll save that to the end. I'm born and raised in Connecticut. I went to Fairfield University. I work in a family-owned and operated fuel distribution and commercial real estate development company. I started working when I was 13, like many children of immigrants, alongside my father, who was a gas station operator for Exxon. As my parents' ambition grew, they became franchisee owners for fast food restaurants along with the gas side. And while I was in college, I came back and my parents had acquired more property and they got onto the development side of the business and the fuel distribution side of the business. The reason for giving my background is just to show that I've had a lot of good experience and I have a good amount of knowledge on various parts of my industry. And I love Connecticut, so I went to college in Connecticut. So that's a little bit about that. The pricing for fuel, I can only speak on behalf of my industry. It varies by town to town, as you all know, because you guys probably all fill up. Taxes, we have 60 to 65 cents, Connecticut tax. That's a big portion of what's baked into what you buy. There's hauling, so transportation, development, permitting, a lot of things go into the price of fuel. Price gouging for fuel, I'm not quite sure if it's really effective, because if you're a local one business store owner, your price is different versus having 20 sites, 50 sites, or 500 sites. Maybe you operate like Cumberland Farms. Their pricing is obviously cheaper than me. I have like 50 sites, right? So it's really hard to actually investigate and come down to a resolution for something like that. So I'm not quite sure if that's a good use of taxpayer funding. But in general, having the Attorney General have power over what he can decide is a economic disruptor, I think it's a little bit concerning. He mentioned today that the convenience stores have like the highest prices. We're the last people in the industry to even sell an item, right? Like we're not Walmart, we're not Target. We don't have the ability to bulk buy like Costco does. And also being in the free market, people will buy what they want to buy, right? Something from Costco that might be Kirkland owned, which is Costco's brand, you can disclose that it's maybe less toilet paper or something, but consumers will buy what they want to buy. It's a free market, and if you don't like it, then you buy it somewhere else. Just like gas, you don't like it, you can fill up somewhere else, or maybe you do want to pay 20 cents more for BP or Mobil because of the quality of what you're getting, right? So I don't know if price gouging necessarily would work well for fuel since it's such a variable industry. I think also some things that he said today were a little bit concerning, saying like 60-day extensions. If he wanted to and needed it, he would have to prove the disruption. I mean, this is taxpayer funding that's time being spent on these things, and saying something like the governor and the attorney general might not agree on certain things, so the power should be shared. I can't speak on behalf of everybody, but for me, it kind of shows a little bit of fractured leadership, and also kind of opens the door for corruption if you have an attorney general who just wants to check whatever he wants to check. And that's basically my opinion on this. The little comment I had about the SB 430, I'll just wrap it up real quick. The death penalty isn't going anywhere for the country. Every state has, different regulations on it. I think I sympathize with people who are supporting this, but I personally am in opposition. there are engineers that have to make this type of equipment. There's chemistry that's involved in creating this, and manufacturing, machine operation, people that have to do things like, to get this out there. I think it would be an error to lose this talent in Connecticut and gift it to other states. There's a lot of good talent here that is being utilized for these things, and it's very detailed, and I think that that should be preserved in this state. And while there's a lot of sympathy for, people who are dying on death penalty and things like that, I don't think that it's going anywhere, and gifting our talent to other states would be an error. And that's it.
Thank you. Are there any questions? Okay. Thank you very much for testifying. Okay. Next, Stacy Ober.
Good afternoon, honorable members of the committee. My name is Stacy Ober. I am the Government Relations Manager in New England for the American Kennel Club, and I'm testifying to oppose House Bill 5112, statewide ban on the sale of dog, cats, and rabbits in pet shops. The American Kennel Club was established in 1884 as a not-for-profit animal welfare organization. We have more than 5,000 clubs across the country, including 57 in Connecticut, and we are a recognized and trusted expert in canine health, training, and breeding, and in promoting responsible dog ownership. So we encourage owners to provide proper care, training, socialization to ensure that their pets remain happy, respectable members of the community, and well-mannered canine good citizens. AKC and its affiliated clubs offer a wide range of educational programs and materials to teach dog owners how to reach these goals. And we also operate an inspection and compliance program to ensure proper care, conditions, and record keeping for dogs and kennels that are registered with AKC. My written testimony details many of our animal welfare programs, including those benefiting Connecticut communities. AKC believes that great pets come from a variety of sources, including breeders, responsible rescues, and regulated pet shops and shelters. Our belief is that consumer choice should not be arbitrarily limited by prohibiting the lawful sale of dogs in pet shops. Earlier testimony today to the committee stated that pet shops engage in predatory lending practices. That is false. Connecticut General Statute Section 22-354A bans making payment for pets over a period of time and entering purchase leasing arrangements. AKC opposes House Bill 5112 because a Connecticut statewide ban on retail sale of pets that's meant to improve animal welfare would ironically drive an increase in the trafficking of unhealthy pets to consumers. The committee is receiving testimony today that Connecticut shelters are overflowing with speculation that those animals were first purchased at Connecticut pet shops before surrender. I want you to know that the recent data from the Connecticut Department of Agriculture documented that over 41,000 animals were brought into Connecticut by animal rescue importers from other states and foreign countries such as Turkey, China, Egypt, Korea, and Slovenia between 2021 and 2024. So imported pets do not include detailed health or background information as required for pets sold by pet stores, and many are feral or semi-feral dogs and not the best fit for every family that wants a pet. We know that dog owners frequently want a particular breed of dog because of its predictable size, temperament, grooming needs, and instincts. And the wait list for a puppy from a reputable purebred breeder is typically 2 to 3 years. When consumers cannot obtain the pet they want from licensed and inspected entities and are willing to wait, they are at significant risk of online scams. Since 2017, the Better Business Bureau has been studying pet sales and warning about fraud to consumers to exercise caution. The committee heard testimony today about online ticket fraud. I want you to know that according to the BBB, pet scams accounted for an estimated 25% of all online scams in 2021. So you can find links to these credible sources in my written testimony. The crucial first step in supporting lifelong
Please summarize. Your 3 minutes have passed.
I'm just finishing my last sentence, if I could.
Great. Thank you.
the crucial first step in supporting lifelong responsible pet ownership is by educating prospective dog owners to ensure they are purchasing from responsible sellers who offer contracts, performing self-inspections of facilities and reporting violations, and avoiding buying pets over the internet. Please vote no on House Bill 5112. Thank you.
Thank you. Are there any questions? Representative Retigliano.
Thank you, Mr. Chairman. Good afternoon. I just want to be clear on one thing. You're the American Kennel Club, and we've had a lot of people testify today that there's horrendous things or really bad business practices and animals being mistreated in a lot of these pet stores. And then it's a little surprising to me that you're here saying to vote no for the bill. You don't support a bill banning the sale. Can you just go over quickly some of the accusations that most of these people are engaged in what would be considered cruelty to animals?
Well, the first thing I'll say is all 50 states have animal neglect and cruelty laws. And so AKC supports enforcement of those laws. Our experience and observation is that banning pet stores from selling pets does not result in strengthening the enforcement of laws in other states where pets might be acquired. All animals deserve healthy, humane care and conditions, and we support that with our own inspection program, which many people are not aware that we have an inspection and compliance department. And we are very concerned about an unsuspecting public that goes online and is sending money through Venmo, other direct pay accounts, and either not receiving any animal or receiving a very sick animal from some of these bad actors that you've heard today referred to as the black market.
Well, thank you. That answers my question. I appreciate it.
Thank you. Representative Turco.
Yes, I'm here. Thank you, Mr. Chairman. Ms. Ober, it is, right? Stacy Ober?
Yes.
Thank you for your testimony. So I am kind of shocked when I saw AKC was on here. I said, okay, I'm really interested in what American Kennel Club has to say, because I would think they would, want to protect animal safety as much as possible. But just doing a quick Google search, I see that AKC seems to have some recent history in opposing a lot of state laws to strengthen protections of animals or hold individuals' animal for abuse of dogs. So I don't really know the American Kennel Club as I thought I did. And we heard testimony today from individuals that said no reputable breeder would sell their dogs to a pet store to be sold in a retail shop. And I just wanted to get your opinion on that. Are AKC breeders selling their dogs to pet shops that are being sold to consumers?
So when you refer to AKC breeders, and I did share a lot of detail about who the AKC is in my written testimony, because my experience has been that supporters of pet shop bans tend to mischaracterize the AKC and claim that because we have a purebred dog registry, there's money to be made from the registration of dogs in pet shops. And I want to just acknowledge that our purebred dog registry, any dogs that are registered from a litter of purebred dogs and sold through pet shops, is a very nominal percentage of the dogs that are registered in our registry. Our members are typically hobby breeders. These are the individuals. I know one of the reps earlier said they didn't believe that dogs were bred as a hobby, when in fact they are. There could be sporting dogs that someone might breed their own hunting dogs. We have preservation breeders who are spending their discretionary money on looking to improve and extend the life of certain breeds of dogs that are very rare. we recognize more than 200 breeds of dogs. And so these are individuals that are invested in sporting, exhibiting, engaging in hunting or other sports, field trials with their dogs, and they're only selling a pet privately to a family that is incidental to their real purpose of breeding dogs for show, exhibition, or sporting related activities. They're not breeding dogs for purposes of selling them and operating as a business. So that's the distinction. And you heard earlier one of the pet store owners reflect on changes made in Connecticut back in 2014 to prevent pet stores from even collaborating with hobby breeders and to sell their dogs. So there are commercial kennels that breed purebred dogs, and they would be at liberty to register litters with the AKC. And by virtue of voluntarily engaging with us, you have volunteered to open yourself up to our inspection and compliance program. I hope that answers your question, Representative.
I really appreciate that. So it sounds like there are some breeders that may sell purebreds, from what you're saying, to pet stores, but they go through an increased scrutiny because they're part of the AKC before they are able to do that. Am I getting that correct?
Anyone that registers dogs or litters with the AKC has agreed to be inspected and held accountable to our care and conditions standards, whether they're a hobby breeder or whether they are engaged in breeding dogs for purposes of wholesale.
Thank you. So that does sound good that measure's put into place, but does the AKC then have any concerns over the, industrial breeding facilities, as we've heard them be called today, or puppy mills, we've heard them be called today, that are not part of affiliated, have some sort of partnership with AKC? Do you have any concern over those facilities, the way they operate, how they're regulated, how they're inspected, and the sale of those pets to stores here in Connecticut and then sold to Connecticut residents?
Well, I can say to you that the AKC consistently advocates for the USDA to have the money and the resources it needs to ensure that these kennels are timely inspected and that the rules are enforced that you've learned about today. We have even partnered with the American Veterinary Medical Association to pass what's referred to as the Healthy Dog Importation Act down in Washington, D.C., to address the bad actors who were importing dogs from outside of the United States for the retail rescue trade. There's bad actors who are engaged in fraud. There are sometimes breeders who hold out to the public that they have an AKC affiliation when they don't. So there's a considerable amount of fraud out there, and that's why I wanted to highlight the Better Business Bureau statistics.
Thank you very much for your responses. I appreciate that.
Representative Acker.
Thank you. And Stacy, thank you for your testimony. I think that might have been me, Stacy, Representative Acker, stating about that the hobbyists, as you mentioned, there are some hobbyists, but I'm sure that they do sell their animals. So most of my hobbies cost me money. So I don't think, but in terms of breeding, I do understand that you have some probably members that, enjoy what they do and bringing a nice pet into the world. So I strike that as being that's only there for money, that they may do it for the enjoyment of raising animals. So thank you. Thank you, Mr. Chairman.
Great.
Thank you, Representative. Thank you for letting me clarify the intention and the motivation of our members in Connecticut and their passion.
Thank you. Are there any further questions? Okay, thank you. Hearing no more questions, thank you very much for testifying. Next is Amy Jesse. Okay. All right. Next is Marilyn Melendez.
Good afternoon. Honorable Chairperson and members of the committee, thank you for the opportunity to speak today. I come before you not only as a professional with over 20 years of experience in probation and child welfare, but also as a survivor of domestic violence. I share my story not for sympathy, but to illustrate the urgent need for this legislation, HB 5162. Because for victims like me, remote vehicle technology is not just a convenience, it can be a weapon used against us. By all statistics, my children and I should have been another case of generational failure, but I refuse to let the abuse and trauma we endured define us. I fought to break this cycle. I pursued an education, built a career, and worked tirelessly to be an example for my children. I wish I could say that working within a system designed to protect families like mine helped me escape, but instead it reaffirmed how broken that system truly is. Victims are not supported as they should be. We are met with endless hurdles, labeled as difficult, and blamed when we struggle. Too often, survivors are stripped of their dignity and power long before they are ever empowered to reclaim their lives. What many people don't realize is that the most dangerous time for a victim is when they try to leave. When I finally made the decision to escape, I thought I would be free. Instead, I found myself facing a new battle, not just with my abuser, but with the very system that was supposed to protect me. For over 8 months, I lived in hiding due to ongoing threats to my life. My children and I moved between friends and family members' homes, never staying in one place too long. My abuser stalked and harassed me, despite a restraining order. He entered the courthouse, called my office, and taunted me with his presence. He would wait for me to leave my home, then break in through windows, just to remind me that he was still in control. And his control didn't stop at physical presence. He used technology to track me. I never knew exactly how, but I always felt hunted. I was forced to switch cars constantly to stay ahead of him. The very system that told me to leave failed to protect me from being found. This is why this bill is so crucial. Survivors should not have to fight for control over their own vehicles. Remote access technology in the hands of an abuser becomes a tool for stalking, intimidation, and entrapment. A survivor with legal possession of a vehicle should have the absolute right to revoke an abuser's access without unnecessary fees, delays, or legal loopholes. Had my abuser been able to remotely disable my car or track its location, I may not have made it out. This bill is not just about technology. It is about safety. It is about autonomy. It is about giving survivors a real chance to escape and rebuild their lives. I urge you to support HB number 5162, an act concerning motor vehicle data privacy and victims of domestic violence. This is more than just a policy. It is a lifeline for those who desperately need it. Thank you.
Ms. Melendez, thank you for waiting all day to testify and for sharing your story with us and reminding us why what we do is so important. I think sometimes we get caught in statistics and numbers and we forget the impact on the real lives of our constituents. So thank you for sharing. And with that, Senator Kissel.
Thank you very much, Chairman Maroney. One of the nice things that I get to participate on is the Council on Domestic Violence. And we're constantly trying to make strides forward. And I will say, it's my considered opinion over the years that Connecticut has led the way nationally in addressing issues related to domestic violence. Did your, I don't want to use the wrong term now, did your spouse or significant other or abuser, let's say, did they have one of these devices on your car? Because like, I just want to try to draw an analogy. One of the things that's really important if you're breaking up in one of these abusive relationships is finding, I don't want to call it a safe house, but a lot of the local domestic violence centers, they will have a place that no one knows where it's located. And in fact, I'm aware of some situations where there was a glitch and somehow that location and they had to fix it all because people need a safe place to go. And so did this person have one of these devices on your automobile? And if you found out about it, how did you address that?
In, in regards to knowing if he had the device on the car or not, like I mentioned, I'm not sure. However, he was able to locate me at times because he knew of the car. And that's why I had to switch cars multiple times. I had to take over 8 months or close to a year off of my job so I can go into hiding because he knew what areas to locate me at.
So if we go down the road of trying to ban this technology, I can see it being beneficial in some respects. Let's say you have a 16-year-old, they're driving, and the parent wants to know where the car is. For whatever reason, it's a trust issue. And so this device is going to let you know, no, you didn't just go down to the store, you were cruising all over town, and this is the data. So I'm just wondering, is there do we have any choice as to how we can allow it use for beneficial aspects, or do you feel the negatives so outweigh, the dangers so outweigh that we should just have an absolute ban on this technology from the private citizenry?
The part I feel is that if there has been found that you do have an abuser, you do have a restraining order, even in family court, there are difficulties where you're going through the process. It can take a few months to get through a divorce and it can take years. And when you have property at times, it still gives the other individual the ability to have access to that property. You can't distinguish that car belongs to them. You can't have information on it. If there is a restraining order in place, I feel that the person that owns the car, if the car's under my name or it's already been shown in court, I've proven the evidence. I should have the right, not having to go through legal loopholes to contact these, the car manufacturers or these individuals to take his ability to track the car off. They make it very hard to do so because I don't have like a divorce decree and so forth. And that's what I mean. There has to be a balance, but I feel like in regards to the technology aspect, because they can download it and if they have that information, it's easier for them to track my location.
Okay, that's great. I really appreciate it. This one intrigues me, especially with my work over the years with Senator Flexer and others on the domestic violence issues. And it strikes me as something we could actually get our arms around if this is part of the hearing before the court regarding a restraining order. Certainly, we're very sensitive to firearms and issues like that. And in a way, this may not be a loaded gun or a knife, but having someone have immediate, like probably through their cell phone, to know where you are, that puts you in harm's way. That puts you in danger. Conversely, though, it would allow those with laudable or non-abusive goals, a mom or dad and their child, or even like the president of a commercial hauling business that wants to know where all his or her trucks are at any given moment. There's a lot of good things that can be done, but I bet you we can get to a good solution regarding this, whether it's legislatively or some other way. So I'm happy to look at your testimony, and I appreciate your patience all day in testifying, because we've had a ton of testimony on some other issues and not so much on this one, but this one could actually, if we get our arms around it, save lives. So thank you. Thank you, Mr. Chair.
Representative Turco.
Take issue with this mic. Betsy has to turn it on. Yes, that's on. Thank you. Thank you, Mr. Chairman. Ms. Melendez, thank you so much for being here and for your testimony. So as you stated, I mean, this bill, the way it is proposed, is very restrictive. Someone can only get this GPS tracking technology turned off when they meet certain specifications, and that includes being a survivor of domestic violence or going through domestic violence situation, and then needing to be able to show the manufacturer that there is a restraining order and there is an active situation going on. So to my colleague, concerned about maybe this technology being, banned or turned off, it's only very specific situations to protect domestic violence survivors. But what I wanted to ask you about is the initial proposal that we have in front of us today in this legislation was copied off of the law that already passed in California recently as a starting point. And since we've put this bill in and scheduled a public hearing, I've actually heard from some national domestic violence and data privacy organizations that while they think it's great, Connecticut started with the California language, that language was watered down and weakened by the time it originally got introduced in California and it became law, compromises with the manufacturers and things like that. So just want your opinion on the proposed language, if you see any way, as someone who's been through this, that this language should be strengthened before we pass it out of this committee.
I feel, in regards to the language, I definitely feel that I'm not saying it has to be completely banned, because I do have a teenager and I track her location. And I have 2 adult children that have successfully succeeded in their situation. However, we need to make sure, like you indicated, if I've already proven that I've been abused, I've already proven the burden of proof that I needed to obtain a restraining order, then it should be easy for me, cost effective as well, of me being able to take away the power from my abuser and me obtain my power back. Because for so long, I have lost the power. And I should be at least given the right to be given that power back, especially if the car belongs to me. I'm not asking to take it off of the other individual. That's his prerogative, that's his car. But if it's my car, my personal property, I'm already been through, sorry for my language, heck and back, so I don't have to swear. And now that I'm obtaining my power back, why can't I be given the power of taking it away from him and him being able to locate me so I can get hurt again?
Thank you very much, Ms. Melendez. I appreciate that, and wanting to make it an easy process in an already stressful situation for you. So thank you.
Appreciate it.
Thank you so much for your testimony here today. And as Senator Kissel mentioned and Representative Turco, your willingness to sit through a lot of testimony and to share your story and the importance of this. I think it's got to be difficult for you to do this personally and publicly, but it is of great benefit, I think, to legislators up here as they consider the importance of this and that it does have a face and does have an impact, and the need to get this done is so paramount. So thank you, Ms. Melendez, for your time.
Thank you so much. I appreciate it. Have a nice afternoon.
You as well. Michael Fox, followed by Kevin Curry. Michael, you're online, right?
Yes, I am. Can you hear me?
We can, Michael.
Okay. Good afternoon, Chairman Maroney, members of the General Law Committee. Many of you know me. My name is Michael Fox, and I'm the Executive Director of the Gasoline and Automotive Service Dealers of America. That's the trade association that represents the mom and pop gasoline retailers, the ones everybody always accuses of gouging. I've been coming before this committee since 1979, and I've always considered it an honor to do so. But I have to be honest with you, the last 3 to 5 years, it's become very difficult because the bills seem to be more and more political in nature rather than trying to help Connecticut business owners or Connecticut consumers. HB 6586, introduced by the Attorney General's office, is a classic example of this bill. You've already heard testimony from Chris Herb, who represents the jobbers or the distributors in Connecticut, that over a decade ago, the current Attorney General sat on the General Law Committee and negotiated the current bill that we have. Now, I have had at least 20 conversations with the Attorney General, and his insistence that he needs to increase the food chain where he can look outside of Connecticut retailers, because as he testified, retailers aren't the problem. I have only one problem with that. The language in the bill says he can go after any firm, individual, or corporation. I'm not sure what more he needs, why he can't go after anybody else. The other thing that I'm concerned about is a lot of the language and the need in the current bill seems to be trying to go after food pricing. And again, he needs to go after somebody else because he's found out that retailers who are charging $20 are paying 19. So if that's really his goal, why don't we leave the current gouging bill alone because it works? His own testimony says retailers are not the problem, and then just insert language that says he can go after anybody he needs to in the entire chain of distribution for gasoline. That's one suggestion that I have. The problem with the bill in its current language is it just doesn't define what gouging is. The Attorney General and I had a huge argument the last time this happened, which was when the state chose to suspend the state gas tax, which was a great thing. We supported it, we wanted to do it, and we did do it. But he held press conference after press conference telling consumers to just call his office and repeat the 800 number where you could call, but he didn't define what gouging was. So gouging at that time was just defined as anybody who didn't reduce their retail price on a certain day by 25 cents a gallon. Only one problem with that. A lot of us had inventory at our tank where we paid that 25 cents. Some service stations only get one delivery a week. We're not all high volume gas stations. So I'm not going to take up too much of your time because I hope you have a lot of questions because I have a lot of suggestions on how we might be able to do this. I think what really disturbs everybody, and you're hearing it over and over, is this debate between enacting emergency powers. It's a check and balance. He doesn't like that. I understand that. But it works, and we shouldn't change that. If you do nothing, do not change that at all. Why? Because I don't care if it's a Republican in the governor's office and a Democrat AG or vice versa. If the two of them can't get together and define what an emergency for the consumers of the state of Connecticut is, that's the real problem. So that check and balance of how this has been working, and this has been working flawlessly. Now, the problem that we have in the current bill, not the bill you're seeing here today, but the current law, is we get a letter from the AG saying consumers have accused you of gouging, and that means I got to hire an attorney, and I got to get a lot of paperwork together to send to the Attorney General's office. And we've been doing that for 10 years. And if there was a huge problem with retailers gouging, I think there'd be a lot of them you'd see on the front page of every newspaper at a press conference, not only by the Attorney General, but both parties. And I would support that. Gouging is unconscionable. Anybody who does it should be hung in the public square. With that, if you have any questions, I'm here to answer your questions.
Thank you, Mr. Fox. And I asked someone earlier not to reference bills that may be under consideration in other committees. I don't know if the hanging in the public square is under consideration in judiciary, but we won't discuss that aspect of your submission. But I do want to say thank you for staying with us today and having this conversation, and for being willing to work with the Attorney General and other legislators over the last number of years on an issue that I know you don't necessarily agree with the overall context, but your desire to make potential bills better has been commendable for a number of years. I think I've disagreed with you on other bills in the past as well, but you've always been forthright and honest and willing to sit down and talk and help identify problems and solutions to an issue, even when we or other legislators in my position maybe didn't see eye to eye. And it's very commendable, and I do admire your willingness and passion on this issue. I do think you highlight a couple issues that the Attorney General was, and his team was kind enough to sit with us and the ranking members early on in the session to go over a series of bills that they had under consideration they wanted to bring to the committee. And some of the language you referenced, having a problem with the ranking member Tigliano, ranking member Chigarella, myself, and Senator Maroney also had some issues with, and they do have a series of amendments they've already introduced to the committee to clarify some of that. So I think you'll feel a little bit relieved that some of that consideration is already underway. It is likely true that we'll be reaching out to you and a couple others impacted by this legislation to kind of work through some of this. I do think at the heart of the issue, the Attorney General is correct that there needs to be an expanded group of people that his office can look at and evaluate and potentially bring in line. But I'm going to want to rely on you a little bit to help narrow that down a little bit. So I'm hoping you'll keep yourself amenable to receiving calls from me as we move forward, and being as willing to work with past chairs. Hopefully you'll do that for me as well. So I appreciate that.
I
You got
will
any
do
questions
that,
for
and I
Mr. Fox?
appreciate your comments.
Of course. Representative Yacarino has a question for you as well.
Just a couple of questions. Thank you, Mr. Chair. Thank you, Mr. Fox, for being here. A long time ago, our family had a garage in North Haven, a gas station. And at 29 years old, I became the dealer representative for all the dealers to meet with Exxon Corp USA. And the headquarters used to be in Long Island. I think they've moved since. But if I remember correctly, Mr. Fox, gas retailers could only mark up the gasoline a certain percent, and had to do mostly in volume. And I forget the percentage. It was a few, like 5 or 6 cents a gallon. I don't know what the markup is today. It's like 30 years ago. But do you know what the potential markups are, Mr. Fox?
I think that that's the area of concern with the AG and that we have as well. We are in a free market society. We are free to charge what we want. If a retailer wanted to go out today and charge $9.99 a gallon, he could. I don't think he'd be able to sell much fuel on the simple fact that the media, the legislature, the Attorney General would focus on that. But current law doesn't prevent that. We certainly don't want to change that. But here's what I can say. Last Sunday, I turned 69. I started in my gas station at 20. That was a long time ago, 1978. There was no minimum markup, but there was this unwritten rule. This was the amount of cents per gallon you can make. We have worked very hard because tax increases, fees on credit cards, and these are things that the legislature can't help us with because that's federal. Federal banking controls credit card companies. I wish you could help because you've always been very helpful. And so when we look at margins today as compared to years ago, here's what I could tell you. The day I opened my gas station, my retail posted price was $67.9. As you heard earlier, there's over 65 cents in taxes now. We all have to share some of the blame why gas sometimes is $2, $3, $4, and dare I ever say it, $5. So as retailers, we have these huge signs on top of our pumps. We accepted that. We agreed with that legislation. We have these huge signs to attract you to come to our station. That is the best form of competition and price control. But as you heard earlier from Ms. Khan, there are so many different, and I was surprised I heard the word in a different industry, zone pricing of fuel. We had that battle, we lost. It's not going to get fixed. I don't think so anyway, but you have dealers who pay, I'll give you an example without taxes, $1.10 a gallon. You have some dealers that pay $1.30 a gallon. Now, if they're next door to each other, that dealer paying $1.30, even if he only marks up a penny, $1.31.9, that retailer paying $1 a gallon is going to post $1.29.9. Which one of us is wrong? I don't think in a free market society, either one of us is wrong. That person did a better job of getting a better buying price and he or she deserves it. And that's the way I look at that. But we've always been willing as retailers to sit down with the legislature. When you enacted the law to suspend the gas tax, we suggested that you mandate we pass that on. And we wanted that because sometimes you need to grab control when you can so you just don't get the egg on your face, so to speak.
I appreciate that answer. And it's a very competitive business. It was competitive then, it's competitive today. And I would argue that most gas retailers are within a few cents of each other, maybe 5 cents of each other. And I think they do a good job overall. I think they get a bad name, a bad rap, but they work hard. They're family businesses. I do have one more question, Mr. Chair, to Mr. Fox. If there's a complaint today, do you respond to the Department of Consumer Protection, not the Attorney General, for just a general complaint? Like if somebody said you're charging $5 when you're only charging you should be charging $4.50.
So that's some of the problem, and unfortunately, you're going to hear me say I'm on the Attorney General side when he was saying we hear about these problems first. So the consumer is directed to either the Department of Consumer Protections or the Attorney General's office. Now, when the Attorney General does a press conference, he makes it easy and sets up an 800 number. And so most of the complaints come into the Department of Consumer Protections and the Attorney General, and they do seem to work very well together. It seems that the Attorney General appears to have an issue. He takes, let's say he has 1,000 complaints and he goes to the governor and says, we need to declare a state of emergency. And this is where I think this committee could really help. I think you need two types of states of emergencies, one for gasoline and one for all other consumer products. Why? We could have a war break out in Iraq, Israel, bomb a refinery somewhere, and it's only going to affect the price of gas. So then in a state of emergency should be limited to the price of gasoline. And we welcome that. That helps us as well as keeps us on our toes. But when you have these, we're talking about eggs, we heard that earlier. Well, now you're really starting to get in the world of politics that the former president had 2 million chickens killed because of bird flu. So obviously the price of eggs is going to go down. And then there's a public debate. Did the former president do that because the media is only reporting about the price of eggs as inflation, not everything else? Your committee is smart enough to know that the price of gasoline and diesel fuel, when it goes up in the $3 and $4 range, affects the price of every single product that is transported into the state of Connecticut. No one is going to pull the wool over the General Law Committee's eyes. And that we all thank you for. But the politics today is getting uglier and uglier. And we have to keep the politics out of this. Innocent, hardworking business owners, as you just said, get hurt. The state has to remember, you take one service station, we may contribute $600 million in combined gas tax, sales tax, gross receipts tax, and income tax to the state of Connecticut. I'm not sure you're going to find too many other businesses. Just one industry gives the state that type of revenue. That's why you can't hurt it. Not because Mike Fox says so, because you don't want to hurt the state.
I agree with you. I think we need to work with you through DCP more than anything else. I have no other questions, but thank you, Mr. Chair. Thank you, Mr. Fox.
Thank you. And thank you, Mr. Fox, again for your time and testimony here today.
Thank you so much. Senator Kissel, good to see you again, sir.
Thank you.
Kevin Curry, to be followed by Matthew Lawazetta.
Good afternoon. Good afternoon. My name is Kevin Curry, and I'm a local business owner from Meriden. I started as a mechanic, graduating from the State Technical College program, which I believe was great, and I think that you guys have done a great job funding that over the years. But my concern today is on this House bill that's before us on price gouging. I do agree with Mr. Fox and Chris Herb from the independent, the fuel marketers, of what's going on. I think the problem we have is all of our costs have gone crazy. You know, tanks in the ground are almost $500,000 for a tank job today. Nobody sees that. Our margins have not increased like that. The problem that we really look into, as we had over the years, we had during the last hurricanes, I know myself and some of my dealers were accused of gouging. After we submitted all of the testimony back to the Attorney General's office, they found out that the problem was not with us. It was actually with the system, because when you lose the refinery down in Mississippi or Louisiana, that triggers everything in the country. The price of gasoline spikes. It's a commodity that's traded on Wall Street. And as the price goes up, the public doesn't see that. But in our business, we show the public right on the street. We have 12-inch digits right out in front. And as one of the gentlemen legislators just said, everybody's within a few pennies. And that's how we price. We price off our competition like a lot of other places. Whatever the competition's doing, we're all doing the same. Our prices change daily. And it's amazing when the products become in short supply, they change a couple times a day. We need to make sure back in the 2008, 2009, when the price hit $5 a gallon, a lot of gas stations went out of business because they did not raise their price enough to cover the next delivery coming in. And it's a very tough business. I've been at it since 1979, as I said. I enjoy it. I love dealing with the people, and we just want to help. We want to make sure we can stay in business and protect our customers as well as the local communities that we serve.
Thank you, Kevin, for your testimony. Are there any questions for Kevin? Seeing none, thank you again for your testimony here today.
Thank you.
Matthew? I saw him. He was in. Matthew, you still there? Madam Clerk, we had Matthew in. We seem to have lost him. Could you flag me if he does rejoin? Thank you. Next up is Victoria Hamilton. Is she in? I'm not seeing Victoria. Edmund Foucault is in the waiting room. Oh, and Victoria is in now. Victoria, to be followed by Edward Foucault. Victoria, can you hear me?
Dear honorable members of the General Law Committee. My name is Ed Foucault. I am the co-owner of All Pets Club, a family-owned business with 4 locations here in Connecticut. We employ between 85 and 95 people, ranging in age from 16 to 68 years old. We've been proudly serving the communities for 36 years. I come before you to express my strongest opposition to the proposed ban bill HB 5112. This proposed ban, while well-intentioned, threatens to have serious consequences for our business, our employees, and our customers. If enacted, it would force us to close stores. In fact, we estimate that over 35% of our employees would lose their jobs immediately, and our locations would no longer be viable. Connecticut has some of the strictest retail pet laws in the country since 2014. The state reinforces rigorous regulations on our pet shops, breeders, and animal welfare. Comprehensive sourcing restrictions, frequent inspections, consumer protection laws, strict animal welfare standards, and an increase in transparency. However, we know based on our experience, this ban would do nothing to address the real issues at hand. The unregulated breeders who would continue to operate and thrive in an environment where the highly regulated sources for pets have been shut down. These bad actors will operate without oversight of any kind and prey on families who do not know any better and do not have access to regulated sources for animals and the expertise that pet stores provide. At All Pets Club, our commitment to animal welfare has always been our top priority and is part of why we have been successful over 36 years. Simply put, if we're not providing happy, healthy puppies, kittens, and rabbits, we would not be in business. Another crucial point, or I'm sorry, that was already repeated right there. I understand and share the concerns over animal welfare. I fully support efforts to curb unethical breeding practices. However, this ban will not solve those issues. Instead, it will drive the industry underground as it has in California since the state banned in 2019, as reported by the LA Times article back in October of 2024. California veterinarians also reported they have seen an increase in consumer purchasing sick dogs from unregulated sources shortly after the ban took place. A ban like this will leave Connecticut consumers with fewer options and responsible, ethical pet sourcing. I urge you to consider the broader impacts of this proposed ban on small businesses like mine and our employees and the responsible pet owners we serve. We are committed to animal welfare and transparency and the well-being of both pets and families who welcome them into their homes. I ask you to work with us to find solutions that truly address the core issues of animal welfare while allowing businesses like ours to continue servicing the community. Thank you for your time and consideration.
Thank you so much for your testimony here today. Are there any questions? Seeing none, thank you again.
Thank you.
Victoria, I've seen you pop in and out. Are you having connection issues, or are you able to join us?
I think I'm able to join now.
Oh, excellent. Thank you, Victoria. The floor is yours.
Okay, thank you. To the honorable members of the Planning and Developing Committee, my name is Victoria Hamilton and I live in Stratford, Connecticut. I am opposing the bill HB 5112. I've had the pleasure for working with Safari Sands Pet Center in New Haven since 2016. Over the years of being in the pet retail industry, I've realized it's more than just people buying a dog, cat, or small animal. We take pride in educating our past, present, and future customers. We are more than just a pet store. Banning our local pet shops only forces consumers to now explore different options that may not include shelters or rescues. This pushes people to search online or backyard breeders, which can cause consumers to be scammed or search in the wrong places. Breeders are advertising online who may not be regulated or subject to inspections, and the people that are not part of the pet world do not understand what it means to be regulated or a backyard breeder. People want to pets and if people want pets and they're going to get pets by all means necessary. Continuing to have heavily regulated pet stores in Connecticut means we know where the pets are coming from. Connecticut requires pet stores to only purchase from USDA licensed breeders. Many times people assume we don't know who these breeders are. Over the years of working with Safari Stands, I've had the privilege to go on many of the breeder trips where we visit the breeders and check out the facilities that we get our kittens, puppies, and rabbits, and their parents before they arrive at the store. I've been to Ohio, Indiana, and Missouri, just to name a few places. During these trips, we spend a few days getting to know the breeders and their families that dedicate their lives to these animals. We also get to meet their vets and ask as many questions as possible. We get to see the large play yards and where the parents get to stretch their legs, use the bathroom, and play and run around. We've seen the facilities that they have and the heated floors, the extra protocols that they take so that we can't bring in extra germs. And we take tons of pictures and videos to show the families the behind the scenes of the breeders that they don't get to see. It's not just the babies that we worry about. It's also about how the parents are taken care of. Just like we go on the breeder trips, the breeders also come to see our store so they can see where their babies are at now as well. The greatest takeaway from being at Safari Stands has to be the joy that people get as soon as they walk in with our big hellos and our smiles. Our regular customers are now family, and the new customers are always amazed at how knowledgeable the staff is and how well taken care of the animals are. The families that have gotten pets from us bring them back to visit or come in to show us pictures and videos to show us how big they are. And then we also love to be part of the community as much as we can. We were part of a ribbon cutting ceremony a few years back with our mayor of the town at a dog park, and we have volunteers from different schools and programs who may have disabilities come in with their supervisor to learn working experience and interacting with customers. We've even partnered with Make-A-Wish Foundation to grant kids their wishes. The local pet stores are more than just Petco and PetSmart. We are dedicated to teaching every single person that walks through those doors something new. Thank you for your time and your attention.
Thank you for your testimony today. We really appreciate it. Any questions for
Yes,
Victoria? Seeing none, thank you again, Victoria.
of course. Anytime.
I have Matthew Labozetta, who I have not seen rejoin. Okay, so moving on, we have Asela Shabazz, also from Safari Stands.
Hello. Can you hear
Hello.
me?
Yes, we can. Please proceed.
Okay, thank you. Thank you for hearing our testimonies today from Safari Stands in opposition to the bill today. I personally started my journey with Safari Stands in particular in 2018, just as a customer, actually. I did receive a couple of my hamsters from there, and since have purchased 3 different small breed puppies from there as well. I've had the wonderful pleasure of going on breeder trips myself as well over my time there, and that has been the most eye-opening and educational part for me, and what I take every day into finding new friends for my customers as they come in. And it's definitely like the most comfort that I can give to someone going forward, seeing the breeders with my own eyes, speaking with them, getting to know their facilities, getting to know why they are so passionate about the breeds that they do work on and work with, and how they are furthering the breed and their commitment to furthering the breed. I definitely have found that Safari Stands has been very educational with the customers that we do have come in. It's kind of like the best setting to get people to know other kinds of animals that they may not have even known existed before coming into the store. And that's definitely the best part that I personally take away from working there every day, is just letting young people especially know about different kinds of animals. And I would just like the opportunity to continue that on. Thank you so much for your time today.
Thank you again for your testimony, and you got to congratulate the owner of your pet shop. He got everyone to come out today. It's incredible. Thank you again. Any questions? Seeing none. Thank you again, Isela. Next up, we have Aaron Bowman.
Good afternoon. My name is Aaron Bowman, and I'm here today to speak against proposed Bill 971. I think we can all agree that human trafficking is a horrific crime, and we must do everything in our power to stop it. However, this bill misplaced accountability, shifting the burden from criminals and law enforcement to that of a business owner. So I have a few key concerns with this. One, it shifts law enforcement duties to business owners. This bill makes hotels, motels, and inn owners financially responsible for a crime they have no control over. Fighting human trafficking is the role of law enforcement, not small businesses, who lack the authority to investigate or even stop these crimes. Two, it imposes unfair financial burden on businesses. This bill punishes businesses with civil penalties instead of going after human traffickers. Many of these businesses are already struggling here in Connecticut with high taxes, inflation, and increased regulation. This only adds more costs. Hotels and motels cannot act as a policing agency without incurring legal risks and operational costs. Three, it ties the hand of law enforcement. Instead of allocating resources to police, investigators, prosecutors, this bill redirects focus to regulatory enforcement on businesses. This approach is a waste of time and resources, allowing traffickers to operate while businesses deal with compliance issues. Four, it ignores the real solution: stronger law enforcement. We need harsher penalties for traffickers, not business owners. Increased funding for law enforcement training and human trafficking task force is the real solution. Collaborative businesses and law enforcement should be voluntary and incentive-based, not forced through penalties. Human trafficking is an evil that must be eradicated, and this bill targets the wrong people. Instead of burdening small business owners with regulations and penalties, we should be empowering our law enforcement to go after the real criminals. I urge the lawmakers to reject this bill and focus on real solutions that will make a real difference and put the responsibility where it belongs, on human traffickers and not the small business owners. Thank you.
Thank you, Mr. Bowman, for your testimony here today. I just want to have a point of clarification. We're not redirecting any funds from any law enforcement agencies to do this, and we're not shifting the burden away. Our local law enforcement, state and federal partners will all continue to have the same exact level of enforcement capacity and authority that they currently do. This would just require the Department of Consumer Protection to oversee hotels, motels, and inns, and that would be the agency that would be able to enact a civil penalty if the hotels, motels, and inns do not adhere to the current existing laws. that are already on the books for them. So I just want to make sure that people don't think that this is a brand new level of relationship or like responsibility that additional hotels and motels have. The way we understood it was this would just make the Department of Consumer Protection the authority by which we would recognize that those hotels, motels, and inns have responsibility, and that would be the agency that would enforce their current existing authority. That's my current understanding of this. And if we need to revisit that during the ongoing conversation of that, I think that will be important. So I do appreciate your testimony. I just want to make sure we end up on the same page if we're not quite there yet. Representative Ritigliano, followed by Representative Turco.
I appreciate it, Mr. Chairman. A few years ago, I was called in for a bunch of hotelers in my area. They had concerns, and really what they were talking to me about is they were concerned about the Tourism Bureau. I know this is I'll get to the point. They were saying that the lack of a tourism director was preventing preventing conventions and hockey tournaments and all sorts of crazy things, and that the algorithm for their hotel and motel prices were dropping so low that they were having a problem with sort of human trafficking or escorts and all this really stuff. I was like, what an odd connection. They were coming to me for tourism dollars, but really it was because they were afraid that their hotel and motel got so inexpensive that people were starting to use it for really nefarious means. So I kept that with me, and I've always advocated for tourism dollars and all sorts of other things. I figured that's got to be good for everybody. I'm just curious, based on how I read this bill, which is a very small bill, exactly what your industry, your particular business would have to do to run afoul of this legislation.
Is that question to me?
It is.
I am not in the motel or hotel business. Actually, I recently just retired from law enforcement, and I did 20 years in the Air Force. So, to me, being in the law enforcement background, it seems that task force, from my experience, have worked much better as far as rounding up individuals who are currently breaking the law. And this is definitely something that is rampant throughout our state with all the easy on and off exit points of some of these hotels. So I just feel that you're asking somebody that is not in a law enforcement position to enforce laws when they could be putting themselves at risk, depending on what type of clientele that is facilitating this human trafficking.
I appreciate that. I guess I'll ask that question of a hoteler if they do come before us on the bill. I should have guessed the law enforcement thing by a couple of the gun safes in the back.
You said not to blur out my background, so.
Sometimes I'm aware, but not totally aware. All right.
Representative Turco.
Thank you, Mr. Chairman. And I too thought that perhaps you worked for the motel or hotel industry, but I think my question can still apply. I represent the town of Newington and all of the Berlin Turnpike part of Newington, and we have a lot of motels and hotels. And I'm very concerned. I've heard from law enforcement throughout the years about the human trafficking, prostitution, drugs, and other crimes that take place on the Turnpike. And there's some particular motels that seem to just be repeat offenders. We have one in particular, I've been told law enforcement was called there 632 times last year for various type of crimes. So since you have experience in law enforcement, I'm wondering, do you believe that there's any circumstances where an owner, manager of one of these motels, hotels, has a responsibility to adhere to certain laws and regulations, like let's say reporting incidences of suspected human trafficking to law enforcement? And if they do not, that would be a violation where there could be a civil penalty. Wouldn't that be an asset to law enforcement to have some responsibility on the actual owners of an establishment where human trafficking might be taking place?
I think we lost Mr. Bowman. That's a.
Can you hear me now?
Oh, we can. Yes, there we are.
Okay. Yeah, that is a I think that's working now. That is a very good point. I do think there needs to be an educational aspect to this for those that either manage or run, especially some of these motels that currently in your area that are, they rent rooms by hours, is what we used to hear as kids and stuff like that. And I think there is a responsibility for those owners to bring awareness or to facilitate law enforcement, say, hey, listen, we've had, this one hotel room and there's all these different Johns coming and going. We need some investigation on this. I don't know if there should be a penalty other than, I don't know what current laws are on the books for somebody who is facilitating in human trafficking. Maybe that's something that could be looked at, that these people are knowingly running these operations and are not saying anything. I think a lot of it has to do with education and what to look for, and be able to have some type of hotline that they can report this, because it is something that is rampant throughout our country.
Thank you for your response.
Thank you for the questions.
Thank you, Mr. Bowman. Next up, we have Connor Norris, followed by Mark Hollis. Connor, are you there?
Yes, I am. Can you hear me?
Yes, we can, Mark. Go ahead.
Great. Chair Lamar, Chair Maroney, and all distinguished members of the General Law Committee, thank you for allowing me to submit testimony on SB 611, establishing a maximum charge for occupational licenses. My name is Connor Norris. I'm the Director of Labor Policy at the NE Regulatory Research Center at West Virginia University. I agree with many of those who testified on the bill earlier today, so I will just make a few quick points for the sake of time. Now, Connecticut licenses more low or medium income occupations than most other states in the country. And people joining these low or medium income professions are hardest hit by the cost of obtaining a license, which includes the licensing application and initial licensing fees. By making it more difficult for aspiring workers to begin working in professions that do not require a traditional four-year college degree, so these low or medium income professions, licensing requirements limit economic opportunity, that first step up on the ladder. Research finds evidence that states with more licenses for these lower or median income professions have lower economic mobility and increased income inequality. So in effect, they make achieving the American dream that much more difficult. The biggest issue with the licensing fees is that they have to be paid before working and earning an income. So it comes at a terrible time for the applicants. Earlier testimonies mentioned the certified public accountants paying around $500 in fees that are directly related to this bill. That sort of understates the issue for them, because when you include the CPA exam fees and some other fees that they have to pay, not just to the licensing board, they end up paying over $1,000 just to begin working. And that's a lot of money for them. Connecticut has 10 other professions that have application and initial licensing fees that combine to over $500. Again, these are considerable costs for aspiring professionals. But with that, I'll stop and say thank you for your time and answer any questions.
Thank you so much, Mr. Norris, for your testimony here today and for providing some national perspective to this as well. I think it's important for us to understand the extent of the challenge we face in Connecticut. We're going to get a large fiscal note on this. This is going to come at a cost to the state, and I think it's important that we understand what that cost is and how it's currently being funded, and where that burden currently lies. And I think you did a great job of indicating where the state is collecting this money from, and that has broad impacts in addition to the budgetary impacts at the state level. The individual pocketbook constraints that's putting on so many people in our state is widespread and significant. So again, thank you for giving us a national perspective as well. Mark Hollis, followed by Bonnie Stewart.
Mr. Chairman, esteemed members of the committee, I'm here in support of House Bill 5162. You are being recorded. There's cameras all over the place, and you know this, and you assented to it. You came in here, you knew full well there were going to be cameras. You came in here and you knew full well that everything that you said would be noted, which is appropriate, okay? But the automakers would provide you that provide you with navigation tools in their cars are also able to monitor where your car goes, track where your car is, and report how you're driving. General Motors, among others, have been selling this information to third parties who in turn sell that to your insurance companies. All of a sudden, your insurance rate goes up and you have no idea why. The issue here is consent. Now, you came in here and you consented to be recorded. Obviously, you're here, okay? With respect to your car, General Motors has some text in an agreement to buy a car that says something about keeping an eye on you with something like OnStar and so on and so forth. And if you're involved in a horrible accident, OnStar will, with no response from you, call 911, which is a real win for you and it could save your life. However, as we found in the case of Marilyn, it also allowed her ex-spouse or ex-husband or abuser to track her. And this is because the dealership sold the car to this person and that's their record. And she owns the car now, but the person they sold the car to can always figure out where that car is and can always track the car. That's something that this bill puts a stop to, and it should. It prevents abusers from following around the person that they are abusing through the use of their car. And the technology is what I'm here to explain. How it works, why it works, and what it's being used for. So if you have a car that has access to the internet, you're being watched.
Hold on. We've got Co-Chairman Maroney and followed by Senator Kissel. Okay, Senator Kissel, you want to go?
Senator Maroney, so kind of you. Previously to the young lady, the woman that was had her abuser stalking her,
Yes.
I think it was Vice Chairman Turco had indicated that the bill was patterned after California, but that it was learned later on by someone informing Rep. Turco that it was watered down. So I would posit to you, because I don't want anybody using my data unbeknownst to me, because I find it offensive based upon civil libertarian kind of ideas, but also they're making dough probably too off of my back, and that's not fair also. What if we weren't going to go down the route of California? Uh, is there another state that we should perhaps look to as a more restrictive, tougher proposal? Because I like the underlying idea, both as it pertains to domestic violence issues, but also in so many other areas. I think that, we need, and it can't be just boilerplate, like you sign this thing that's 18 pages long. That's never going to work. But we need to know what we're getting involved in. And it just amazed me that for the longest time, people said, this is tracking you and you can talk into it and all that stuff. And I thought that was malarkey until I saw it just actually working before my eyes. So how can we get our arms around this?
Well, California is a start, okay? And what Representative Turco is indicating is that it was watered down, which has to do with disclosure, okay? If you go on social media, and we did have a discussion about social media and children earlier, if you go on social media with this, okay, and you say, I'm gonna start an account and I'm going to be, on social media and so on and so forth. Initially, you agree to allow the social media company to track you, and the tracking is limited more or less on the basis of the information the social media company wants out of you. It's as simple as that. However, with General Motors, with Hyundai, with all of the other automakers, with the exception of Ford, they don't tell you. They don't disclose to you what they're doing. They don't disclose to you how much information they're collecting. And they furthermore don't disclose to you that they may sell that information to a third party, which then in turn will uh, uh, sell that information to your insurance company. Okay, so to a certain extent, what you should have is strong language regarding disclosure. I think that that would be a good start.
Well, I was looking for another state that we could use to swipe their
I
ideas
don't
from.
know of one.
Well, if you could,
California
then,
watered
then
down the
I,
disclosure.
it's late. I just know, I know other people and the good chair who's like the master of technology from my perspective, at least from all his work previously. But get us some language, because my druthers is I want this to be as tight as possible, not just for the people that can be victimized through violent people and they want to get away. But this whole thing just bothers the heck out of me, that big corporations are riding roughshod over our rights without us even knowing about it. That's just fundamentally wrong in my book. And so I'd like to at least get something rock solid out of this committee, if at all possible. I don't know how the leadership feels, but I think they're on the right track. So thank you. Thank you, Mr. Chair.
Thank you. Senator Maroney.
Yeah, thank you. And what I hope you'll come back, we are looking at updating our consumer data privacy laws. And just so as part of our consumer data privacy laws, we define geolocation data as sensitive data, which means that it's supposed to be opt-in, that you're supposed to have to give someone your permission to sell that versus opt out for some of the other, your sale of personal data and other issues. The issue we found is in Texas, which has similar data privacy law. Car dealers were claiming the Graham-Leach-Bliley Act exemption because they had financing units, which was meant for not for manufacturers or for car dealers, it was meant for financial companies. So we are looking at closing that loophole so that you would have to give permission. But then the other issue you mentioned about it being buried within a larger agreement, that would be looking at, again, the clear and unambiguous consent without the use of dark patterns. So we'll have to tighten up those loopholes, but we will have a bill coming forward to do that for everyone.
Well, Senator, what I would advise the committee to consider is to allow a judge, and this is due process of law, okay, to allow a judge where if you take out a restraining order because representative over here is stalking you, okay, that she
When she doesn't know me any better to know it would be a waste of time.
I'm picking out bad examples here, but if she were to be stalking you, she should not be able to get any information from a dealership in this case to track where you are at all times. And that should be a big part of the law right there, is to allow judges to cut off access with just simply a restraining order, which is the kind of thing that where judges are quick, legislatures may be slow.
Excellent. So I think we'll have two bills looking at this issue. We have this one specific to this individual issue, but also a much larger data privacy bill that Senator Maroney's been working on for a number of years and making slow modifications to. And I think that will be the bulk of the work would likely be in that bill in this regard. So we'll appreciate any advice that you can provide as we move forward.
Thank you for your consideration.
Thank you. Bonnie Stewart, followed by Chris Davis.
Good afternoon, chairs, ranking members, and members of the General Law Committee. My name is Bonnie Stewart, and I'm the Executive Director and CEO of the Connecticut Society for CPAs. You've heard a lot about Connecticut's fees and how many more we have than other states, as well as how high our fees are. You have a chart going around now that will show you how CPA fees in Connecticut compare to the rest of the country. It's alarming because we also have a shortage of CPAs in the country, but particularly in the Northeast, and Connecticut is definitely one of those states where we have a shortage of CPAs. That's a problem particularly for governmental agencies where they can't find enough governmental auditors to make sure things are going right with boards of education and other things. In addition to that, we have a declining number of CPAs in the country, and while we're hoping to turn that around, it looks like we are going to have for quite a while more people exiting as they retire the profession than enough people coming in to fill all those slots. So one of the issues that we face is not only that high fee, but we as a state are losing the younger people in our state because when they're graduating, we're also between Boston and New York, where their fees are significantly less. And this is especially true for some of our more entrepreneurial-minded individuals who are looking to start their own business. They do look at every penny. And as was stated before, between the licensing fee, the 5 years of education, there's a lot of things that we have to overcome already. On the other side of the equation, our retirees in Connecticut don't maintain their license. And so we're losing them from serving as CPAs on the nonprofit boards that we get calls about practically every week looking for a CPA to serve. But in Connecticut, because of our high price, we find that our members do not maintain their license once they retire just because of the cost of it. So we're 276% higher than the rest of the countries in terms of the national average. The average fee, if you take everyone together with Connecticut, is just below 100 at 99. The most popular or mode is at $100. And then coming in a close second are two fees, and that would be 50 and 150. So we feel what you've set forth in your bill makes a lot of sense, $100. You can see that there's still 29 states that are below that, but it would be a reasonable fee and something that we would appreciate your taking into consideration to help us bring more people into the pipeline as well as keep people in the pipeline at a time when we're having difficulty maintaining the number of CPAs that the state really needs. Happy to answer any questions. I did submit testimony, but you've heard from people all day and I'm sure you're ready to leave. So I want to cut it down for you.
Great. Thank you very much,
I
Bonnie.
just have one other point. I'm sorry. We are not included, I believe, in the governor's bill, but we are in yours. And so I wanted to make that point about the importance of the pipeline. As you know, we are working with you on another bill that will hopefully help us as well. But for us to be in that is really, really important in terms of the final package, just because of the issues we're having with the number of CPAs or the lack of CPAs in Connecticut.
Great. Thank you, Representative Acker.
Thank you, Mr. Chair, and thank you for being here. How many CPAs are in Connecticut now that are registered in Connecticut?
That's a good question. I say that because we get the list from the Department of Consumer Protection on a regular basis, but not all those people are still with us. But I would say that it would be fair to say that there's about 10,000. Now, some of those could be retired but have maintained their license, and others are going to be registered. So they earned their CPA, but they no longer are maintaining an active license. So they could be working for a company versus an accounting firm and therefore don't have to maintain their CPA license.
So if you're the CPA, you can hire people that help do processing that aren't essentially CPAs?
That's actually a very good point. You can hire CPAs, but not have them have an active license, because under the law, the only people that actually have to be CPAs are those that do a test work. So if somebody's doing taxes, they don't need to be a CPA. If they're doing regular accounting work, they don't need to be a CPA. Now, obviously, you've got a benefit if someone is because of all the extra training they have to go through to earn that credential, but they don't have to be. Nor do you have to hire one, a CPA. You could just hire somebody with a regular accounting degree who's got less experience in education, or someone who's even an English degree or history degree, anybody that you can bring in to teach how to do things. We are hiring a lot more IT people than we used to, just because technology plays such a key role in the accounting profession.
Okay, thank you. I had a question till you brought up the IT part. I'll think of it. If I think of it, I'll ask it. Do you have to do continuing education at all?
Yes.
Required?
Yes, 40 hours a year.
40 hours a year at an expense.
Yes.
Thank you. Thank you for your testimony. Thank you, Mr. Chair.
Thank you, Representative Vitigliano.
Hi, Bonnie.
Hi.
Do we license bookkeepers?
No, actually, many of our, I'm going to say former CPAs, even though they earned the credential, but don't want to keep on paying the license fee become bookkeeping businesses, small businesses, and they do not have to pay the fee. Accountants don't have to have the fee, only CPAs.
Okay, thank you.
So I had a question in that same vein. So enrolled agents then would not have to pay a licensing fee if you're an enrolled agent?
It's my understanding that they don't have to pay a licensing fee to the state, but a few years ago, the Department of Revenue Services under then Commissioner Sullivan started up a program to have them register with the state. It's minimal in comparison.
Okay.
Very like cents on the dollar.
Okay. Great. Thank you very much, Bonnie. And we look
welcome.
forward to seeing you when your other bill comes out. So thank you for hanging in there all day.
Thank you.
Next, former Representative Chris Davis.
Good afternoon. Oh, good afternoon, General Law Committee. Thank you very much for having me here today. I'm Christopher Davis. I'm the Vice President of Public Policy with the Connecticut Business and Industry Association. Given the late hour, I'll just jump right to the testimony since you've heard testimony on both of these bills previously, but I'm here testifying in support of Senate Bill 611 that we just heard from Ms. Stewart about, an act establishing the maximum charge for certain occupational licenses. CBIA has been very much in favor of this bill the last several years. You may remember Senate Bill 135 last year passed this committee unanimously and also passed the Senate before dying on the vine at the last few days of session last year. So we're back here again this year to advocate for this bill as well. It could impact over 60 licenses at DCP based on their information that they provided last year. 120,000 individuals could see their costs reduced. And this is very important in order to get more individuals into the workforce with 75,000 jobs that are open right now here in the state of Connecticut. And with the rest of my time too, I'll also comment in our opposition to House Bill 6856, the act concerning the Attorney General's recommendations regarding abnormal economic disruptions. As discussed at length earlier today, it seems like days ago now at this point, but earlier today, and Representative Ritigliano in particular asked a lot of questions that we describe in our testimony as being concerns as well about the powers that would be bestowed upon the Attorney General to impose these penalties and regulatory burdens at will on different prices on different products in the state of Connecticut in response to different market conditions or changes in customer preferences that these businesses may face. And I think it was mentioned earlier as well, especially when it comes to food, that there's federal regulations about having to put on those food products, the size and weight of the food within those products, so that then give the Attorney General the ability to go after businesses here in Connecticut for making those changes in order to meet those market conditions or customer preferences, I think is not the best use of his office at this point. And it would give him the exclusive authority, unchecked, as mentioned earlier, by any other government official to open these investigations and put on those burdens, as well as being able to declare the economic or abnormal economic disruptions beyond what the governor and the president of the United States can currently do. So with that, I'll open myself up to any questions.
Thank you very much. Are there any questions? Representative Lamont,
Just
followed by Representative Acker.
just really quick, and good to see you, Chris. I have two related questions, both of which are exploratory in nature, so don't take the bait if you don't feel like you should. Okay? One is, how are we to know what the best use of the Attorney General's time is when he tells us he's receiving scores of phone calls asking him to investigate a situation? Like, to me, that's where I tend to come back to the Attorney General and say, like, you are receiving a level of input and dialogue from the constituents of this state suggesting that you feel like either the local business retailers, which he thinks isn't the real problem, but more likely the larger manufacturer and distributor level is exploiting Connecticut consumers during a moment of crisis or emergency. Like, to me, that's where I find it hard to question what he determines to be an appropriate tool, because I'm not receiving those calls. And if you in your former life were receiving scores and scores of phone calls about how long the lines at DMV are, you would demand accountability out of an agency to move an agenda. In your current role, if you receive a call from 20 businesses in Connecticut saying, this is a huge problem, I need you guys to focus on this, you would focus on this. And so I think that's where I think my willingness to support where the Attorney General is trying to go is coming from, is because he is receiving those calls. And we kind of are receiving them too. Like, we hear it. We hear the frustrations, we hear the anger, and we kind of know what market forces are determining what rise in prices. And we can kind of walk through our constituents on some of those issues. But also on the national and even occasionally local levels, you'll hear politicians saying, well, it's those other politicians who aren't doing enough to change that. So it kind of feels like that responsibility becomes ours to regulate to a certain extent. And so this is, again, an exploratory conversation with you, having that you occupy an interesting space, you know what our space is, you know what the Attorney General space is, and you still to this day are responsive to constituents to a certain degree and to do something when you see a problem. So how do you navigate? How do you think, given your role, how do you think an appropriate like navigation of regulatory power could be?
So in this particular case, there are already existing price gouging laws that allow this type of investigation if a president or the governor declares an emergency, and then they would be able to investigate that. What troubles me about this particular law is that it actually removes language that exists in that current law that would allow for the fluctuation of price of items sold at retail which occur during the normal course of business, and instead gives the Attorney General the ability to declare abnormal economic disruption essentially at will, because there's really a loosely defined what that is, and then provides them the ability to continue to have that disruption put in place by simply either modifying that order or seeking a continuous 60-day extension to those orders. So this would give one individual, he or she in the future, and you know, I serve with Representative Tong. I know him well. I consider him a friend. I'm not questioning him in this. I'm questioning the office going forward, that they would then have the ability to essentially control an entire market if they so choose to do so, because given the fact that this bill provides no checks or balances on that, the existing law actually allows the legislature to come in and override that decision by the governor to have that type of price gouging abilities. This law removes that, and you wouldn't be able to do that. So the Attorney General would essentially be able to control an entire market for any particular good in which they choose to describe as an abnormal economic disruption.
I think that's fair. And I think it's worth, I mean, I'm not suggesting that you would then be in favor if we gave the legislature an ability to override the Attorney General's unilateral decision-making process in this. Like, I think that's a fair concern. And I think it's probably one shared by members of the legislature on both sides of the aisle. It's like, wait a minute, who are we entrusting what with, and what power is that used for? So I think that's a fair concern. Do you share the same concerns we've heard from others with respect to him being able to move up the food chain, so to speak, from like evaluating individual retailer based problems to like looking at manufacturers, distributors, and determining that there is a colluding impact or a price fixing marketplace there that other attorneys general and surrounding states have? Do you question giving him that authority?
So I would say that I do appreciate that concern that he's limited to just retailers in this particular case when it comes to the existing law. I think if you were to look at it within the framework of the existing law and under the same guidelines of a declaration of national or statewide emergency, and then had the ability to look into those things, I think we'd be open to having those conversations. I think the biggest concern is the ambiguity of the ability to announce this abnormal economic disruption. That really gives a lot of people pause about the ability of businesses to be able to react to that and actually have hesitation in making any kind of changes because they don't know if that's going to trigger some sort of declaration from the Attorney General. Look into this.
Thank you, Chris. I really appreciate it. Representative Ackert.
Thank you, Mr. Chairman. Chris, thanks for being here. I'm going to have you use both hats, actually. The hat you have on now and the one that you used to have as a ranking member of finance. And you did such a fantastic job with that. I go over the list of these licenses that we're looking at making one fee, and they're all over the planet in terms of, you know, lower level prices to, you know, well over $1,000. Was there any substantiating discussion as to why, when you were in that other position, that they would say, oh, yeah, we need this $565 or CPA or real estate fee at 1,000, whatever it is? And, you know, was there any reason why, oh, no, that's why we need that amount? If you could answer that.
From my recollection, very rarely was it tied directly to specific costs related to that particular license. And I'll give you an example. My real estate license, my business background is in real estate. I still maintain my real estate license to this day. It's more than doubled since when I first got the license back in 2011. And that was intentionally done because the state was down on revenue. So back around 2015, I believe it was, they doubled almost nearly all of these DCP regulated license costs. Not because the cost of actually regulating those licenses went up, but simply because the state needed additional revenue. So now to this day, I pay almost $600 for a 2-year real estate license, which would mean that you'd have to sell at least one house a year just to make your money back to have that license, right? And someone like myself who just maintains it to help friends and family when they need it at this point, you know, that's quite a burden and may, you know, require me not to renew it when it comes up for renewal in the future, as Ms. Stewart mentioned previously about CPAs no longer maintaining their licenses, even though they're in such a high demand because of the high costs of carrying those licenses over time. Another example would be my older brother is a retired police detective and does cybersecurity and had to get his private investigator's license just recently. That license alone cost him $1,750. This is someone who's post-certified as a police detective having to get a license to be a private investigator for $1,750. No reason why. He had to pay for all the background checks, all the licensing, all the fingerprinting, everything else added up to even more than that over time without a clear explanation as to where those funds went.
Yeah, thank you. Thank you for the answer. And yes, I remember just going back to actually it was a Republican governor that needed some revenue and imposed instead of yearly, I mean every 2 years license fee, it was a 1 year. So essentially the same fee, except we're going to get it every year. So thank you for your answer. Thank you, Mr. Chair.
Thank you. Seeing no further questions. Good to see you, Chris.
Always a pleasure. Thank you very much.
On a side question, I thought I saw a picture of you recently holding a gigantic lollipop with a. Were you at Disney World?
That was a picture from a Halloween
Okay.
celebration where I was featured as an Oompa Loompa with
Nice.
my daughter as Dorothy. So
Yeah. Feel free to bring that to the Capitol anytime you want.
All right, thank you guys.
Thank you. Next up, we have Kirsten Mendy, followed by Jeff Hood.
Okay, I'm here. Can everybody hear me?
Yes, we can.
Perfect. My name is Kirsten Mende, and I am the co-founder and CEO of Lucky Dog Refuge, a 501c3 animal rescue in Stamford, Connecticut. Thank you very much for the opportunity to testify in strong support of HB 5112. In recent weeks and discussions, comparisons have erroneously been made about pet stores and rescues being competitors. This could not be further from the truth, as pet stores and commercial breeders line their own pockets off the sale of sentient beings, while rescues are nonprofits submerged in debt incurred while trying to save a fraction of the nearly 3 million animals euthanized each year due to overpopulation. Rescues end the cycle of reproduction and mass overpopulation. But puppy mills and pet stores encourage breeding for profit, and they do not educate their buyers on why irresponsible breeding is problematic, including overpopulation, overbreeding, illness, genetic defects, and more. As the Humane Society has said many times, the data does not lie, and our own experience as a rescue does not lie. It is a fact that many pet stores are knowingly selling dogs that come from puppy mills. We at Lucky Dog Refuge have a very recent firsthand example from a pet store here in Stamford when a dog was surrendered to us. Documentation irrefutably proved that the puppy came from a breeder with a horrific history of violations, and the store refused to comment, despite its claims to only work with ethical breeders who follow USDA standards. The store did not take the puppy back when the purchaser asked to return it, and so the owner was going to sell it on the street before we stepped in. This is just one of many examples of what has become known as the puppy mill to pet store pipeline and how rescues are left to repair that damage. Over the last 5 years, our rescue has saved and homed nearly 1,000 dogs. I have seen firsthand the devastation of puppy mills, and I've seen the negative impact of pet stores. A large portion of the local owner surrenders that we have received over the last 5 years are dogs that have come from pet stores. And there's a good reason for this. According to the ASPCA, ethical breeders commit to making a good match between the owner and the animal, and they only sell directly to prospective owners. Ethical breeders do not sell via pet stores because then the fate and the future of the animal becomes unknown to them. The ugly truth is that with pet stores providing the demand, puppy mills will continue to provide the supply, and both parties will continue to profit off of animal cruelty. We are not against animal cruelty. We are against animal cruelty. We are not against commerce. Pet stores can absolutely make money without selling animals by focusing on a wide range of other pet-related products and services like food, toys, accessories, grooming, training classes, pet healthcare consultations, and more. According to the Zion Market Research, the global pet care market size is predicted to grow to around $363 billion by 2030. The leading drivers for this number are products, veterinary care, and services, not the sale of animals. This proves that pet stores can be profitable without selling dogs, cats, or rabbits.
Would
I
you
am very much in
summarize?
opposition to
Your
all
3 minutes
businesses.
are up.
I'm in opposition to all businesses that profit off of mass breeding and cruelty of sentient beings, and pet stores are very much among those groups. Thank you very much for your time and the opportunity to testify.
Thank you for your testimony. Are there any questions? Okay, hearing none. Thank you for hanging in there with us all day and for your testimony.
Thank you.
Next, Jeff Hood.
Greetings. Can you hear me?
Yes, we can. Please proceed, Mr. Hood.
Thank you so much.
Fatherhood.
I can't believe I finally made it. It's been a long day. My name is Reverend Dr. Jeff Hood. I'm coming to you from Little Rock, Arkansas. I serve as a spiritual advisor to men on death row. I am about, I guess, a week removed from my 9th execution in the last 2 years. Stephen Nelson in Texas, and perhaps as much as anyone in the country, I'm able to speak to the horrors that executions wrought. One particularly difficult moment for me and a number of others was the execution of Kenny Smith back in January of 2024. During that execution, the state of Alabama proceeded to test a nitrogen hypoxia execution. Earlier, Scott Langley showed a picture of what that mask that was used in that execution looked like. I was brought into the execution chamber to pray with Kenny Smith. I was mere feet away from him when the nitrogen started to flow. Kenny began to heave back and forth over and over again for over 8 minutes. As he heaved, saliva and mucus and bodily fluid caught on the front of that mask. It began to rain down like a waterfall on the inside of the mask. Every time he would thrust forward, his face would hit the front of the mask like somebody who was hitting a window might look. That mask was manufactured by Allegro Technologies, which is a wholly owned subsidiary of Walter Surface Technologies, a Windsor, Connecticut company. I, of course, am here to testify in favor of SB 430, prohibiting certain conduct concerning drugs and medical devices used to execute. I think that in this hour, you and your colleagues are tasked with a very difficult thing, and I've listened throughout most of the day, and I can understand how it's complicated with commerce and regulating something like this. Senator Kissel, I definitely heard your concerns as well, but I want to say that it's not lost on me that if Alabama had had trouble getting that mask, I wouldn't have had to have seen what I saw. I wouldn't have had to experience what I experienced. So I, again, wholeheartedly ask you to think very deeply about Senate Bill 430 and what the sale, manufacture, and distribution of these pieces of equipment cause. Thank you.
Thank you for your testimony. Are there any questions, Senator Kissel?
Thank you very much, Chairman Maroney. I appreciate the fact that you've been with us all day and you listened to the testimony. And indeed, that corporation, while I'm not familiar with it, Windsor is part of my district. But my concern is, like, first of all, if this all happened recently, I'm guessing that these aren't all under the federal system. That's part A. And B, if this legislature decided for whatever reason to march forward with this proposal, what in the world would stop a company from just setting up shop in Montgomery, Alabama, or Little Rock, Arkansas, or any state that has a death penalty and just manufacturing what they need there? Because whatever's being manufactured in Connecticut is being utilized in a state that thoroughly authorizes this. So it's a two-part question, sir.
Yeah, thank you, Senator. I think that in a lot of times the folks here in Arkansas who are interested in progress look to places like Connecticut as beacons of light to sort of guide the way to sometimes a little bit better of a moral situation. And so, I think you're right in that, I'm sure that there would be all sorts of ways to circumvent such a law. But at the same time, if there's an ability to make it a little bit more difficult, a little bit harder, then I think that that is a path worth taking. And I think it's important that the state of Connecticut lead the way morally for the rest of the country. And right now, we're seeing it was an Alabama execution, and we are seeing an unprecedented level of executions. And we're starting to see new new states take up executions. And it is my prayer and my hope that they can't that y'all will make it to where they can't look to Connecticut to get the goods that they need to carry out these executions.
I appreciate that. The other part of my question is these aren't all under federal aegis, that these are state authorized executions.
Yes, sir. Yes, sir. And
thank you. Point proven. Because I tried
yeah.
to make that point hours and hours ago, and it's taken me all day to get to that answer. Thank you, sir. Thank you, Matt, Mr. Chair.
Thank you. Are there any further questions? Hearing none, Reverend Hood, thank you very much for your testimony. Next, there was someone who had technical difficulties who was able to get back online. So Matthew Labazetta.
Hello.
Hello, please proceed.
Hi. I'm just a regular citizen, member of the community, that opposes Bill 6 or 115, I believe it is, 511. I don't feel that banning the sale of animals in pet stores is a solution to the issues that people are trying to bring forward. I believe that it's only going to drive things underground, as mentioned before, and I believe that it's going to interfere with already highly regulated industry that looks out for the consumer and for the animals. I've heard a lot of different testimony today. I just feel that that for me as a consumer who has frequented pet stores, who has owned a pet store, I also have a child with special needs. I don't feel comfortable adopting a pet. I don't feel comfortable rescuing a pet, rather. I like to talk to people that are in the know, that are experts in the field, and I can interact with, various dogs that haven't been through abuse situations. And, I do admire people that rescue dogs. However, it's not for everybody. And I just wanted to, chime in a little bit and just give my perspective. I'm not at all related to the pet industry or to any organization involved in this. I just felt the need to comment on it and, kind of present my point of view. Thank you.
Great. Thank you very much, not only for hanging in there all day, but then overcoming the technical difficulties to take your time to testify to us. Yeah.
You're welcome.
Another dad joke. Next, Randy Fazikis. Okay. Next, Jill Fleming. Okay. Tiara Scretchen.
Yes. Hi, can you hear me?
Yes, we can. Please proceed.
Thank you. Today I come in strong opposition of the proposed bill HB 5112 on the prohibition of the sale of dogs, cats, rabbits, in pet shops. While I understand the concerns regarding animal welfare, I believe that a ban is not the appropriate solution. Instead of shutting down responsible, regulated businesses, we should focus on enforcing existing laws and strengthening regulations to ensure the humane treatment of animals. I've personally worked at a pet store, safari stands, for almost 2 years in 2021, and my experience was absolutely amazing. Not only did we personally care for our animals as if they were our own, but we also helped many families find their forever fur babies. And there are many rules and regulations that must be followed when it comes to getting a dog, even going as far as personally visiting the breeders to make sure animals were being treated fairly. We had repeat customers and visitors say how much we've changed their lives. And we wouldn't just sell an animal to anyone. The process would take multiple hours to make sure that they're a good fit. And pet stores provide an important service to our communities by offering families a safe, reputable source for pets, as well as supplies and veterinary guidance. There are pet stores who work with licensed breeders and adhere to strict standards to ensure the health and the well-being of the animals they sell. And a ban would unfairly punish responsible businesses while failing to address the root issue, irresponsible breeders and unregulated sellers. We should be going to the root of the problem and eliminating puppy mills instead of the places who actually care about the animal's well-being. And eliminating these pet stores could also drive consumers to purchase animals from more unregulated online sources or backyard breeders where conditions may be far worse and oversight is minimal. And this could increase and complicate the very problems that the ban seeks to resolve. And rather than banning pet stores altogether, I urge us to focus on implementing stronger licensing requirements, increasing oversight, and harsher penalties for animal mistreatment. We should allow people the right to choose how they would like to acquire a family pet because not everyone's able to adopt, and some people have specific preferences, and some breeds may be harder to find in shelters. The amount of difficulty shelters may create adopting a pet, we hear a lot from our consumers and our customers, and that's why they choose to buy at a pet store. So we should really give people a choice instead of forcing them to do something that may deny them. And I ask to reconsider this ban and explore alternative solutions that may better balance animal protection with consumer choice and business sustainability. Thank you very much.
Thank you very much for your testimony and for hanging in there all day. Are there any questions from the committee? Okay, hearing none. Thank you again, Ms. Gretchen.
You're welcome. Thank you.
I believe that brings us to the end of the hearing. Is there anyone in here who would like to testify? Hearing no one,
I would I would ask my co-chair if he has any final remarks.
We have pitchers and catchers report on Wednesday. Our next committee meeting will be on Friday for purposes of public hearing. And pay attention to your calendars. We'll see you all soon.
We have public hearing Friday at 10 a.m. And are there, do the rankings have any comments? Okay, 10 a.m. Friday for a public hearing. And the agenda will be out. The agenda's out. Okay, with that, we are adjourned. Thank you, everyone.